ಮೇಡಮ್ ಇಲ್ಲಿ ಯಾರಾದ್ರೂ ಇಂಟರ್ನ್ ಬರ್ತಾರಾ? Whenever there is a call to them. Direction. Got one more list. Xerox.
ಸ್ವಿಚ್ ಗೆ ಕನೆಕ್ಟ್ ಮಾಡಿದಾರ, ಎಲ್ಲಿಗೆ ಕನೆಕ್ಟ್ ಮಾಡಿದಾರ? ಲೈವ್ ಮಾಡಿದ್ದು ಇದು ಲೈವ್ ಇದೆ ಅಲ್ಲ?
Sir, memos.
ಬರ್ತಿದ್ದೆ
ತಗೊಂಡವ್ರು ಇಷ್ಟ ಬಂದಂಗೆ ಇಟ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ತಾರೆ ಎಲ್ಲ. ನಂಗೆ ಹೆಂಗ್ ಬೇಕೋ ಹಂಗ ಇಟ್ಕೊಂಡಿರ್ತೀನಿ. ಕಸ ಮರ್ತೋಗುತ್ತೆ. ABM ನೆನ್ನೆ ಆ ಹುಡ್ಗ ಬಂದಿದ್ದು ಎ ಅನ್ನೋದು ಕೆ ತರ ಕೇಳಿಸಿತ್ತು.
सर नमस्ते. Good up, sir.
For listing,
11/6.
ಏನಕ್ಕೆ 11/6?
Send the file for mediation. Another connected matter also on 11/6. And it is
Mediation
only for the sending case for mediation, not for the hearing.
at 11/6, 2:30. Yes,
Adjournments. List number 1, page number 10, serial number 46. 46 and 47. Page number 11, serial number 48. Page number 12, serial number 49 to 52.
48.
49, please.
yes,
49.
48 ಯಾರು, who is mentioning?
Now, Sharma, in my matter,
Yes.
it is connected now. The steps are to be taken on the very same judgment is, or judgments are challenged, orders are challenged. If they take notice, it could be avoided. That's all my request.
We'll do that when the file is before us, Mr. Sharma.
Very
not
well,
now it's
very well.
mentioned.
I will wait.
Yes.
I will wait.
49 ಯಾರು mention ಮಾಡಿದ್ದು?
No, not so much. 14. I'm appealing for petitioner, please.
Yes,
Really have small accommodation, please, my lord. I have to file amendment application ಅದಕ್ಕೋಸ್ಕರ. Amendment
49
application.
at the request of counsel for the petitioner, relist on 14th June. If arguments are not advanced on that date, the petition will be liable to be dismissed for non-prosecution. 2014 matter, please don't, we won't give you any other
Please, please.
adjournment.
Please.
Page number 13, serial number 53 to 58.
Serial number 58 to you, my lord.
Yes.
Adರಲ್ಲಿ the counsel for respondent number 3A and B is under medical care. So I will price 2 weeks time.
Petitioner inform ಮಾಡಿದ್ದೀರಾ?
I will intimate
You are the
petitioner.
58. It submitted that the counsel for respondent number 3A and B is unwell. Relist on 5th July.
ಆಗ್ಬೋದು.
5th July. Hmm. Have you informed the respondent? Will, but have you informed or no? Yes or no? If you are not informed, please wait.
Page number 14, serial number 59 to 64.
Hearing for petitioner, 60, serial number 60, my lord.
Serial number?
60,
Mic ಇದೆ ಜೋರಾಗಿ ಮಾತಾಡಿ ಇಲ್ಲ. Breakfast
serial number 60, my lord.
breakfast ಮಾಡಿದಿರೋ ಇಲ್ವೋ?
ಇದು NOC
ತಿಂಡಿ ತಿಂದಿದಿರೋ ಇಲ್ವೋ? ತಿಂದಿದ್ದೀರ? ಮತ್ತೆ ಜೋರಾಗಿ ಮಾತಾಡಿ.
serial number 60, petitioner ಗೆ ನಾವು NOC 60,
ಹಾ.
petitioner ಗೆ NOC ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ, my lord.
ಹಾ.
So ನಮ್ಮ ಹೆಸರು ಮೆನ್ಷನ್ ಮಾಡೋದು ಬೇಡ.
ನಿಮ್ ಹೆಸರು ಮೆನ್ಷನ್ ಮಾಡಕ್ ನೀವು ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋ ಹಾಕ್ಬೇಕಪ್ಪ. ನೀವು ಅಲ್ಲಿ
Next week.
ಪ್ರಯೋಜನ ಇಲ್ಲ.
Next week.
ರೆಸ್ಪಾಂಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದೀವಿ.
ಇಲ್ಲ. When it is called.
Page number 15, serial number 65 to 70.
Hmm. You informed. 70 at the request of counsel for the petitioner, relist on 21/6.
My lord, serial number 66. Serial number 66, my lord. Press time for 2 weeks, my lord.
66.
ಹಾ.
ಯಾರಿಗೆ ನೀವು
Petitioner, my lord.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ?
I prefer for the respondents 4 and 4.
Respondent number 4 and 5. CB Prakash is no longer appearing.
No, with any NOC that R. Shivchandra Nayak I represent.
Shri R 66, Shri R Shivchandra Nayak has entered appearance for respondent number 4 and 5.
4 and
Registry direct delete the name of Shri CB Prakash as that appearing for respondent number 4 and 5. Counsel for the petition seeks for a week's time to get ready and address his arguments. Relist on 14/6.
Serial number 51, my lord. I appear for the petitioner.
1.
Petitioner.
Hmm.
Weeks time, madam. Weeks time, madam.
Respondent inform ಮಾಡಿದಿರಾ?
Inform ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಮಾಡಿದಿರಾ?
ಹ್ಞೂ ಸರ್. ಆಮೇಲೆ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಎಕ್ಸ್ಟೆಂಡ್.
At the request of non-filing of amended cost title.
ಅಲ್ಲ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ, ಅದು ಮಾಡ್ತೀವಿ.
And counsel for the petitioner seeks for and is granted a week's time to get ready and address his arguments. Relist on 14/6.
ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಮೇ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
By then, the amended cost title is not filed. The petition will be liable to be dismissed for non-prosecution.
ನೋ ಮೇಡಮ್.
In file ಮಾಡಿ.
ಫೈಲ್
ಒಂದ್
ಮಾಡ್ತೀವಿ.
ವಾರ
ಆಯ್ತು.
2015 matter.
interim order may be extended.
Interim, ಅದು ಮಾತ್ರ ಬೇಕು. Interim order earlier granted is extended till next date.
Page number 16, serial number 71 to 77.
75, my lord, I'll inform the rest.
Um,
informed, I will.
One submission, Your Honor. In the respond number three, respond number three is no more, so I'm reporting death of respond number three, man,
You're filing a memo.
please.
I will take steps.
Counsel for respond number 3 has filed a memo intimating the death of respond number 3. Legal heirs ಯಾರು?
Rigorous, either respond, I'll,
Details ಇಲ್ಲಿ.
details I'll
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
one week, I will record.
Learned counsel for respondent number 3 undertakes to furnish the details of legal representative of deceased respondent number 3 within, by end of day 13th June.
Wow.
Learned counsel for the petitioner seeks for 2 weeks' time thereafter to file necessary application to bring the legal representatives on record. Relist on 5th July.
Earlier, I voluntarily appeared before this, filed an occult, my petition copy is not served to me, can you direct?
ನೀವು legal representative appear ಆಗಂಗಿದ್ರೆ
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಕೊಡಿ, ಕೊಟ್ಟೆ ಕೊಡ್ತೀವಿ. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ, ಪೆಟಿಷನ್ ಕೊಡಿ,
Please,
ಆರ್ಗ್ಯುಮೆಂಟು ಮಾಡ್ಬೇಡ ನಾವು.
ಆಯ್ತು.
serial-
73,
ಹಾ,
petitioner,
yes,
already intimated to others.
ಮಾಡಿದೀರಾ? 73 at the request of counsel for the
2 weeks.
petitioner released on 21/6.
My lord, serial number 77, kindly 2 weeks time, my lord, respondent. I am petitioner,
Respondent inform ಮಾಡಿದೀರಾ?
inform ಮಾಡಿದ್ರು.
77 at the request of counsel for the petitioner released on 21/6.
Much of lord.
Page number 17, serial number 78 to 82. List number 1, order serial number 1.
Seven in this case. Number 7, my lord.
Here for the petitioner, my lords, week's time may be granted, my lords, I'll.
Last order date, I could not complain.
5, 6 and 11 are dead.
I'll,
You have not taken steps despite order,
my lords, will comply with it.
and process fee also has not been paid. You will do this, not your senior, you will do this. When will you do it?
My lords, a week's time may be granted.
The applications will be drafted by you.
Please,
Counsel for the petitioner seeks for and is granted a week's time to file necessary application to bring the legal heirs of deceased respondent number 5, 6 and 11 on record, as also to make payment of necessary process fee and furnishing copies to the unserved respondents. Relist on 21/6/24. If
interim
the
order,
above is not done by then, the petition will be liable to be dismissed for non-prosecution.
please, interim order.
What is
may
your
kindly
name?
be- Ramula, my lords.
And so and so submit that she'll file.
My lords, interim order may kindly
Interim
be.
order earlier granted is extended till next date.
Much of.
Serial number 2,
For petitioners in this case, my lord.
Yes, madam.
My lord, in this case, my lord,
respondent.
Respond-
Respondent number 5.
respondent number 6 is the second, first purchaser. And respondent number 5 is the second purchaser, my lord. Now, my lord, respondent number 6 has not appeared before the DC. I have taken steps, my lord. He is purposely avoiding the.
You have not taken steps, you have not paid the process fee.
I have paid, my lord. I paid the process.
Address he moved.
Address he moved, ಹೊಸ address ಬೇಕು.
ಅದು ಬಂದಿದೆ. My lord, now, my lord, the respondent number 5, my lord, his LRs are brought on record and they are present before this court, my lord.
Hmm.
And this petitioner has given some amount to them, my lord, and they want to withdraw the application, my lord. It is settled out of court, my lord.
Settle out.
Settled. Parties,
ಅದು
all the
first
parties
ಹೇಳ್ಬೇಕು.
are here only, my lord.
ಅದು ಫಸ್ಟ್ ಹೇಳ್ಬೇಕು.
Sorry.
ನೀವ್ ಯಾರಿಗೆ?
I am for petitioner,
ಅಲ್ಲ, you are the owner or the purchaser?
subsequent purchaser.
You are the subsequent purchaser.
Yes, my lord.
And 5A to C ಯಾರು?
She is original grantee,
5A to C original grant.
original grantee.
6A to C ಯಾರು? 6A to E,
Oh, first purchaser.
first purchaser. You
Yes, sir.
purchased from 6.
Yes, my lord.
ಕೊಡಿ.
Memorandum of settlement.
IA 1 and 2 ಏನಿದೆ?
Sir, 1 to bring the LRs of R6, IA 2 of 23 to bring the LRs of R5.
R5 ಇನ್ನ ಆಗಿಲ್ವಾ? ಬಂದಿದ್ದಾರೆ. ಇದು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Pending. Application.
IA 2 of
2 of
23.
23.
My lord, I may be permitted to file the amended petition, my lord. Amended writ petition.
ಒಂದು ನಿಮಿಷ. During the pendency of the above matter, respondent number 5 expired on 5/8/2010.
5/8/2020.
Hence IA 2 of 23 has been filed on 23/8/2023 to bring the legal representative of deceased respond number 5 on record. They said application being within time, 5 expired on 5/8/2010.
2010, my lord. Before filing up the writ petition, therefore I filed application, my lord, and LRs are brought on record.
Writ petition ಜೊತೆ ಎಲ್ಲಾರ್ ಫೈಲ್ ಮಾಡಿದ್ರ ಆಮೇಲೆ
ಆಮೇಲೆ ಎಲ್ಲಾರ್ application file ಮಾಡಿದೀವಿ, ಹೌದು. We are not aware of the death, my lord.
Learned counsel for the petition submits that the petitioner was not aware of the expiry of respond number 5. Though the petition was filed against a dead person, the application under IA 2 of 23 has been filed to bring the legal heirs on record. Notice having been ordered, respond number 5A to C have appeared through a counsel. And madam, no objection to allow. She submits that she has no objection for the said application to be allowed, though it has been filed though the writ petition was filed against dead person. She further submits that there is settlement which has been arrived at between the parties. In that view of the matter, in the interest of justice, IA 2 of 23 is allowed. The person named therein are brought on record as respond number 5A to C. During the pendency of the above matter, respond number 6 had also expired. Hence, IA 1 of 23 had been filed. Respond number 6 is the first purchaser from the petitioner. And the first purchaser has thereafter sold it to respond number 5.
Yes, my lord.
Respond number 6, it is submitted as no subsisting right, title, and interest in the property subject matter of the writ petition. Hence, the IA 1 of 2023 is in IA 1 of 23, you'll
To bring the LRs.
one notice hogilla, so you want to
I will, yes, my lord.
withdraw that
Withdraw,
application.
yes.
Hence, they said IA 1 of 23 is dismissed as withdrawn on the basis of the memo filed by the
I-
petitioner. For the compromise. The petitioner is before this court with the final order. He is before this court seeking for the following order, following reliefs. A memorandum of settlement has been filed by both the parties, which reads as under. The petitioners Dakshayani by new petitioner. In settlement ಏನಾಗಿದೆ? ಎಲ್ಲ ಆಗಿದೆ ಅಂದ್ರೆ ಏನಾಗಿದೆ?
ಏನ್ settlement ಆಗಿದೆ?
ಟರ್ಮ್ ಏನು?
ನೀವೇನ್-
ಅವ್ರೇನ್ ಕೊಡ್ಬೇಕು, ನೀವೇನ್ ಕೊಡ್ಬೇಕು?
ಅದ್ ಹೇಳಿ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ.
ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಇವ್ರು ಪೆಟಿಷನ್ ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ. Petitioner is a grantee.
ಅಲ್ಲ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 5 is the grant.
ಆಗ್ಲೇ ಉಲ್ಟಾ ಹೇಳಿದ್ರಿ ನೀವು.
5 is the granting.
5 is the grantee.
Yes.
ಅದು ಉಲ್ಟಾ. Respond number 5 is the grantee. Respond number 6 is the first purchaser who has sold it to the petitioner. ಎಷ್ಟು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಾ? They not mentioned it at all. ಬರ್ದಿಲ್ವಲ್ಲ ನೀವು?
I will mention it. my lord.
ಬರ್ದ್ರೆ ಅವ್ರು ಕೇಳಬಹುದು ಎಷ್ಟು ರಿಸೀವ್ ಆಗಿದೆ ಅಂತ.
ಇವ್ರನ್ನ ಕೇಳ್ಬೋದು, ಇವ್ರು ತಗೊಂಡಿರೋರು.
ಸೊ ಇಲ್ಲಿ ಬರಿಬೇಕಲ್ಲ.
5. I will write it. my lord.
You are the petitioner, it's in your interest to write it.
Yes.
Pass over. ನೋಡ್ಬಿಟ್ಟು ಸರಿಯಾಗಿ ಬರೀರಿ.
Serial number 3. Chetan B.
Kindly pass it on. I'll comply. During the course of it.
Petitioner, ಏನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನು?
Set aside abatement application to be filed and wakalat to be filed.
Kindly pass it over.
Application file ಮಾಡ್ತಾ ಇದ್ದೀರಾ
Please,
ಇವತ್ತು?
please.
Pass over.
Serial number 4. H.C. Shivramu.
My humble request, my lordship,
Yes.
2 weeks' time may be granted, my lordship, to bring the LRs on record, my lordship.
Wakalat filed by H. Manjunath.
I'm appearing for
R5.
R7, my lord.
R6B is not on record.
R6B is not on record. Mr. Manjunath. None appears for the respondent. Counsel for the petitioner seeks for and is granted 2 weeks' time to take necessary steps to bring the legal representative of deceased respondent number 2 and 4 on record. Relist on 21/6.
Humble request, my lordship.
Serial number 5. Girisha Kodgi.
I appear for the petitioner in this matter.
Yes, Mr. Kodgi.
Respondent number 6, respondent number 6 expiry ಆಗಿದ್ದಾರೆ ಅಂತ ಸುದ್ದಿ ಬಂತು. ಅದಕ್ಕೆ I will take the details and file necessary application.
Counsel for the petitioner submit.
ಯಾವಾಗ ಡೇಟ್ ಏನು ಗೊತ್ತಾಗಿಲ್ಲ ಇನ್ನು.
Respondent number 6 is expired. He seeks for and is granted
Yes.
3 weeks' time to file necessary application to bring the legal representative of deceased respondent number 6 on record. Relist on 28/6.
Serial number 6.
Lords, a week's time may be granted, my lords. There are office objections.
Court fees.
Court fee.
I'll pay. There are other office objections.
Why you want a week's time to file?
Lords,
pay 100
type
rupees?
copy needs to be filed. I'll have it filed in a week.
Ondena, inna just
Other 6 office objections.
6.
Within a
Counsel
week.
for the petitioner seeks for and is granted 2 weeks' time finally to comply with the office objection. Relist on 21/6. If by then compliance is not made, dismissal for non-compliance.
Serial number 7. Nagaraj VM. 5 office objections. 8th time.
None appears for the petitioner. 2 weeks' time is granted finally to comply.
The
with
time,
all
my lord,
provisions.
5 times time has been granted for.
5 times,
8th times.
8 times ಕೊಟ್ಟಿದೆ.
ಹೌದು.
ಮತ್ತೆ ಬರ್ದಿಲ್ಲಲ್ಲ. None appears for the petitioner. Office objections have not been complied with despite 8 opportunities have been granted to the petitioner. It appears that the petitioner is not interested in prosecuting the matter. Petitioner is dismissed for non-prosecution. First, the petitioner is before this court seeking for the following reliefs and admit that.
Serial number 8.
Advocate for R6.
It should be have been R5.
R5
R5
is a caveator.
They were the caveator.
Caveator wants to retire.
Please. K. Mahadevamma shows the applicant.
Learned counsel for caveator respondent number 5 is filed dated 22/4/2024 seeking permission to retire from the matter. Along with the memo of retirement, the NOC Wakalatnama bearing the acknowledgement of receipt of the papers and NOC dated 4/4/24 has been enclosed. In that view of the matter, the memo of retirement is accepted. Shri Sarvana S is permitted to retire from the matter. Print the name of respondent number 5. Relist on registry direct, print the name of respondent number 5. Relist on 21/6. If none were to appear for respondent number 5 on that date, the matter would be taken up for consideration.
Would it be
based
on
the
first
submission
week of July?
made by the other councils.
First week of July. 5th, please.
July.
Great.
Serial number 9. Ravishankar, yes.
1 week time may be.
Yes, sir, agide.
3rd time. 3 office objections.
1 week's time is finally granted.
Please.
To the counsel for the petition to comply with office objection. If not complied by 13, by 14, the petition would be liable to dismiss for non-prosecution, relist on 21st.
Please.
Serial number 10, J.M. Rajana Shetty.
Respondent 4.
R5 and R6.
R5 and R6 are my vendors. Then they are formal parties.
ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತಿದೆ? Notice
Idರಲ್ಲಿ what happened, your lordship can see after lapse of 51 years from the date of first sale.
It's ready.
ಅದು not
Now-
claimed ಅಂತಿದೆ sir, 5 and 6.
Now it is for a payment of process fee for R5, 6, 8 and 9.
I'll
You
pay.
want dispensation, you file a memo, we'll dispense at your.
Dispensation, because 8 and 9 are my vendors,
But memo.
petitioner's vendors.
ಕೊಡಿ.
Paper.
It's your risk.
Please.
ನಾವು ಈಗ ಬೇಕು ಬೇಡ ಅಂತ ಏನ್ ಹೇಳಲ್ಲ.
The
ನೀವು
fourth
ಬೇಡ-
respondent is only the person who is claiming.
That we'll see at the time of argument.
ಈಗ ಏನಾಗಿದೆ
ಅವತ್ತು ಬೇಕು ಅಂದ್ರೆ ಕಷ್ಟ ಆಗತ್ತೆ ನಿಮ್ಗೆ. ಇವತ್ತು ನೀವು ಫೈಲ್ ಮಾಡಿ at your risk we will dismiss it.
ಇಲ್ಲ
Take process.
process ತಗೊಳ್ತಾರಂತೆ.
I'll pay the process.
Pay the process. Counsel for the petitioner seeks fund is granted a week's time to make payment of necessary process fee and furnish copies in respect of unserved respondent number 5, 6, 8 and 9. If needful is done, registry is directed to issue notice to respond to the said respondent returnable by 12th July.
In the meantime, your lordship may kindly say that the stay is granted by this court on 20/12/2023 against the orders of deputy commissioner. Because after lapse of 51 years from the first day sale, they have filed a petition. Then your lordship is now in the state, those stays granted. Now they came near the property and demolished these, the entire fencing put up by these petitioner. Because of that reason, I filed an applications, 2 applications. One is for restraining him from entering into the property, and in another one is seeking directions to the police protection.
Contempt ಯಾಕೆ ಹಾಕಿಲ್ಲ?
Contempt, stay ಇದೆ ಅಂತ.
ಇದ್ದಾಗ ಅವ್ರು ಮಾಡಿದ್ರೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬೇಕು ನೀವು.
Lordship,
Why are you interfering with the position?
They served yesterday copy and yesterday evening. The press week time to file an objection to this main.
In the
petition.
meantime, let him undertake not to interfere with the possession of the
You
property.
can't. Once it is execution is state.
One more connected matter is there, Your Lordship.
Connected matter ಆಗ್ತೀವಿ, but how do you interfere? Tell your clients not to do that.
They served yesterday evening in the copy. The press tried to file an objection to main
If the
petition.
contempt petition is filed, we'll take immediate cognizance. Once an order is passed by the court, you can't try and interfere. Order ಇಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ, order ಇದೆ.
Yes.
Advise your client not to do it, and they'll be taking too much of a risk. This court by order dated 20/12/23 has already stated the impugned order dated 16/4/2023 at Annexure G. Submission of learned counsel, senior counsel for the petitioner is that despite the said order, the respondent number
Respondent number 4.
4 is seeking to interfere with the position of the petitioner. Once the order dated 16/9/23 has been stayed, the question of any interference by respondent number 4 would not arise. Respondent number 4 is therefore restrained from interfering with the position of the petitioner till the next date of hearing.
Much.
Serial number 11,
Connect the above matter with WP number.
WP number, Your Lordship. WP number 28357 of 23.
357 of 23.
Yes, Your Lordship.
ಅದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ?
Complete ag.
ಇದು 5, 6, 8 and 9 ಅದ್ರಲ್ಲಿ ಸರ್ವ್ ಆಗಿದಾರಾ?
I'm not aware. I'll verify.
5, 6 are the petitioners there.
ಅದರಲ್ಲಿ
Adjournment.
ಮತ್ತೆ then we can ask
ಅಲ್ಲಿ
them to
ಅದರಲ್ಲಿ
take-
4 acres of the land. We purchased only 1 acre of the land from them.
ಅದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ ಅಷ್ಟೇ? 5, 6 are the
They
petitioner.
are the
8
petitioner.
and 9
8 and 9 ಇಬ್ಬರಿಗೂ ವೆಂಡರ್ಸ್ ಅವ್ರು ಯಾರು ಇದು ಮಾಡ್ಲಿ.
ಬಂದಿಲ್ಲ. So ಅವತ್ತು
ಅಲ್ಲ 8 and 9 ಅವರು ರಿಪಿಟಿಷನ್ ಹಾಕಿರೋದು. 5 and 6 ಒರಿಜಿನಲ್ ಪರ್ಚೇಸರ್ಸ್. ಅವರು ನಾಟ್ ಕ್ಲೇಮ್ಡ್ ಅಂತ ನಮ್ಮ ಪಿಟಿಷನ್ ಬಂದಿದೆ.
8 and 9 ನಾಟ್ ಕ್ಲೇಮ್ಡ್ ಅಂತ ಬಂದಿದೆ. 5 and 6 ನೀವು ಪ್ರೊಸೆಸ್ ಫೀ ಕೊಡ್ಬೇಕು.
ಅದ್ರಲ್ಲಿ ಒಂದು ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೇಳಿದ್ರು.
Police protection. If they do it, then we'll
Please,
take
ma'am.
action.
serial number 11,
For the petition,
Yes.
which time?
Counsel for the petitioners, ಎಷ್ಟು ಸತಿ ಆಗಿದೆ?
second time, 4 office objections.
Counsel for the petitioner is granted 2 weeks time finally to comply with the office objection. If the same is not complied with by 18th, the petition will be liable to dismiss for non-prosecution released on 21st.
Serial number 12, Sangamesh RB.
Notes the notice has been served on them, but notes the office has directed me to take steps once more.
Served.
Yes, notes.
Acknowledgement anything?
R3 insufficient
Avru-
address, R4 insufficient address, R7 door lock.
Not served.
R7 is the one, my lords, who is the contesting
Door
respondent.
lock, not served.
But may I request this, my lords? My lords, the matter was filed during the vacation bench. Lords, the honorable court issued notice, but then my lords did not allow me to press for an interim prayer.
In
The
who
interim
are
prayer,
you?
I am the, lords, the original grantee, 1940. is the
19.
Grantee.
We'll have to hear the others.
Lords, I am not seeking any.
The purchaser interfere in the possession, we can grant. not
ಅಲ್ಲ
otherwise.
ಅದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ lords, the assistant commissioner has already passed an order, lords, holding that the sale deeds are invalid because there is no non-alienation forever.
Deputy commissioner
condition.
ಏನ್ ಮಾಡಿದ್ರು?
Deputy commissioner, lords, in respect of one grant, two purchasers are there. Lords, both the purchasers will file appeal. One appeal, the deputy commissioner allows, the other appeal,
Sangamesh,
lords,
we
the
can't
deputy
grant you
commissioner
an order
reverses.
without hearing.
Now I will make this submission. Lords, 2011, subsequent to the order passed by the assistant commissioner, lords, the revenue entries from 2011 are standing in my name. Lord, now they have filed an application on the basis of this order to change the revenue entries. I would request this, lords, let there be status quo with respect to revenue entries, because from 13 years, lords, the revenue entries are standing in my name.
They're still standing in your.
Yes, lords, this is the revenue entry. MR number 139 of 2011-12, 14-12-2011, lords.
This is, when did you secure this? 1/6/24. They're in their name. File a memo.
I'll file it along with the memo.
Petitioner has filed a memo enclosing the RTC issued on 1/6/2024 at 11:14 AM. Considering that the revenue entries stand in the name of the petitioner, the the official respondents are restrained from effecting any transfer or of the revenue entries or making any change in the revenue entries till the next date of hearing. Issue fresh summons to respond number 3 to 5 and 7, returnable by 12th July. Process fee and copies to be furnished by end of day 11th June,
I'll do.
failing which the interim order will stand automatically vacated.
I'll do.
File a memo with this.
I'll do it. I'm obliged.
Serial number 13, Uday KS.
My lord, one of the office objection is that certificate copy of annexure E is not produced. I am filing the application for dispensation of it, my lord. And second office objection is that the ages of respondents 4 to 6 are not mentioned. My lord, they were their ages were not mentioned even before the third respondent, my lord, when they filed the.
Council submission al kotra mugiyate. You don't need it. Once the office objection is raised, give a council submission there. Both these could have been sorted out.
Application is ready, my lord, seeking dispensation. I'll file.
Log ನೋಡ್ಬೇಕು. Submit that the ages of respond number 4 to 6 were not mentioned in the annexure.
Annexure E.
Otherwise, you are wasting the time of this court for us to look into all these things.
I apologize.
Annexure E being the arising out of the application filed as per the order passed on 1/4/2020. In that view of the matter, office objection at sale number 2 is overruled. As regards office objection at sale number 1, he has filed an application for dispensation. Yenidu annexure E.
Annexure E is order passed by the assistant commissioner.
Where is the original of this?
Original order, my lord, I have applied for one more set of copies.
ನಿಮಗ್ ಬಂದಿದೆಲ್ಲಿ?
ನಮಗೆ ಕಾಪಿ ಸರ್ವಿಸ್ ಆಗಿದೆ. I had filed an appeal before for Deputy Commissioner, my lord. Copy of, certificate copy of it was,
Assistant Commissioner, you went before the Deputy Commissioner,
Please,
so you
madam.
should have had a copy of it.
Deputy Commissioner order I have produced, my lord. Assistant Commissioner order I have applied for one more copy.
One more copy.
Please.
Counsel for the petitioner has filed IA 1 of 24, seeking for dispensation production of the original of Annexure E. He submits that he has filed an application for issuance of fresh certified copy, since the earlier copy had already been used in the proceeding before the Deputy Commissioner. He is granted 3 weeks' time to obtain the certified copy and produce the same. Yes, what is it? Who are you?
Lord, I am the purchaser, my lord.
Purchaser.
Grant- Please, my lord. Grant was made on 10/5/1976.
Sale on,
Sale on 24/8/1992.
petition filed on,
Petition is filed on 17/5/2008.
and AGA accepts notice for respond number 1 to 3, issue notice to respond number 4 to 6, 4 to 10, returnable by 12th July. The operation and execution of the order dated 1/4/2020 passed by a third respondent in case number so-and-so at Annexure E and order dated so-and-so at Annexure F. He stayed till the next date of hearing. The petitioners are also restrained from in any manner dealing with their property, subject matter of the above petition till the next date, till the disposal of the present petition.
Much of-
We list on 12th.
Process.
Process fee and copies to be furnished by end of day 11 June,
Please.
failing which interim order will stand automatically.
Serial number 14, Shri Hari AV.
Notice may be dispensed to the other respondents, my lords. 3 to 6, they are not the contesting respondents. I'll file a memo to that effect.
Counsel for the petitioner has filed a memo seeking for dispensation notice to respond number 3 to 6. Accepting the said memo and the submission of letter and counsel for the petitioner, notice to respond number 3 to 6 is dispensed with the sole risk, cost and peril of
Please.
the petitioner.
Interim order may be extended.
R7 and 8.
Interim order was granted on last time.
ಇರ್ಲಿ. Argument ಯಾವಾಗ?
I have to take my instruction from my client.
ಯಾವಾಗ?
Within 1 week. Weeks.
Counsel for respondents 7 and 8 seeks bond is granted 2 weeks' time to file a statement of objections, if any. Objections to be filed on or before 25th June. And AGA also. Objection na records. Then AGA seeks for 2 weeks' time to secure records. Relist on 28/6 interim order earlier granted is extended till next date.
Much obliged. 16 also connected.
Connects with WP 14902 of 2024.
In that matter also, I'll be filing a memo to dispense with the.
ಬಂದ ಅವಾಗ.
Please.
Serial number 15,
My lord, on submission. In that connected matter, we didn't receive any
Connected ಮಾಡಿ ಕರ್ದವಾಗ.
NOC.
File ಬರ್ಲಿ.
15, Sarvana S.
Yes.
May I request for a passover?
Kindly pass over in.
Pass over.
Serial number 16, Shri Hari AV.
ಏನಪ್ಪ ಇದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ ಸೇಮ್ ಆರ್ಡರ್ has been challenged as in serial number 14.
ಹಾ.
ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ. Notice may be dispensed to respondents 3 to 6 my lords in this case also.
Counsel for the petitioner has filed a memo to dispense, seeking for dispensation notice to respond number 3 to 6.
Please.
Same dispense of the sole risk, cost and peril. ನೀವು 7 and 8
Yes, my lord.
ಕಿವೆಟ್ ಫೈಲ್ ಮಾಡಿದೀರಾ?
ಕೆವಿಯಟ್ ಫೈಲ್ ಮಾಡಿದಾರಂತೆ NOC ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
Still we not received NOC.
ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಅವ್ರಿಗೆ 6 and 7 ಗೆ 7 and 8.
ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಏನು?
Appear ಆಗ್ತೀವಿ.
ಕಲ್ಯಾಣ ಅವ್ರ ಹೆಸರು ತೋರ್ಸ್ಬೇಕಾ?
Please, madam.
your ಫೈಲ್ ವಕಾಲತ್
No, still not, madam.
still not filed. ಯಾವ ಫೈಲ್ ಮಾಡ್ತೀರಾ?
ಇನ್ನು ಕ್ಲೈಂಟ್ಸ್ ಇಂದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದಿಲ್ಲ. ಅದು NOC ಇನ್ನೂ ಬಂದಿಲ್ಲ ಅದಕ್ಕೆ.
Shri Kalyanar, on behalf of Shri Kalyanar, a submission is made that you would be entering appearance
Yes.
on behalf of respond number 7 and
Yes.
8.
7 and 8.
Registry is directed to print his name as such. He seeks for and is granted 2 weeks' time to obtain instruction, file his statement of objection. Objections, if any, to be filed same date. And AGA, same order.
Same order as in interim order.
ಒಂದು records ಬಂದ್ರೆ ಆಯ್ತಲ್ಲ.
ಹೌದು.
Connect with WP 14221 of 2024, relist on same date.
Interim order in this matter.
ಏನ್ ನೀವ್ಯಾರು?
I am for the petitioner. I am the purchaser. my lord.
Purchaser.
I have purchased a portion of land out of the.
Deal with the property till that.
Please. In connected matter, interim order.
Operation.
annexure est.
Clear? The
Connected matter order.
AGA accept notice ಆಗಿದೆಯಲ್ಲ? ಇದೆಲ್ಲ ಆಗಿಲ್ಲ. And AGA accept notice for respondent number 1 and 2. The operation and execution of the order dated 17/1/24 passed by the first respondent deputy commissioner and so on so on annexure A is stayed till the next date of hearing.
Much obliged.
Petitioners are also restrained from any manner dealing with the property subject matter of the above writ petition till the disposal of the above petition.
Please make.
Hearing on IS serial number 17.
The LR's application, my lord, last date.
Number 48 to E, my lords.
Any objection?
My lords, we have no objection.
During the pendency of the above matter, respondent number 4 expired on
28/2003, my lord. 28/2003.
2003. Application was filed 2003.
Yes, my lord.
Filing before the petition was filed.
Yes, my lord. Died on 28/3. She had 2 daughters, 1 son, my lord. Daughters, one also died. Son also died married, unmarried, my lord. Only Putlingamma has married 4 children.
ಇದು ಮೊನ್ನೆ ಬಂದಿತ್ತಲ್ಲ ಇನ್ನ ಇಬ್ಬರನ್ನ ಬಿಟ್ಬಿಟ್ಟಿದ್ರಿ
ಅದು unmarried, son. Unmarried, ಮಗ ಮದ್ವೆ
Is unmarried. Another one is also
married, no issues, my lord.
no issues.
Who expired on 28 to 23? 2003.
Siddhamma died, my lord.
ಸಿದ್ದಮ್ಮನ್ ಪಾರ್ಟಿ ಮಾಡಿದಿರಾ ಇಲ್ಲಿ?
ಮಾಡಿದ್ವಿ.
It is submitted as respondent number 4 Siddhamma expired on 28/2003, much before the filing of the above petition. Srimati Siddhamma was survived by 2 daughters and a son. ಎಷ್ಟು ಜನ daughters?
2 daughters, my lord.
2 daughters and 1 son. 2 daughters and a son. 4 daughters unmarried, huh?
1 daughter unmarried, my lord.
One of the daughter expired as a spinster. ಆಮೇಲೆ
ಮಗನು ಡೆತ್ ಆಗಿದ್ರೆ ಮ್ಯಾರಿಡ್ ಆಗಿದ್ದಾರೆ ಅವರು.
ಇವಾಗ ಯಾರನ್ನ ತರ್ತಾ ಇದೀರಾ ರೆಕಾರ್ಡ್?
ಪುಟ್ಲಿಂಗಮ್ಮನ ಮಕ್ಕಳು, ಸ್ವಾಮಿ. Putlingamma also died.
Putlingamma is the daughter.
Yes, my lord.
ಮಗನ ಹೆಸರೇನು?
ಚಕ್ರ ಸಣ್ಣಯ್ಯ.
ಅವರು ಎಕ್ಸ್ಪೈರ್ ಆದ.
Expired ಆಗಿ.
ಸೊ ಇವಾಗ ಇಬ್ಬರನ್ನ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಬೇಕಲ್ಲ?
Yes, ma'am.
Also expired on
24/9/2018, my lord.
24/9/2018. And the son ಹೆಸರೇನು?
Son ಚಕ್ರ ಸಣ್ಣಯ್ಯ.
ಚಕ್ರ ಬರ್ದ್ಕೊಡಿ. ಚಕ್ರ ಸಣ್ಣಯ್ಯ expired on?
Date no. My lord.
Has also expired.
Expired, man.
ಇವಾಗ ಯಾರನ್ನ who are you bringing on record?
ಪುಟ್ಲಿಂಗಮ್ಮನ ಮಕ್ಕಳು, ಸ್ವಾಮಿ. ಮೊಮ್ಮಕ್ಕಳು
ಚಕ್ರ
ಸಿದ್ದಮ್ಮ.
ಸಣ್ಣಯ್ಯ ಅವ್ರ ಮಕ್ಕಳು?
ಇಲ್ಲ, no issues.
Wife?
Wife also death, my lord.
Wife also did. Expired and also expired. Wife predeceased after? Wife ಅವ್ರ ಮುಂದೆ ಸತ್ತಿದ್ರ ಅದ ಅವ್ರ ಸತ್ ಮೇಲೆ ಸತ್ರ?
I am not aware, my lord.
That I don't have that kind of. Let's, they're all, whoever they have implemented here, they're all Putlingamma's children. Putlingamma's
ಚಿಕ್ಕ ವೀರ ಏನು ಅವ್ರೇನು?
Son.
ಅವ್ರ ಲೀಗಲ್ ಏರ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ?
ಅವ್ರ ಮಕ್ಕಳಿಲ್ಲ.
ಅದನ್ನ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಇನ್ನೊಬ್ರು ಸನ್ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇರೋದು. ಸನ್ಗೆ he died issueless. He is no more.
Yes, what about his wife?
His wife
ಡೆತ್ ಆಗಿದ್ದಾರೆ.
ಅವ್ರ ವೈಫ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ.
ನಿಮ್ ಫ್ಯಾಮಿಲಿ ರೀ, ನೀವ್ ಹೇಳ್ಬೇಕು.
ನಮ್ಮ ಇದ್ರಲ್ಲಿ ದೇ ಆರ್ ಆಲ್ Putlingamma ಇದು.
So your uncle, what happened to your uncle's family ಗೊತ್ತಿಲ್ವಾ?
Uncle's family, I don't have any knowledge, but that's.
ಅವ್ರಿಗೇನೋ ಗೊತ್ತಿಲ್ಲ, we can understand. ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ.
It's only my lords, as far as my clients are concerned, I can.
His wife also having expired, there being no issues. IA 1 of 22, IA 1, 2 and 3 of 2022 have been filed to bring the legal representative of the deceased Putlingamma on record, since they are the only legal heirs now of the deceased Siddhamma, respondent number 4. notice having been issued to the person named in IA 3 of 2022, Shri Vinay Kumar GS has entered appearance for them. He submits that he has no objections for allowing IA 1, 2, and 3 of 2022. In the interest of justice, even though respondent number 4 had expired prior to filing of the petition, and the petition is filed against dead person, considering that the legal representative, respondent number 4, have no objections, IA 1 of 2022 is allowed the delay of
1786 days, my lord.
1,786 days is condoned. Consequently, IA 2 of 2022 is allowed. The abatement in respect of respondent number 4 is set aside. By allowing IA 3 of 2022, the persons named therein are brought on record as respondent number 4A to E. Counsel for the petitioner to carry out necessary amendment and file amended cost title. When will you get ready?
Well, it's
2015.
any date, your lordship may.
You want to file any objections or?
Well, at this moment of time, they don't have any records and they are also not interested.
We list on 21/6 for 21/6. In the meanwhile, amendment to be carried out and amended cost title to be filed.
18, R. Shashidhara.
Respondent number 3, my lords, is no more. Respondent number 4 to 7 are the LRs of the respondent number 3, my lords. My lord, wide order dated, my lord, on 17/3/2023. The petition was set aside, abated against respondent number 3, my lords. And so I filed application to recall the said order.
During the pendency of the above matter, respondent number 3 expired, which came to the knowledge of the petitioner and this court on account of the postal shara having been returned on 10/8/2018. Indicating that he had expired on 10/8/2018. Hence, IA 1 of 23 has been filed for setting aside the abatement by contending that respondent number 4 to 7 are the only legal heirs of deceased respondent number 3. Accepting the statement made in support of IA 1 of 23, the said application is allowed. The abatement in respect of respondent number 3 is set aside by allowing the memo dated 10/4/2023, respondent number 4 to 7 are treated as a legal representative of deceased respondent number 3. Counsel for the petitioner to carry out necessary endorsement in the cost title indicating that respondent number 4 to 7 have been treated as legal heirs of respondent number 3 by virtue of this order. None appears for the respondent. Relist on 21/6.
Please.
Serial number 19, DM Siddhappa.
Some technical difficulty, senior cannot log in.
LR application senior ಏನಕ್ಕಪ್ಪ ಬೇಕು?
I don't have the file.
ನೀವ್ ಹೇಳಿ.
Don't have the file.
R3, setting aside abatement and bringing LRs.
Notice should be gone for LR application, LRs.
R3. Shashidhara, you accept notice for R3?
The notice may go, my lord. I'm not aware that with the last
4 and 5 ಇದೀರಾ?
4 and 5.
ಅವ್ರಿಗೂ ತಗೊಳ್ಳಿ. Time save ಆಗುತ್ತೆ. Shri R. Shashidhara, who has entered appearance for respondent number 4 and 5, accepts notice on IA 1 of 23. Filed to bring the legal representatives of deceased respondent number 3 on record. Considering that respondent number 3 is the brother of respondent number 4 and 5. He seeks fund is granted 2 weeks' time to obtain instruction, make a submission, relist on 21/6.
Serial number 20, Rajendra MS.
For the petitioner, my lords, I filed an application to bring the legal representatives of respondent number 4.
I undertake to appear for the legal.
Shri P.H. Virupaksha, who has entered appearance for respondent number 4 through caveat, accepts notice on IA 1, 2, and 3 of 2023, which have been filed to bring the legal representative deceased respondent number 4 on record.
Please, can be allowed.
Allowed. He submits that he has no objection for the said applications to be allowed. Considering that respondent number 4 expired on
5/4/2021.
IA was filed on
IA was filed in on 21/8/2023.
Respondent number 4 expired on 5/4/21, hence IA 1 of 23. IA 1, 2, and 3 of 23 were filed on 21/8/23. IA 1 for condemnation of 388 days. IA 2 for setting aside abatement, and IA 3 for bringing legal representative of deceased respondent number on record. Accepting the reasons stated in support of IA 1 of 23, delay of 388 days is condoned. IA 1 of 23 is allowed. Consequently, IA number 2 of 23 is allowed. The abatement in respect of respondent number 4 is set aside. By allowing IA 3 of 23, the person named therein and brought on record as legal representative of respondent number 4. Counsel for the petitioner to carry out necessary amendment and file amended cause title.
It's a week's time, I'll also file my objections.
Counsel for respondent number 4, A2, 4A2?
A to C.
A to C.
A to C. A to C. Counsel for respondent number 4, A to C, as also respondent number 5 to 7. If seeks for is granted 2 weeks time to get ready and address his arguments, relist on 21/6. Okay.
21.
Look, I've made an application for bringing on record the LRs of deceased respondent number 6. She passed away after the impugned order was passed, but before we filed it.
Accept our notice, sir. During the pendency of the above matter, respondent number 6 expired. As such, IA 1, 2, and 3 of 23 have been filed. Issue notice on the persons named in IA 3 of 2023. As regards IA 1, 2, and 3 of 23, returnable by 12 July. Process fee to be paid. Process fee to be paid and copies to be furnished by end of day 12 June. Failing which the said application will stand dismissed.
Please.
Serial number 22. Harish HV.
For response 4 and 4, 5 and 6. Milad, respondent 7 died and filed the applications on a condonation of delay 1191 notice has to go. And
R9, deceased.
R9 also is there for 4 response 4, 5 and 6.
4 to 6.
But what has been stated in IS 2, 3 and 4 of 2022, Milad, is total falsehood. What has happened is the 7th respondent died in 2017. That's what I kindly see the objections filed by me for a moment. Now the petitioner
filed objections
to the IS 2, 3 and 4 of 2022.
That is in respect of respondent number 7.
Respondent number 7.
Are you going to appear for the LRs mentioned in IF?
Or LR say Allah. He Milad 7th respondent died unmarried. This question has been considered by the deputy commissioner. That has been suppressed by the petitioner in the writ petition. And he files the writ petition as if 7th respondent is alive. Kindly see, Milad, the objections filed by me for a moment.
Already considered by Andre, we'll have to consider whether the contention, whether the order is.
No, Milad, in the order sheet, on the order passed by the deputy commissioner, nothing is there on that.
Elli there, Mr. Ramchandra.
The order, Milad, I am the subsequent purchaser, I came to know and I filed it. He has died during the pendency of the petition itself.
Respondent number 7 was who before the deputy commissioner?
Lord. Respondent number 3, Anjanappa.
Respondent number 7 is Anjanappa.
3. Kindly see the order passed by the DC last
3. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಆರ್ಡರ್ ಅಲ್ಲಿ ಅದ್ರ ಬಗ್ಗೆ?
ಅಲ್ಲ ಅದರ 13 page 13 his name is shown, LRs are not. Before going to Milad, the order of first deputy commissioner, kindly see the objections for a moment.
ನಿಮ್ಮ objections ಆಮೇಲೆ ನೋಡೋಣ. In the orders.
7th respondent died in 2017. Now this has been Milad brought to the notice of the deputy commissioner in the appeal, and he has dealt with this question.
Where has he dealt with?
Next year, Milad, your last may go to page number 15. ಕನ್ನಡದಲ್ಲಿದೆ 2ನೇ ಇರ್ತಾರೆ ತಮ್ಮ ವಕೀಲರ ಮೂಲಕ ತಮ್ಮ ಲಿಖಿತ ಆಕ್ಷೇಪವನ್ನು ಬೆಳೆಸಿದ್ದಾರೆ. ಅದರಲ್ಲಿ 3ಕ್ಕೆ ಹೋಗಿ ಆರಾಮ್ 3ಗೆ. The respondent submits that the 3rd respondent ಅಂದ್ರೆ Anjanappa. In the above appeal by name Anjanappa died on 17/3/2017 without marriage and without any issues. As he being the brother of the respondent, she has cremated him as per the customs prevail in the community, and there are no legal heirs of the deceased said Anjanappa. And this respondent of wife and LRs of the first respondent are the only LRs of the deceased Anjanappa who are all on record. The respondent submits that the appellant being the stranger to the family in the order to mislead the honorable court has filed pre-all application by stating that some other persons as LRs of the deceased Anjanappa. As such, the said application is to be dismissed. The respondent submits that since there are no LRs of the deceased Anjanappa and who are already on record,
As such, the said appeal application filed under Art 22 Rule 4 and Section 5 of the Limitation Act. So application does not zero consideration needs to be dismissed. This is, my lord, what has been noted by the Deputy Commissioner.
What is the order on that?
Order ಅದರ ಇಷ್ಟ ಅದ್ರ ಮೇಲೆ ಹೋಗ್ಲಿಲ್ಲ ಅವರು. But petitioner has suppressed material fact. ಅದಕ್ಕೆ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಒಂದ್ ನಿಮಿಷ ನೋಡಿ ಅಂತ ಹೇಳಿದ್ದು. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಎಲ್ಲರ
Applications ಮೇಲೆ ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಇಷ್ಟ ಇದ್ರ ಮೇಲೆ ಏನು ಇಲ್ಲ.
ಏನಿಲ್ಲ.
But he died Milad 2017. The petitioner filed Milad LR application before the deputy commissioner. I produced not those applications along with my objections. ಈ ತರ ಸುಳ್ಳು ಹೇಳ್ಕೊಂಡು ಕೋರ್ಟ್ಗೆ ಬರ್ಬಾರ್ದು. ಇಲ್ಲ ಇರೋದು ಇದ್ದಂಗೆ ಹೇಳ್ಬೇಕು.
Lord, even that application is not considered by the.
Order ಮಾಡಲಿಲ್ಲ, but that has been noted. Your lordship knows how Milad this authorities pass
I
orders.
would be very happy if that contention is true. My client says that he is dead and his LRs are there and he has given LRs.
Where is IA 4?
ರಿಟ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಅರ್ಜಿಗಳಲ್ಲಿ ಹೇಳ್ತಾರೆ. 2 and 3 and 4 of 2022 ನಲ್ಲಿ.
IA 4 ಎಲ್ಲಿ? ಏನಂತ ಹೇಳಿದ್ರೆ ಯಾವಾಗ ಸತ್ತಿದ್ದಾರೆ ಅಂತ?
ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ 7th respondent died ಅಂತ ಹೇಳ್ತಾರೆ, which is total falsehood. He also knows.
That may be a typographical error, my lord, but he died during the pendency of the order, before the order passed by the deputy commissioner.
ಎಲ್ಲಿ ಹೇಳಿದ್ರಪ್ಪ? You said Court Master Reddy is saying during the pendency of the writ petition ಅಂತ ಹೇಳಿದ್ರು.
ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ 3 ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ.
ಒಂದು ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹೇಳಿದ್ದಾರೆ. ಇನ್ನೆರಡು ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
But I have also said I inquired and came to know his death and thereafter given all the
Para
information.
4 ನಲ್ಲಿ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ 2022 applications in para 4.
I am not aware of the law of limitation. ನಾವು ಇವು ಎಲ್ಲ ಬರೆದಿದ್ದೀರಾ. There is already a finding by the deputy commissioner giving the date of death.
My lord, date death is there, but application is not considered. Order sheet is available.
That's a different, you should have mentioned that in your application.
My lord, I would file a better affidavit so far as a 7th.
Affidavit ಅಲ್ಲಿ ಸುಳ್ಳು ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು?
That's what, my lord, now the party.
Is contention.
No, now the party has given, these are the persons who are paid by them. My lord, kindly see page number 3 for a
moment.
moment.
Given whatever, if your party gives a false statement on oath on one aspect, the other aspect also is false.
My lord, he has clearly stated in para 3 that he is dead and his LRs are Ashwatthama and Pratap, that's a son. I have said clearly.
Please read para 4.
My lord.
Para 4 of
No, that I agree, my lord. During the pendency of the writ petition.
ಅದೇ ಅಲ್ಲ ಇನ್ನೇನೇನೋ ಬರ್ದಿದ್ದೀರಾ?
That I have said, my lord.
But if you read the whole thing.
My lord, I submit that during the pendency of the proceedings, the respondent number 7 demised and left the above mentioned persons as his legal aids, as stated in the accompanying application, who succeed and represents to the estate of the deceased. Their presence before this court is very much necessary and would assist the court in determining real question and controversy between the parties. I inquired, came to know his death, thereafter given all the information to advocate to file the application.
Affidavit ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
My lord, I am.
IA number?
IA number
3. I state that I was not aware of death of respondent number 7.
My lord, is it
Only when my
respondent
advocate
7?
called me and informed me regarding his death as per postal shara. I inquired. ಎಲ್ಲ ಸುಳ್ಳು
My lord, ಅದು 7 ಅಲ್ಲ 9 ಬಗ್ಗೆ ನೋಡ್ತಾ ಇದ್ದೀರಿ ತಾವು.
7. Not aware of the law of limitation. ಏನೇನೋ ಬರ್ದು.
My lord, para 4 start with I submit that during the pendency of the.
Which IA are you reading?
My lord, delay application.
IA number?
Lord, IA number 1 of 2022 lordships. So delay 2 of 2022, sorry.
Art 22 rule.
1191 days delay.
Art 22 rule 4 ನಲ್ಲಿ ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ para 4 ನಲ್ಲಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. Section 5 of the Limitation Act ನಲ್ಲಿ ಹಾಕಿರೋ ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ ಅಬೇಟ್ಮೆಂಟ್ ನಲ್ಲೂ ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ para 4 ನಲ್ಲಿ.
My lord, see para 4, my lord, 1199, that's IA 2 of 2022. My lord, this is what, I submit that during the pendency of the respondent demised and left the above mentioned persons as so and so, who succeed and represent their presence
All
before,
these applications you have said or mentioned
that
or
he died before.
adverted to the observation made by the deputy commissioner.
My lord, I have not stated so.
We'll go
But-
by, these are all routine
My lord,
matters.
it is true, my lord.
We'll accept the submission with accepting the submissions and theory.
That is true. Even, my lord, only when he filed objection, I came to know about that, and even I secured the order sheet.
You could not have known because you're challenging that order,
My lord,
which is clearly mentioning that he expired in 2007.
ಅಲ್ಲ ಅವರೇ ಅಪ್ಲಿಕೇಶನ್
by-
ಆಗಿದ್ದಾರೆ ಡಿ ಸಿ ಮುಂದೆ. I produced that
that is by
application also.
mistake probably, my lord.
Not a mistake. We'll take action against Mr. Srihari.
My lord, if that is the case, the
We'll-
order passed by the
we'll
deputy
take-
commissioner, my
We'll
lord,
take action against Srihari Reddy, number one.
my
but
lord,
we'll
once,
issue notice
before
on
that, my lord,
Just
very
a
true.
moment, just a moment. But we'll have to issue notice. If they are the legal representative, they cannot be deprived.
Correct, my lord, but we have categorically
We
stated
don't
that
know whether your category.
he died unmarried.
ಅವ್ರು ಬಂದ್ಮೇಲೆ ಕೇಳೋಣ ಅವರು
Yeah.
ಏನಿದೆ ಅಂತ.
That question may be left open.
Will be
But
left.
ಈಗ, my lord, for a moment, before that, kindly see the objections, page 5. Page 5 of my objections.
ನಿಮ್ಮ objections ಹೇಳಿ. Objections to?
Objections to all the three IAS of filed in 2022. IAS 2, 3 and 4. Common objections ಹಾಕಿದ್ದೀನಿ.
Statement of objection to. ಇಲ್ಲ. 3 of 22 ಬೇರೆ ಇದೆ, 4 of 22 ಬೇರೆ ಇದೆ. ಕಾಮನ್ ಅಲ್ಲ ನಿಮ್ದು, ಬೇರೆ ಬೇರೆ ಇದೆ.
ಅಲ್ಲ, ನನ್ನ objections, ನಾನು ಕಾಮನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ.
ನೀವೇ ಸೈನ್ ಮಾಡಿದೀರಾ.
ನಾನೇ ಸೈನ್ ಮಾಡಿದ್ದೀನಿ.
ಕಾಮನ್ ಅಲ್ಲ, ಬೇರೆ ಬೇರೆ ಇದೆ.
ವೆರಿ ವೆಲ್. ಇದರಲ್ಲಿ ನಾನು ಸ್ಟೇಟೆಡ್. Kindly go to my lord, the objections filed to, lord, application to Art 22 Rule 4. Art 22 Rule 4. ಅದರಲ್ಲಿ
Died unmarried and not having any.
ಪೇಜ್ ನಂಬರ್ 5 ನಲ್ಲಿ ನಾನು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೆ.
We don't know, we'll find out.
ಆಮೇಲೆ petitioner has filed an application annexure R2 page 6 before the deputy commissioner. He was aware that the seventh respondent died. He files an application before the deputy commissioner to bring these two persons as LRs. This application, as your lordship seen in the order, it has been discussed, but there is no conclusion.
No order.
Order ಇಲ್ಲ. But
Order is-
ಇದನ್ನು ಹೇಳಿದ ಮೇಲೆ he makes seventh respondent again a party here as if he is alive.
That will take action.
And he suppresses
My
material.
lord, page 13, my lord.
Yeah.
Sorry, my lord. Page 13 may be seen for a moment.
13 of what?
13 of the writ petition. My lord, the order passed by the DC. In the cost title, my lord, the name is shown as Anjanappa. That may be the reason why, my lord, it has continued in the writ
It
petition.
cannot be a reason, Mr. Harish. You are challenging an order. So obviously it presumes that you have read the order which you are challenging.
My lord,
Have you
that
not-
is true,
Is it
but
your
sometimes
contention that you have not read the order that you are challenging?
that the cost title says that, my lord, that's
We
the
are
reason why
issuing
it
a
is.
show cause
Anyway, my
notice
lord,
under section
would-
340 to your client.
my lord, that.
Give your show cause, you give an explanation, we'll consider that. You cannot be saying and doing these kind of things.
My lord, I shall inquire, my lord. I shall.
ಮತ್ತೆ ಅಶ್ವತ್ಥಮ್ಮ ಎಲ್ಲ ವೈಫ್
the-
ಅಂತ ಹೇಳ್ತಾರೆ. I produced documents show that she is the wife of somebody else.
IA 1, 2 and 3 of 2020, IA 2, 3 and 4 of 2022 have been filed to bring the legal representative deceased respond number 7 on record. In the said application, it is contended by the petitioner that the petitioner was not aware of the date of death of respond number 7. It is further contended that he expired during the pendency of the above proceeding, above writ petition,
Said proceedings.
and that the date of death and the aspect of death came to the knowledge of the petitioner only upon the return of the postal shara indicating the death of respondent number 7 and on the counsel for the petitioner inquiring in relation thereto. It is further contended that the petitioner is not aware of the law of limitation and not being aware of the legal process after coming to know of the death through inquiry. IA 1, 2 and 2, 3 and 4 of 22 have been filed. Objections thereto have been filed by respondent number 4 to 6 and 9, contending that respondent number 7 had expired long ago on 17/3/2017 in the which had been brought to the notice of all concerned in the proceedings before the Deputy Commissioner.
But he filed, my lord, petitioner filed an application before the Deputy Commissioner. That is page number 6 in the objections. His own
Order sheet is
application.
there, my lord. No orders are passed on.
ಅದು ಬೇರೆ ಆಯ್ತು. ನಾನೇ ಹೇಳಿದ್ದೀನಿ ಆರ್ಡರ್ ಕನ್ಕ್ಲೂಷನ್ ಇಲ್ಲ ಅದರಲ್ಲಿ ಅಂತ. This is
Then that the petitioner as an appellant had filed applications to bring the legal representative of the deceased respondent number 7 before the Deputy Commissioner itself, which was considered by, as regards which objections were filed by Uriaro, who had filed this, Gayatram, by respondent number
Gayatrama.
Or two.
Brother of Milord Anjana.
respondent number 6 before this court and respondent number 2 before the Deputy Commissioner, categorically indicating that Anjanappa, respondent number 3, Anjanappa, respondent number 7, Anjanappa had expired on 17/3/2017 and they are no legal representative of his. In that view of the matter, show cause notice is issued to the petitioner to explain as to why false statements have been made in the affidavit in support of IA 2, 3, and 4 of 2022 under section 340 of the Code of Criminal Procedure. Even though it is disputed by respondent number 4 to 6 and 9.
9 is no more.
Respondent number 4 to 6. Even though it is contended by respondent number 4 to 6 that respondent number 7 expired without legal heirs. And the considered opinion that since applications in IA 2, 3, and 4 of 2022 have been filed, claiming that the persons named in IA 4 of 22 are legal heirs of deceased respondent number 7, I deem it fit to issue notice to respondent number on those persons on IA 2, 3, and 4 of 2022. The aspect of whether they are legal heirs or not is left open and would be considered on the basis of the submissions made by them on their appearance.
And
The issue notice returnable by 12th July, process fee to be paid by end of day 12th June. The reply to the show cause notice to be filed on or before 18th June, relist on 21st June for consideration of the said reply.
There are 3 more IS filed by the petitioner.
respondent 9
Yes.
died on 9/6/23.
I reported the death of respondent number 9.
Hmm.
Thereafter, it appears petitioner has filed some applications. I have not received copies of the same, my lords.
Copies could,
I'll give it right now.
counsel for the petitioner undertakes to furnish copies of IA 2, 3, and
IA 2 of 23 and 3 of 23.
Ashtena
He dies on 9/6/2023.
in favor of respond to the council.
ನನ್ನ ಮೆಮೋನಲ್ಲೇ ಎಲ್ಲಾರ್ಸ್ ಯಾರು ಅಂತ ಹೇಳಿದ್ದೀನಿ. If your lordship finds that.
12th June.
Please. And R3, my lord, is dead. And R4 and 5 are already on record.
ಅದಕ್ಕೆ ಏನ್ ಮೆಮೋ
ಅದು ಬಂದಿದೆ. If it has come, I will make necessary amendment.
R4 and 5 are treated, ಆಗೋಗಿದೆ ಅಲ್ಲ?
Treated.
ಆಗಿದೆ.
I'll furnish the copy, madam.
Yes.
Serial number 23, Vinod Prasad.
My lords, I am appearing for respondent number 13 and 14, my lords. My lords, I undertake to file wakalat in respect of respondent number 5 to 8, my lords. My lords, I received the wakalat, my lords.
You will file wakalat for 5 to 8.
My lords, 8 and also my lords 10, 11 and 12, my lords. I need some clarification from my parties. A sign ಒಂದರಲ್ಲೇ ವಕಾಲತ್ತಲ್ಲಿ ಇದು ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ. I will get an instruction and file within a week, my lords.
ವಕಾಲತ್ 5 to 8 ಆಗ್ತೀರಾ?
Yes, my lords.
14ಗೂ accept ಮಾಡ್ತಾ ಇದ್ದೀರಾ notice?
14 I have filed the wakalat, my lords. That
File
other
your-
ranking of the parties, it was mistaken, my lords. That's why it was not shown as wakalat file. I have corrected in wakalat. I have corrected in the wakalat, my lords.
I check ಮಾಡ್ತೀನಿ.
In this
Please.
petition, the one of the respondent left out, the not included due to oversight, my lord. Typed application
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ?
to include the party.
IA ನಂಬರ್
I number 1/24, my lord.
ನಂಬರ್ 1 of 24.
Yes, my lord. His name is Mr. Basha. Kindly impugn order, my lord. Page number 22. Respond number 4, my lord. Basha is not included in the petition.
ಅವ್ರ ವಕಾಲತ್ ಹೆಂಗ್ ಹಾಕಿದ್ರು?
That's also.
13 is there, my lords. Basha. This one number 13 is there.
ಇಲ್ಲಪ್ಪ ಭಾಷಾ ಎಲ್ಲೂ ಇಲ್ಲೋ ಇಲ್ಲ.
The office objection ಮಾಡ್ಬೇಕಾಗಿದ್ದಾಗ.
ಈ ವಕಾಲತ್ ಹೆಂಗ್ ಹಾಕಿದ್ರಿ?
Sir, in my petition, ಅಲ್ಲ ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟಿರೋದು ಇದ್ರಲ್ಲಿ ನನಗೆ. Well, they have served the copy, petition copy, my lords, in that respond number 13, Pasha Muhammad, son of Muhammad Umar Saab.
Petition ಅಲ್ಲಿ ಆಗಿತ್ತು copy.
ಬೇರೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ರಲ್ಲಪ್ಪ ಅವ್ರಿಗೆ.
By mistake ಆಗಿದೆ.
By mistake it was omitted.
Then the name is found in his copy, not in the court copy.
Please, madam.
In petition ಇನ್ನೇನಾದ್ರು ಮಿಸ್ಟೇಕ್ ಇದೆಯಾ?
ಇಲ್ಲ sir.
ಅದೊಂದೇ ಮಿಸ್ಟೇಕ್.
ಒಂದೇ mistake.
Due to oversight, it was not mentioned.
If better copy may be served, my lords, I will correct myself and rank of the parties, my lords, in the wakalat also.
I'll
151 ಅಲ್ಲಿ ಹಾಕಿದೀರಾ ಇದು?
Please, madam. Is in the party is in impugn order, my lord. By oversight, it was not included.
So you will be appearing for Basha Mohammed.
Yes, my lords. Almost all are private respondents. I will take undertake to file wakalat, my lords. The rank there is a mistake in rank of the party. That's why I have to make corrections in the wakalat also.
Let counsel for the petitioner submits that in the writ petition filed due to an unfortunate error, the name of Mr. Basha, son of Muhammad Umar Saab, was not mentioned. However, in the copies furnished to the respondents, his name was mentioned, which is accepted and admitted by the counsel appearing for respondent number
14 minutes, 13 and 14.
5 to 8 and 11 to 13, 11 and 13. The said counsel submits that he has no, it is in that background that IA 1 of 24 has been filed under section 151 of the Code of Civil Procedure to include the name of Mr. Basha, son of Muhammad Umar Saab, as respondent number 14 in the petition. The counsel appearing for respondent number 5 to 8 so and so submits that he has no objection for the said application to be allowed, and he would be appearing for Basha, son of Muhammad Umar Saab. In that view of the matter, IA 1 of 24 is allowed. The person named therein is brought on record as respondent number 14, for whom the Shivogi Mutt appears, I accepts notice. He further submits that he would appear for all private respondents, that is respondent number 5 to 14.
Please.
His submission is placed on record. Registry is directed to print the name of the Shivogi Mutt as that appearing for respondent number 5 to 14. You'll be appearing for all,
Please,
Allah?
Please, my lords, please.
And delete the name of the Anjan Kumar R as that appearing for respondent number 12. Both the counsel seek for 2 weeks' time. Learned counsel for respondent number 5 to 8 seeks for and is granted a week's time to file necessary wakalatnama
Amendment.
showing the proper names and ranking of the
Please.
parties. Counsel
Please.
for the petitioner to carry out necessary amendment and file amended cause title within 10 days time, 10 days from now. Relist on 5/7
Please, ma'am.
22 interim order earlier granted is extended.
Serial number 24.
For the petitioner, my lord. Grants me 2 weeks, my lord, to comply the office objection. For dismiss for non-compliance of office objection.
Pending consideration of IA 1 and 2 of 2023, the counsel for the petitioner is permitted to comply with the office objection. Relist on 28/6.
Please.
Serial number 25. Abhinav Anand.
My lord, this petition pertains to grant of 2 acres of land to a person belonging to scheduled caste in the year 1962. One Muni Venkatappa, my lord, the original grantee was granted 2 acres of land.
So these two amendment applications,
Please, mate, there are 4 IAs. Through IAs,
two
1 and,
amendment application, two dispensation applications.
please, mate, 1 and 3 are for dispensation, 2 and 4 for amendment of the.
What about
petition, my lord.
dispensation? Any? And 4 of 23, which are for amendment. He submits that the said application can be considered at the time of final hearing. His further submission is that even if they were to be allowed, the objection statement filed to IA 2 of 23 and 4 of 23 may be regarded as additional objections.
Yes.
His submission is placed on record. On that day, we'll consider everything.
Serial number
Put it
20.
13th, not,
We take it only on 14th, Becca, 20.
Serial number 26. Ramachandra Reddy.
R3. So ready? Mr. Badri? Your matter is being called out. Serial number 26. Will you accept notice for R3's legal errors? Please. You are appearing for R4. File allapa.
Please. We'll accept notice.
Who is R3? Is your brother, right? And
LR application has been filed. Please. Notice has to
ಇಲ್ಲ,
go
ಇಲ್ಲ,
to.
notice ಹೋಗ್ಬೇಕು.
Notice ಹೋಗ್ಬೇಕು. We have for the 4th purchasers.
27, B. Ramesh.
Should it be passed over, my lords?
Matter may require a final disposal. I am ready any day.
Do the final disposal, but before that, all this,
Okay.
what are these other things? IA 1 of 24. Shall we consider along with the main records, Becca?
May I just submit this? Within 1 day, my lords, possession is given by the Tahsildar, taken over, trees cut. Now they enter into agreement. Main is one thing, but they were aware of it. Tahsildar, my lords. That at least, my lords, your lordships.
Everybody is here. We'll take it up for final hearing. Records, Becca.
Records, there's nothing much in the records. What I would. What I would submit is this.
Counsel for the petitioner, senior counsel for petitioner, as also the counsels for New Year again.
None, I represent 4 to 7.
4 to 7.
Article.
Respond number 4 to 7. Obrena, 4 to 7.
Outside.
Because there are two counsels.
Irli bidi, or
4 to 7 ಇದೆ ಒಬ್ರೆ.
Ravishankar, you filed.
ನಂದಲ್ ನನ್ನ
ಯಾರು
permitted.
file ಮಾಡಿದ್ರು?
Karthik Vim. For all the 4 insurance.
Shivagimat and Karthik Veena. Naveen S in 4 and 5.
Naveen S is also my colleague. He's also.
His colleague.
Wakalat not filed ಅಂತಿದೆ.
ನೀವು ಹಾಕಿದ್ದೀರಾ?
ಮಾಡಿ.
ಬರೀ 4 and 5 ಹಾಕಿದ್ದೀರಾ? 6 and 7 ಗೆ?
ಹಾಕಿದ್ದೀನಿ.
First ಇದ್ರ ಮೇಲೆ ಮಾಡಿ.
Filed yesterday.
Karthik V.
ಹಾ, Shivagimat and Karthik V have entered appearance for respond number 4, 5, 6 and 7. Registry is direct print their name as such. Delete the name of Naveen S that appearing for respond number 4 and 5.
LRs of 6 and 7.
LRs of 6 and 7.
6 and 7 are dead.
5
They are
LRs of respond number 6 and 7. 8 to 11 dispensed with.
Yes.
They are my vendors. my lords.
The noting in respect of the order dated 8/4/24 as regards filing of Wakalatnama by respond number 4 and 5 is directed to be deleted. Counsel, both counsel for the senior counsel for the petitioner as also respond number 4 to 7 submit that records are not required and they would be arguing on the basis of the petition and the objections filed. Relist on 14th for final hearing.
21st ಅನ್ನಬೇಕು ಸ್ನೇಹಿತರೆ 14th ಊರಲ್ಲಿ
21st for final hearing.
already be ready.
Let them at least not. Now what has happened? They have also entered into a registered agreement to sell. Ill time ತಗೊಂಡು ಅಲ್ಲಿ ಅದ್ ಮಾಡಿದ್ರು. My lords, one Tahsildar.
That may be, he may have to see the order sheet. They are the ones, 4 to 7. I am the original grantee's children. They are the ones who took time. I have entered into an agreement. I will not sell.
All the parties are restrained from dealing with the property, subject matter of the above writ petition till the next date. None of you deal with it.
No, but the Tahsildar's, my lords, the action your lordships would have to examine.
Deal with it. Ready dog tone, we'll deal with it.
Bereft of merits. What I was trying to impress is bereft of merits. Tahsildar in 1 day gives possession, my lords.
All under the.
Mr. Pranindra, if you have to deal with the Tahsildar, we'll deal with that. If we have to deal with the submissions, we'll deal with that. Everything will be dealt.
Possession given, trees cut, trees sold.
All lawfully we have done it. So we'll argue it.
Yes.
For dismissal, serial number 28. Vaishali Hegde.
Lords, this matter, and if your lordship sees the order sheet, we have not taken, how many times it's come? We, my lords, in an identical matter which was filed pertaining to the same petitioner,
It is 2010 matter. Now
Yes,
you are
sir.
ready to address arguments, address. There is Mr. Vijay Shekhar Gowda.
We had filed an amended petition also, my lords, raising the ground of delay initiating proceedings. In so far as earlier to this Nekanti's judgment, my lords, there were two issues with they are probably the records are called only to show about 2 years in filing this. We have stated and court heard that on the delay in filing this.
Instead of you want, respond number 3 and 4 have not been appearing.
Our time, in fact, the first matter which this honorable court, my lords, allowed on Nekanti's case, this was when this was the first matter which was listed. From that day, they have been taking time. Even
records beka.
I am not, so if they want.
No question, Mr. Pranindra.
My lords, then your lords may call for the records. Only the grant certificate is there. Only those records should be available with the DC or my pleadings. If they dispute any of the pleadings, they have to have the records.
They secure records from the office and they are already order agide.
Yes, records I have received, my lord. Only proceedings they have sent, my lord, from concerned Tahsildar. I will secure original grant records and Darkast, my lord.
Entire records bandilwa.
Illa, bandila.
Okay.
ಅದು my lord, here Tahsildar is a party ಮಾಡೋದಿಲ್ಲ ಇಲ್ಲಿ wherever, my lord. Only deputy commissioner, assistant commissioner is a party in all PTCL matters, my lord. Assistant commissioner and DC, my lord, they'll send whatever proceedings what we have, my lord. Again, we have to call concerned Tahsildar.
File they have to send, whatever is there on the.
Records, custodian of the original grant records will be to Tahsildar, my lord. Again, we have to call Tahsildar and
Whatever has been produced before them, they have to produce.
please, my lord.
Before this court, when we ask for records.
Correct me. I'll secure, my lord, original. Once I
AGA
see-
submit that partial records are
Please,
received. It is not understood as to why partial records have been sent. When records are called for, the entire records
Please, ma'am.
pertaining to that matter would have to be forwarded by the concerned officer to the AGA.
please, ma'am.
Hence, the current AGA is that bring it to notice of respond number 1 and 2. Above order to notice respond number 1 and 2 and secure the entire records. Relist on 14th June, considering that the matter is of the year 2010 and no further adjournment can be granted. If records are not received by 14 June,
Yes, ma'am.
both the deputy commissioner and this assistant commissioner shall remain present before this court personally.
Let it not be in the stage of dismissal for now. Our stage in the archer, we'll come and argue, my lords, but
List on so and so date for final hearing.
Serial number 29. Madhukar Deshpande.
Preparing for respond number 19 to 23 months.
ಪಿಟಿಷನರ್ ಯಲ್ಲಪ್ಪ ಅವರು ದೊಡ್ಡಪ್ಪ ಆಗ್ಬೇಕು ಸರ್ ನಮ್ಗೆ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅವರು ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾ ಇಲ್ಲ
ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಿ
ಬರ್ತಾ ಇಲ್ಲ ಸರ್ ಅವರು ಅದೇ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟ ನೆಕ್ಸ್ಟ್ ಬೇರೆಯವ್ರ ಲಾಯರ್ಗೆ ಕೊಡೋಣ
ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್?
ಗೊತ್ತಿಲ್ಲ ಸರ್
ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗತ್ತೆ.
ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್ ನೆಕ್ಸ್ಟ್ ಬೇರೆಯವ್ರ ಲಾಯರ್
ನೋಡಿ ಎಲ್ಲಪ್ಪ ಇದೇ ಮ್ಯಾಟರ್. ಎಲ್ಲಪ್ಪ ಅವ್ರು ಸತ್ತೋಗಿದಾರಾ?
ಹಾ ಸರ್ ನಮ್ ದೊಡ್ಡಪ್ಪ ಸರ್.
Petition number 1.
ಎಲ್ಲಪ್ಪನ ನೀವು ಪೆಟಿಷನರ್ ಇದ್ರಲ್ಲಿ?
ಹಾ ಇದ್ರಲ್ಲಿ.
ನಿಮ್ಮ ಹೆಸರೇನು?
ಅವಿನಾಶ್ ಸರ್. ಅಪ್ಪಯ್ಯ ಅವರ ಮಗ ಸರ್.
Itu Appaya. Will be two petitioners.
ಅಪ್ಪಯ್ಯ ಅವ್ರ ಮಗನ ನೀವು?
ಹೌದು ಸರ್.
ನಿಮ್ ತಂದೆ ಇದಾರಲ್ಲ?
ಇದಾರೆ ಸರ್.
The son of the second, Shri Avinash, son of the second petitioner is before this court in person. He submits that his counsel ಏನಂತ ಹೇಳಿದಾರೆ? ಬರಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ.
ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಸರ್ ಅವರು. ನಾನು ಬೇರೆ ಲಾಯರ್ ನೋಡಿ.
That he submits that his counsel has informed him that they would not be appearing in the matter. He further submits that petition number 1 has also expired. ಅವ್ರ ಯಾರಿದ್ದಾರೆ ಅವ್ರ ವಾರಸ್ದಾರ?
ಮಕ್ಕಳಿದ್ದಾರೆ ಸರ್. ನಮ್ ದೊಡ್ಡಪ್ಪ ಮಕ್ಕಳಿದ್ದಾರೆ.
He seeks for filed
Santosh Kumar.
Now 17.
compliance. He submits that you'd be engaging a new advocate in the matter given 2 weeks' time. Relist on 21st June 2024 in the category, in the stage at which the above petition is. 21ನೇ ತಾರೀಕು ಬರಬೇಕು ನಿಮ್ ಕೌನ್ಸಿಲ್.
Serial number 30. Badri-Vishal.
For the petitioner. Purchasers writ petition. Records may be required, my lords. There are multiple.
Who is for respond? Mr. Papegoda is appearing.
In 2023, my lords, there was NOC filed.
Where are they? Records are required.
May be required because, my lords, one of the main contention.
Yes or no, maybe illa illi. Yes, madam, records.
My lord, records is I'll secure my lord.
2012.
Already we have received, my lord. We received records, my lord, but yeah, I have to open it and see, my lord, whether original records are there or proceed.
Learned counsel for the petitioner submits that records are required. Learned AGA submits that
Records, I'll secure the records from, original records from Taluk office.
she given 10 days time, she will secure the original records.
Please, ma'am.
She is directed to secure the entire records.
Please.
Relist on 21/6/24. If records are not secured by then, the deputy commissioner and the assistant commissioner
Please,
will be
ma'am.
personally present before this court.
Oblige.
None appears for the respondent. If none were to appear for the respondent on next date of hearing, the matter would be taken up for consideration. None appear for the private respondents. Will be taken up for consideration.
Great.
31. KG Sadashivaya.
Lords, in this matter, my lords were
For
pleased to
respondent.
direct the state to secure records, my lord.
ಬಂದಿದೆಯಮ್ಮ? Not required.
Not yet, my lord. I have to secure.
ಬೇಕಾ ಬೇಡವಾ?
My lords, our contention is, my lord, the grant is made on a ground of grow more food scheme, my lords. As such, that has to be looked into.
ಯಾವಾಗ ಬರುತ್ತೆ? 2012.
My lord, kindly 2 weeks' time, my lord.
And AGA seeks for 2 more weeks' time.
No prior permission, my lord, is taken. That is the ground.
No, to secure records. Earlier orders of 4712 and 8320.
My lord, we have secured the records, my lord, all these matters, my lord, but I need to recheck, my lord, is there any original grant records, my lord? It is a free grant or a grow more food grant, my lord?
Seeks for 2 weeks' time to secure all the original records. Relist on 21st June. Considering that the matter is of the year 2012, if records are not secured by then, both the deputy commissioner and the assistant commissioner
Oblige.
shall be personally present before this court.
32. KC Shanmukha.
I appear for petition in this case.
So Prakash?
My lord, I am here, my lord.
Yes. Ready?
I am ready.
This is grant is writ petition, my lord. Lord, the land was granted to the Chandrappa, my lord, father of the petitioner. On 26/11/1963, in survey number 26, my lord, his total extent is 6 acres of Mangenalli village. This
Grant dated 1961.
26/11/1963, my lord.
Sagwali Chetto.
Sagwali.
Was granted in 60/61. Sagwali Chet was issued in 63.
63.
Hmm.
1910-1964, my lord, Chandrappa sold 3 acres to Lakkamma.
1964.
1910-1964. Petitioner's father Chandrappa sold 3 acres to Lakkamma and 3 acres to Duggamma on the same day.
ಎಷ್ಟು acre grant ಆಗಿದ್ದು?
6 acres, my lord.
666.
Same date to
Same date.
Lakkamma and Durgamma, na?
Lakkamma and Duggamma. He said Lakkamma, my lord, sold 3 acres to Martandappa fourth respondent hearing, my lord. On 1/2/1995. 1/2/1995.
Yes.
The grantee Chandrappa filed application, my lord, on 99/2000.
Chandrappa filed on
99, in the year 99/2000.
date illa.
Date
99/2000.
2000. And it is ordered on 27/12/2000 and directed to restore the land in favor of the grantee, my lord.
27/12/2000.
27/12/2000. Assistant Commissioner directed to restore the land to the original grantee. Against that, my lord, the respondents have filed an appeal before the DC. Marthandappa and Duggama, my lord. Both have filed an appeal before the DC. Deputy Commissioner dismissed the appeal on 18/6/2001. As per the order of the Assistant Commissioner and the Deputy Commissioner, my lord, the Kata and RTC changed in the name of the grantee in the year 2001. Void MR 7 of 2000/2001. RTC also shows, my lord, the name of the grantee, my lord. And restored to the grantee, my lord. And Chandrappa and his family members are in possession of the land from 2001 onwards, my lord. The respondent number 4 and 5, my lord, filed writ petition before this honorable court. In writ petition number
27045-46 of 2001.
2001.
Yes.
Telling the Deputy Commissioner's order of confirmation.
AC and DC order was set aside and remanded back to the second respondent for fresh consideration. Again, the Assistant Commissioner, after verifying the documents, my lord, allowed the appeal filed by the grantee as per Annexure C, my lord, on 2/4/2008 and directed to restore the land, my lord. That is challenged by the respondents before the Deputy Commissioner, my lord. And the Deputy Commissioner, on the ground that, my lord, the respondents are in possession of the land since from last 49 years. Hence, he allowed the appeal and set aside the order passed by the Assistant Commissioner, my lord.
64 was the sale.
64, within 1 year, he sold, my lord. He violated.
Here or whatever he sold.
My lord.
The he only filed the application in 1999.
99, my lord.
Not you as legal representative.
Yes.
Chandrappa sold in 64, received the money. He filed the resumption application in the year 1999. For 34 years, what is the 35 years? What is the reason given?
Reason was not explained, madam. But as per the new amendment, my lord, from 2023, the delay, my lord.
Any amendment can only be prospective, not retrospective. Can any amendment be retrospective?
Prospective, retrospective ani helilla.
Amendment ಯಾವ್ದಾದ್ರು retrospective ಆಗಕ್ಕಾಗತ್ತಾ? Can only be prospective. 35 years delay ಏನಾದ್ರು reason ಕೊಟ್ಟಿದ್ದೀರಾ ಹೇಳಿ?
Delay was not stated anywhere, my lord.
That is right.
As per the amendment, as per the Amendment Act, my lord, it should be saved, my lord. Section 5 class C and D, my lord, is inserted.
To hear you on prospective or retrospective, whether the amendment is prospective or retrospective.
My lord, retrospective, my lord. It is stated, please, my lord, has it.
Can an amendment be retrospective?
My lord, but, and here, my lord,
Prakash,
in
ಅದೇ
the present case,
ಮುಂಚೆ
my lord, act came
Yeah.
into their rescue, my lord, only in the year 1979, my lord. 79. 89, my lord, we have to take a delay of 10 years, my lord. It is not prior to act, my lord, that is only 4-1. Is,
64, he sold it.
please, my lord, act,
Year
from the act, my lord, from the act,
Date of the act,
date of the act, my lord,
10 years.
please, my lord.
10 years delay, explanation illa.
May I make one submission?
Yes.
That may not be necessary. That aspect, my lord, may not be necessary. That issue may not be, my lord, necessary for disposal of this
class
information.
C and D was inserted. Section 5,
Madam,
C and D was
Madam, will
inserted.
come.
What according to you is necessary, Mr. Prakash?
My lord, what happened is, my lord, this is the second application. The order is made on the second time. My lord, my learned friend, my lord, with respect, my lord, he has not made a proper submission, my lord. Your lordship kindly appreciate. I have filed, my lord, counter to the in this petition. My lord, I don't dispute with the argument of my learned friend regarding date of grant, extent of land, survey number, village, and etc. My lord, it is true that, my lord, the land was granted, 6 acres of land was granted in survey number 26/14, my lord, on 23/8/1963. My lord, it was sold on 19/10/1964. My lord, in favor of Lakshmamma and my lord, Duggamma. My lord, this Chandrappa, my lord, he is, my lord, father of the petitioner before your lordship, my lord. He filed a petition seeking a declaration to declare the sale as null and void and to restore the possession. My lord, in number RRCKK 690/7980, he moved the application soon after commencement of the act before Assistant Commissioner. My lord, saying that this is, my lord, contrary to terms of the grant. My lord, I request my lord to take my counter, page 15, my lord, page R2, my lord, page 20. No, page 20, my lord. Typed copy is page 20. My lord, this application was rejected by the Assistant Commissioner. R2, that is on 16/10/1982. 1980 typed copy, my lord, it is shown as 92 is wrong. This copy is available, my lord, photocopy available at page 18. 16/10.
For the cash does not come under the scheduled caste.
Yeah, Meena, my lord, according to them, Meena and Aika community. But whatever reason, my lord, my submission is, my lord, it is held by this court. My lord, the res judicata as embodied under section 11 of CPC is applicable once application is rejected for any ground. When that was not challenged by the original grantee, there is no question of, my lord, again re-agitating the matter by filing another application.
That order was not challenged by the grantee.
No, not challenged. It was not challenged. But but what happened is, my lord, this after sale of land in 1964, my lord, the special deputy commissioner submitted a report to the divisional commissioner because under the rules he is the proper party for cancellation of grant. My lord, annexure R1, your lordship kindly see, annexure R1, page 15. Divisional commissioner, who is a proper authority to cancel the grant on the ground of, my lord, violation of terms of the grant. My lord, he passed an order on 7th September 1984. My lord, the order copy is available at page 15, annexure R1. My lord, in that, my lord, page 17, your lordship kindly see the order of the regional commissioner, now regional commissioner, then divisional commissioner. My lord, may I read? my lord, page 15, 1-5, annexure R1.
Yes, yes.
My lord, let your lordship kindly see, this is Sri Chandrappa, the father of the present petitioner, and Lakkamma is the purchaser, and Durgamma another purchaser. These proceedings were initiated in the year 83-84 for cancellation of a grant on the ground that the terms of that non-alienation condition was violated. Then, my lord, para 5 at page 17, I have perused the records. The Assistant Commissioner Shumaga Subdi in his report so has granted 6 acres of land of Manganhalli village in favor of Chandrappa, subject to non-alienation condition. The grantee has credited the upset and obtained Sagoli Chitti on 6/1/64 with condition that the land should not be alienated for a period of 15 years. The perusal of the records revealed that respondent number 1, Sri Chandrappa, sold the land to respondent 2 and 3, Srimati Lakkamma and Srimati Durgamma, while registered sale date dated 19/10/64. There is no doubt that the land was granted to respondent number 1, subject to condition that he should not alienate for a period of 15 years. In the instant case, the land was sold within 1 year from the date of grant. Hence, respondent 2 and 3 are in possession of the land for the last 20 years. At this stage, it would be clearly unjust to cancel the land granted to respondent number 1 and resume the same to the government. So this was dropped, holding that the purchasers are in possession for a period of 20 years. It was unjust to see that they are evicted and land is resumed. Before this, my lord, annexure R2 order was passed by the Assistant Commissioner on the application made by the father of the present petitioner. This is page 18. I have already, my lord, brought to my lord's kind notice.
Yes.
My lord, survey 26. This order is achieved finality. Annexure R2 order, my lord, achieved finality because the grantee or the petitioner hearing challenge this order. So, my lord, my lord, my colleague is there, my lord, he furnished the judgment. My lord, ILR 2006 Karnataka, page 174. My lord, in this case, my lord, my colleague, my lord, ILR 2006 Karnataka, page 174.
What is judgment?
My lord, first judgment is ILR 2006 Karnataka, page 174. My lord, the similar my lord, case where, my lord, this court, my lord, considered the question whether another application is, my lord, entertainable. My lord, that is what, my lord,
Para?
one, my lord, my lord, page 27, page 20, para 27, my lord. This is an unusual situation where an order passed by the Assistant Commissioner, which was one being made, subject matter of an appeal under Section 5A of the Act.
ILR 2006 Karnataka, 2006 Karnataka 174.
Oh, yes, ma'am. 174.
Para 27 is I have examined the matter in great
Yes,
detail.
yes. There, my lord, what happened in that case, my lord, the Assistant Commissioner, which was one being made subject matter of an appeal under Section 5 of the Act, and on disposal of the appeal on weights, and had become concluded, is again sought to be made subject matter of another appeal. Lord, once appeal was preferred and that appeal was disposed of against the person who lost the matter before Assistant Commissioner. He prefers another appeal before the Deputy Commissioner. Lord, that is 7 years after the appellate order. Then this court, the Lordship said, it is not permissible. Once order, my lord, achieves finality, there is no question of preferring another appeal. So that relying on this, my lord, another, my lord, single judge of this honorable court, my lord, another judgment, my lord, following this, there also, my lord, similar thing happened. Well, another is, my lord, the state of Mariappa versus state of Karnataka. Para 2. By the said order, the Deputy Commissioner has reversed the order passed by the Assistant Commissioner Bangalore, North Subdivision, Bangalore, and has held that the alienation of 3 acres of land comprised in survey number 50, situated at BK Palya village, Jalaha Obli, Bangalore North Taluk, was in violation of provisions of the Act and was therefore null and void. The Deputy Commissioner ordered for resumption of the land to the government and restoration of the same fair of the original grantee. The petitioner before this court is the purchaser of the land as per history salary dated so and so, so and so. It is unnecessary to go into the other details of the fact involved in this case, inasmuch as this matter deserves to be disposed of only on the short point that the very dispute regarding the resumption and restoration of the land was on contest disposed of by the previous order passed by the Assistant Commissioner and Deputy Commissioner, which have attained finality, and despite the said order, fresh proceedings are sought to be initiated by another legal representative of the grantee, which is apparently impermissible. To this extent, the facts necessary are required to be stated. Para 5. Learned counsel for the petitioner brings to the notice of this court a decision of this court in the case of the Hanumantayya versus State of Karnataka by its Revenue Secretary and others, ILR 2006 Karnataka 174, to contend that it is not open for the Deputy Commissioner to entertain an appeal against the very order passed under the very jurisdiction by his predecessor earlier. He is right and justified in contending that if the authorities are allowed to reconsider the order earlier passed, which have attained finality, then the litigants will be pushed into uncertainty forever and will never be in a position to know what actually would happen to their cases, because at any time the orders passed earlier can be reopened by initiating fresh proceedings at the instance of the same person or persons claiming through or under them. Hence, the impugned order, being patently illegal, deserves to be set aside. So, therefore, my lord, my submission is, once Chandrappa made an application before the Assistant Commissioner invoking, my lord, the provisions of the Act and has failed, whatever may be, my lord, the void order, your lordship is aware, even the void orders, my lord, binds the parties inter vivos, unless it is challenged, my lord, before the competent forum. Therefore, my submission is, firstly, my lord, that the cost is not declared as the scheduled cost, either on the date of the grant or on the date when Act come into force. Act, your lordship well aware, is come into force from 1179. Land was granted, my lord, in the year 1963, and Sagoli Chit was issued in 64. In these 3 dates, my lord, this Meena Naika community is not declared as scheduled part, is one submission. Of course, my lord, the second submission is, my lord, this of, my lord, rejecting the application of father of the petitioner having been achieved finality, but it is not open to the petitioner to re-agitate the matter once over again, but either soya moto or on the application made by him. Therefore, my submission is the learned Deputy Commissioner has not committed any wrong in my lord, allowing the appeal.
Are these submissions considered by the Assistant Commissioner? Or
No, he did not consider. My lord, the Deputy Commissioner.
So this is a new argument you are advancing.
Yes.
Commissioner or the Deputy Commissioner. But even otherwise, my lord, these are legal submissions. My lord, it can be agitated.
Now the question is, what did the Deputy Commissioner say in his order, which is right or wrong?
Deputy Commissioner.
Always address argument, but we'll have to consider Annexure D on its own merits. Idರಲ್ಲಿ ಏನ್ ground ಹೇಳಿದ್ದಾರೆ?
Para number 22, my lord. Page number 22, para number 15. ಈ ತಹಲ್ವರೆಗೂ ಖರೀದಿದಾರರಾದ ವಾದಿಗಳು ವ್ಯಾಜ್ಯದ ಜಮೀನಿನಲ್ಲಿ ಸುಮಾರು 49 ವರ್ಷಗಳ ಸುದೀರ್ಘಾವಧಿ ಪ್ರತಿಕೂಲ ಸ್ವಾಧೀನಾನುಭವ ಹೊಂದಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಪ್ರತಿ ವಾದಿ ಮತ್ತು ಅವರ ವಾರಸುದಾರರಿಗೆ ಈ ಪ್ರಾಧಿಕಾರದಿಂದ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿದ್ದು 1 ಮತ್ತು 2ನೇ ಪ್ರತಿವಾದಿಗಳು ಪರವಾಗಿ ದಿನಾಂಕ 1/12/2008 ವಕೀಲರು ವಕಾಲತ್ತು ವಹಿಸಿರುತ್ತಾರೆ ಅಷ್ಟೇ. ಆದರೆ ದಿನಾಂಕ 18/2/2013 ಸಾಕಷ್ಟು ಕಾಲಾವಕಾಶ ನೀಡಿದಾಗಿಯೂ ಸತತ ಗೈರು ಹಾಜರಿರುವುದು ಅರಿವು ಬಂದಿರುವುದು ವ್ಯಕ್ತವಾಗುತ್ತದೆ. ಮಾನ್ಯ ವಿಭಾಗಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರವರು 17/9/1984 ಆದೇಶವನ್ನು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಪ್ರಶ್ನಿಸದೇ ಇರುವುದರಿಂದ ಮತ್ತು ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಿವಿಲ್ ಅಪೀಲ್ ನಂಬರ್ ನಿಂಗಪ್ಪ ವಿರುದ್ಧ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮತ್ತು ಇತರರ ಪ್ರಕರಣದಲ್ಲಿ ನೀಡಿದ ತೀರ್ಪಿನಂತೆ ಸಾಕಷ್ಟು ಕಾಲ ವಿಳಂಬವಾಗಿ ಮಂಜೂರುದಾರ ಅಥವಾ ಅವರ ಕುಟುಂಬದವರು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯು ಕಾನೂನುಬದ್ಧವಾಗಿರುವುದಿಲ್ಲ ಎಂದು ಉಲ್ಲೇಖಿಸಿ ತೀರ್ಮಾನಿಸಿರುವ ತೀರ್ಪು ಈ ಪ್ರಕರಣಕ್ಕೆ ಸ್ಪಷ್ಟವಾಗಿ ಅನ್ವಯಿಸುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಅವಲೋಕಿಸಿ ವಿಭಾಗಾಧಿಕಾರಿಗಳು ದಾವಣಗೆರೆ ಇವರು ಮಾಡಿರುವ ಆದೇಶದಲ್ಲಿ ಯಾವುದೇ ಉರುಳಿಲ್ಲ ಎಂದು ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿ ಆದೇಶಿಸಲು ಸೂಕ್ತವೆಂದು ತೀರ್ಮಾನಿಸಿಕೊಂಡು ಬಂದಿರ್ತದೆ.
My lord, your lordship kindly see page 19, my lord.
Had you
My lord,
raised
there
this
is-
contention before the deputy commissioner, Mr. Prakash?
Yes, my lord, page 19, my lord, page 19, my lord, in the petition papers, page 19.
Yes.
Your lordship kindly see, ವಾದಿಗಳ ಮೇಲ್ಮನವಿ ಉಭಯ ಪಕ್ಷದವರು ಹಾಜರುಪಡಿಸಲು ಲಿಖಿತವಾದ ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಹಾಗೂ ಕೆಳ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಮತ್ತು ಕರ್ತವ್ಯವನ್ನು ಜೊತೆಗೆ ಮಂಜೂರಾತಿ ಕೂಲಂಕುಷವಾಗಿ ಅವಲೋಕಿಸಿ ಅಂತ ಹೇಳಿ 1, 2, 3 ಅಂತ. Your lordship kindly see, 3 ಅದರಲ್ಲಿ 3 ಮೂಲ ಮಂಜೂರಾತಿದಾರರು ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಶಿವಮೊಗ್ಗ ಇವರಲ್ಲಿ PTCL ಕಾಯ್ದೆಯಡಿ ಜಮೀನು ಬಿಡಿಸಿಕೊಳ್ಳಲು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯ ಬಗ್ಗೆ ಸಂಬಂಧಿಸಿದ ನೋಟಿಸ್ ನೀಡಿ ವಿಚಾರಣೆ ಜರುಗಿಸಿ ಮಂಜೂರುದಾರರು ಮ್ಯಾಸನಾಯ್ಕ ಜಾತಿಗೆ ಸೇರಿದ್ದು ಈ ಜಾತಿ ಪಟ್ಟಿ ಸೇರಿಲ್ಲವಾದ್ದರಿಂದ ಕ್ರಯವಾರು PTCL ಕಾಯ್ದೆ ಒಳಗೆ ತಿಳಿಸಿ ಮೂಲ ಮಂಜೂದಾರ ಅರ್ಜಿಯನ್ನು ಪ್ರಕರಣ 16/10/82 ವಜಾ ಮಾಡಿ ಆದೇಶಿಸಿದ. I have brought to the notice of the deputy commissioner.
So you're taken.
He
as
has considered. He has considered it, but of course it is not find a place, my lord, in the reasonings he has, my lord, said. But I have brought to the notice of the deputy commissioner. The
So
order
not
passed
a
by the,
new argument. Yes,
yes, my lord, yes.
really. What do you have to say about these submissions?
My lord, after remand, my lord, these contentions was not raised by the respondents, my lord, before the assistant commissioner.
Then the order.
Before the DC says, my lord.
Whenever it is raised, we'll have to consider. So what do you have to say about these submissions? Is the order correct or wrong? The validity of the order alla kelta iradu. Order ಆಗಿದೆಯೋ ಇಲ್ವೋ?
That order is passed, my lord, in earlier.
Order pass ಮಾಡಿದ್ರೆ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
That is not challenge, my lord.
How can you maintain it? There won't be any end as observed by the coordinate bench. You have filed it and it's not even allantu inna worst. Legal errors ಆದ್ರೇನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಇಲ್ಲಿ ನಿಮ್ದು ಅಲ್ಲಿ ಇನ್ನ ಬೆಟರ್, ಇಲ್ಲಿ ನಿಮ್ದು ಇನ್ನ worst. You yourself are filing the second application.
ಇದರಲ್ಲಿ earlier read proceedings ಅಲ್ಲೂ ಇದನ್ನೇನು ಎಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡೋದಿಲ್ಲ.
If it is a fact that your earlier application has been dismissed and the divisional commissioner has also dismissed
On the ground that, my lord, he is in possession of the land since from last 19-20 years.
49 years. Which?
No, in earlier case, my lord, he is in possession of 20 years. Because of that, my lord, the
ಅದು
division
challenge
commission-
ಮಾಡಿಲ್ಲ ನೀವು.
That is not challenge, my lord.
Both of them you are not challenged. So it has attained finality. How can you reopen things?
Against the R2, my lord, R1 challenge before the divisional commissioner. That order was not challenged, my lord.
That order, initial order, you have suppressed actually. You have not brought it a notice anywhere. Only the respondents have brought it to notice. You did not inform that you had earlier filed, this is an order passed. Helilla, suppression alva.
I will verify, my lord, that one.
Verify.
I will verify.
ಇಲ್ಲಪ್ಪ ಅಲ್ಲಿ ವೆರಿಫೈ ಏನು ಅದಕ್ಕೋಸ್ಕರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಡ.
ನಾವು ಪಾರ್ಟಿ ಕೇಳಬೇಕು.
If it is required, as we would have granted it. You
I
suppressed.
filed counter in 2015.
You
I filed counter in 2015.
I will.
Third. Record that. Petitioner is before this court seeking for the following leaves. The petitioner is the son of one Chandrappa. And the original petitioner is the son of one Chandrappa. The original petitioner also having expired, his legal representatives have been brought on record. The submission of the contention of the original petitioner was that 6 acres of dry land in survey number 26 of Managenalli, Chengiri Taluk, Davangere district was granted in favor of his father Chandrappa, wide order bearing number 261/60-61, Darkast, /30/60-61. And the Sagwadi check was issued on 26/11/2063 with a condition 26/11/1963 with the condition that the land shall not be alienated for a period of 15 years. However, the said Chandrappa sold 3 acres of land in favor of Dugamma, that is respondent number 5 herein, and another 3 acres of land in favor of Lakamma on 19/10/64, thus alienating the entire property granted to him. The grantee Chandrappa had filed an application for setting aside the sales and for resumption of land before the Assistant Commissioner Davangere in PTCL/CNC/3/99/200, which was allowed by the said Assistant Commissioner by order dated 27/12/2000, setting aside the sales executed by Chandrappa and ordering for resumption of land. In the meanwhile, Lakamma had sold her 3 acres in favor of one Marthandappa, who is the 4th respondent herein. The said order of the Assistant Commissioner was challenged by Marthandappa and Dugamma before the Deputy Commissioner in PTCL/CR/12/2000-01, which came to be dismissed, confirming the order of the Assistant Commissioner. Pursuant thereto, the revenue records were changed in the name of Chandrappa. The said Marthandappa and Dugamma had filed a writ petition in WP number 27045-46 of 2001, which challenging the order of the Deputy Commissioner and the Assistant Commissioner, which came to be allowed by this court by the order dated 29/8/2003. Washing the said orders, this court remitted the matter to the Assistant Commissioner with a direction to dispose the same in accordance with law within 6 months. In pursuance thereof, the Assistant Commissioner in PTCL/CR/5/2006-7 dated 2/4/2008 once again held that there is a violation of the conditional grant, as such the land which is sold within the stipulated time, the sale which has occurred of the land within the stipulated period of time was not proper and ordered for resumption of land. This order came to be challenged by Marthandappa and Dugamma before the Deputy Commissioner. The Deputy Commissioner, while order dated 15/7/2013, set aside the order of the Assistant Commissioner on several grounds, one of them being that the purchasers were in possession of the land for last more than 49 years. And as such, their possession and right thereto cannot be disturbed. It is challenged the same, the petitioner is before this court. The counsel for the petitioner submits that there being a violation of the stipulation of 15, stipulation barring sale of land for a period of 15 years. The grant having been made in the year, Sagoli Chet having been issued in the year 1963, the sale having been executed on 19/10/1964. The Assistant Commissioner had rightly allowed the application filed by Chandrappa, the father of the petitioner, and the same ought not to have been disturbed by the Deputy Commissioner. His other submission is that the petitioner ಇನ್ನೇನ್ ಅದೇ ಅದೊಂದೇ submission ಅಲ್ಲ. What is wrong with that order? Only one submission. Anything else?
No.
Learned counsel for respond number.
4 and 5.
ನೀವು ಯಾರಿಗೆ appear ಆಗ್ತೀರಾ Mr. Prakash?
4 and 5.
4 and 5. Learned counsel for Marthandappa, respond number 4. And the legal representatives of Dugamma, respond number 5, A to C and E to G, submits that once earlier, even prior to the proceedings which are challenged before this court, once earlier, the said Chandrappa had filed a proceeding before the Assistant Commissioner Shumaga in proceedings bearing number 159/499/79/80, which came to be disposed by the Assistant Commissioner by order date 16/10/1992, produced at annexure R2 to the statement of objection filed by respondent number 4 and 5. When the Assistant Commissioner came to a conclusion that Chandrappa was not belonging to scheduled caste or scheduled tribe, and as such was not eligible for restoration of land under the provision of the Karnataka scheduled caste / scheduled tribes, bracket prohibition of transfer of certain land, bracket close, Act 1978. His further submission in so far as the alienation within the period of the bar / prohibition is that the proceedings have been initiated under Rule 43-G of the Karnataka Land Revenue bracket Amendment Rules 1960 on the basis of the report of the Special Deputy Commissioner Shumaga dated 2/4/83, which was in turn based on the report of the Assistant Commissioner Shumaga Subdivision 2/4/1983. The Division Commissioner has come to a categorical conclusion that even though the sale was executed within the period of prohibition, the sale ought not to be disturbed with, since the purchasers were in possession of the land for last 20 years. The submission of Shri S.V. Prakash Laran counsel for respond number 4 and 5 by relying on the above two orders is that firstly, an earlier application filed by the grantee Chandrappa had been dismissed, which has not been challenged and as such has attained finality, and no second application could have been filed thereafter.
Well, it is similar issue, my lord. Second petition is not made. Division bench of dishonorable court dealt the matter. My lord, I just sit, my lord, I am heard, my lord. The division bench of dishonorable court, similar issue, para 10 and 11. Please.
ಆಮೇಲೆ ಅವರು ನಾನು ಎಷ್ಟು ಜನ ಅಪೋಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಆಫೀಸರ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಎಸ್ ಅಮೈಕಸ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಪೆಟಿಷನರ್ ಫಾರ್ ಗ್ರಾಂಟಿಗೆ. Yes. Having been dismissed, the same having attained finality, a fresh application could not have been filed in the year 1999-2000. Secondly, he contends that even though the sale may be within the period of prohibition, the Divisional Commissioner
having held that the sale cannot be disturbed, the same cannot be a ground which could be contended by Chandrappa and now is legal heir before this court. For both the above, he further relies upon the decision of a coordinate bench of this court reported in ILR 2006 Karnataka 174, more particularly para 27 thereof. By relying on Hanumantaya's case, his submission is that the earlier order passed by the Assistant Commissioner would amount to res judicata and no fresh application could be filed. He also relies upon the decision of another coordinate bench of this court in WP number 37765 of 2012 dated 5/12/2013, more particularly para 2 and 5 thereof, which are reproduced hereunder for easy reference. By relying on the above, he submits that once the earlier application had been dismissed, the question of a fresh application being filed would not arise. The authorities concerned ought not to have considered the second application. By considering the same, there would be uncertainty for the litigants, knowing not how many times it could be challenged. He further relies upon the decision of the division bench of this court in ILR 2020 Karnataka 303, more particularly para 10 and 11 thereof, which are reproduced hereunder for easy reference. By relying on the above, he submits that the second application is barred by the principle of estoppel and acquiescence. Heard so-and-so peruse paper. The short question that arises for consideration of this court is one, whether a grantee of the land having filed an application for resumption under section 5 of the Karnataka Schedule Caste so-and-so Prohibition Act, the same having been rejected, can file another application for such resumption? Question mark. In the present case, the facts are not in dispute. The sale having occurred on 19/10/1964, the SC/ST so-and-so Act having come into force on
1/1/1979.
date another
1/1/1979.
1/1/1979. The grantee Chandrappa had filed a proceeding before the Assistant Commissioner in number 159/499/7980. The original grantee himself having challenged the proceedings, challenged the sale and sought for resumption, the said application came to be dismissed by the Assistant Commissioner on 16/10/1992. There being no dispute as regard the said order having been passed, there is also no dispute that the said order has not been challenged by Chandrappa. The said order dated 16/10/1992 of the Assistant Commissioner, therefore, has attained finality. It is subsequently in the year 2000 that the very same grantee Chandrappa filed a fresh application which came to be registered as PTSCL/CNC/3/99/2000 before the Assistant Commissioner, again seeking for setting aside the sale deed and for resumption of the land. In the said proceedings, the details of the earlier order of the Assistant Commissioner dated
1992 were not mentioned. Therefore, I am the considered opinion that such non-mentioning would amount to suppression of relevant facts. It is in that background that the said proceedings were considered. Assistant Commissioner allowed the application, appeal filed before the Deputy Commissioner came to be rejected. In a writ petition filed before this court remanded the matter for fresh consideration before the Assistant Commissioner. The Assistant Commissioner again on 2/4/2008 in PTCL/CR 5/2006-7 allowed the application, which on appeal came to be reversed by the Deputy Commissioner. The entire proceedings from the year 99-2000, to my considered opinion, are non-est, inasmuch as an earlier application having been filed by the very same grantee before the Assistant Commissioner had been rejected. Once an earlier application was rejected, the only option which was available for the grantee was to challenge the same in an appropriate forum to its logical conclusion. Not having challenged the said order, to my considered opinion, would amount to an estoppel, acquiescence, and abandonment of the claim on part of such grantee, depriving him of any further right to file a fresh application for cancellation of the sale deed and resumption of land, as done in the present case in the year 99-2000. This aspect has been considered by division bench of this court in ILR 2020 Karnataka 303, though in that matter, a challenge was made to the order of the Assistant Commissioner before the Deputy Commissioner, and the appeal was withdrawn by the grantee. And in such circumstances, the division bench of this court came to a conclusion that the same would amount to acquiescence and abandonment. In the present case, the present case is worse than that, inasmuch as the order passed by the Assistant Commissioner has never been challenged. Hence, I answer the above point, the point number 1, by holding that once an application filed by a grantee under Section 5 of the Karnataka So-and-so Act is rejected, no fresh application can be filed by such a grantee and/or the legal heirs claiming under such grantee. Question number 2, Antaki. Whether once proceedings initiated by the Special Deputy Commissioner for violation of the period of grant has been dismissed, could the contention that the sale has occurred during the prohibition period be raised in a proceedings filed under Section 5 of the Karnataka So-and-so? In the present case, on the basis of a report of the Special Deputy Commissioner, Shivamogga, dated 2/4/1983, proceedings were initiated by the before the Divisional Commissioner, Bangalore, for resumption of land on account of violation of the period of prohibition of grant made, the said period being 15 years. The Divisional Commissioner, via its detailed order dated 7 September 1984, having considered the same, has come to a conclusion that though the land was granted subject to the condition that the same would not be alienated for a period of 15 years, and that the land was alienated within 1 year from the date of grant, considering that the alienees, respond number 2 and 3 therein, were in possession of the land for the last 20 years, it was clearly unjust to cancel the land granted to the grantee and resume the same to the government. This finding of the Divisional Commissioner, having considered all the issues, and a reasoned order having been passed by the Divisional Commissioner that despite
the transfer having occurred within the prohibited period ought not to be disturbed, would create an embargo for the petitioner now to challenge the alienation on the ground, alienation made by himself on the ground that he had alienated it within the period of prohibition. Thus, I answer point number 2, that once the authorities were to come to a conclusion that the period, that the alienation though made within the period of prohibition ought not to be disturbed, the same cannot be raised once again. Correct. In view of my answer to point number 1 and 2 above, there are no grounds which have been made out in the present petition. The present petition stands dismissed. Revenue entries, if any, made in favor of the petitioner and or the legal representatives are directed to be cancelled and fresh entries to be made in favor of respondent number 4 and the legal representatives of respondent number 5 within a period of 21 days of the filing of the receipt of a copy of this order. General directions. The above petition has arisen and has taken the time of the Assistant Commissioner, Deputy Commissioner, and this court on 2 occasions, for the simple reason that the earlier order passed by the Assistant Commissioner was not, by the then Assistant Commissioner, was not available for the subsequent Assistant Commissioner to be considered in respect of the said land, very same land. The first order was passed when there was no computerization in the administration. But today, there being computerization and all the records being required to be digitized, it would but be required for the Principal Secretary Revenue Department to put in place a system where any orders passed in respect of any survey number are available not only for the officers of the department, but also for the general public, so that they are made aware of any orders passed earlier, obviating the need of further litigation. Hence, the Principal Secretary Revenue Department is directed to implement a system in relation to the above with assistance of the Principal Secretary E-Governance Department, if and so required. A detailed project report to be placed on the record, placed before this court for consideration within 4 weeks from today, relist on 4 weeks from today. Hence, I pass the above order. The above petition is dismissed. Though the above petition is dismissed, relist on 23rd July at 2:30 PM for consideration of the report filed by the Principal Secretary.
Grateful.
AGA is directed to inform, AGA is directed to inform the Principal Secretary Revenue Department of the above order.
Please.
Serial number 33, SN Bhatt.
Despite the order date 31/5/24, none appears for the petitioner today also. The peril of the order sheet indicates that none has been appearing for the petitioner on several dates of hearing. It appears that the petitioner is not interested in prosecuting the above matter. The petition stands dismissed for non-prosecution.
34, Raghavendra K.
ಯಾಕಪ್ಪ ಬರ್ತಾ ಇಲ್ಲ?
ಇದರಲ್ಲಿ ಅವ್ರು NOC ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ. ನಾನು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಒಂದು 2 weeks ಟೈಮ್.
ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ NOC?
ನಮ್ಮ ಪಾರ್ಟಿ ಕೊಟ್ಟಿದ್ದು, ಪಿಟಿಷನರಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ನನಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರು ತಗೊಂಬಂದು 2 weeks ಟೈಮ್.
ಯಾರಿಗೆ? ರಾಘವೇಂದ್ರ ಅವ್ರಿಗೆ? ಯಾರಿಗೆ?
ಪಿಟಿಷನರಿ ರಾಘವೇಂದ್ರ ಅವರು NOC
ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
ನೆಕ್ಸ್ಟ್.
ನಿಮ್ಮ ಹೆಸರೇನು?
ನಾಗರಾಜ್.
ಬರ್ತ್ಕೊಡಿ. He so and so submit that you would be appearing for the petitioner by filing the NOC Wakalatnama. Relist on 21/6. ಏನಕ್ಕಿದೆ ಇದು?
Finally.
For final hearing.
Serial number 35. P.R. Srinivasa Gowda.
My lord, for the petitioner, for 2 weeks adjournment, my lord, time senior.
ಯಾಕೆ?
My lord, my senior HR Ananta Krishnamurthy has been engaged as arguing counsel. ಅದಕ್ಕೋಸ್ಕರ my lord, he has sought for some time.
ಇಲ್ಲ, date fixed ಆಗೈತೆ. That counsel for the petition seeks for and is granted 2 weeks time finally to get ready and address his arguments. Released on 21/6. It's made clear that no further adjournment will be granted. Yes.
Serial number 36. Rajana C.
Petitioner in this case.
You're for respond number 3.
Respond number 3 minutes.
Notice ಆಗಿಲ್ವಾ?
No minutes, I have entered KV 8 minutes.
ಎಷ್ಟು ಜನ ಇದೆ respondents?
Respondent number 4, 5 and 6, my lord, are according to me, my lord, the petition is not maintainable. For this reason, my lord, the applicant before the assistant commissioner is not the petitioner. These petitioners were the impleading applicants before the deputy commissioner, where I have filed an appeal. But the original applicant has not, my lord, challenged the order. But
What is their claim?
They claim that their grandfather was the grantee, and they did not start for, my lord, any prayer in the appeal also. Therefore, their petition, my lord, is not maintainable, my lord, is missing.
You're not the applicant.
Yes. Of course, he may not be aware, my lord, you will ask him.
Senior ಅಲ್ಲಿ
Senior is out of session.
ಯಾವಾಗ ಬರ್ತಾರೆ?
Rest time for 2 week hearing.
2 weeks ಆಗತ್ತಾ ಬರಕ್ ಅವರು? 2 weeks ವರೆಗೂ ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಅಪಿಯರ್ ಆಗಂಗಿಲ್ಲ. Then counsel for respond number 3 submits that the above petition is not maintainable since the petitioners were not the applicants before the assistant commissioner, but had only sought to implead themselves as
Respondents in the appeal, my lord.
as respondents
In the
before the deputy commissioner, as respondents in the appeal filed. The applicant not having challenged the orders passed by the deputy commissioner, his submission is that the petitioners who are impleading applicants cannot challenge the same. Faced with the above situation, learned counsel for the petitioner seeks for and is granted 2 weeks time to get ready and make his submission. Released on 21/6.
37. Rasanna VR.
Petitioner's notes.
Who are you?
But,
Grantina,
but it is
purchaser.
neither a neither a grantee nor a purchaser. my
Very
lords.
good.
Lord, the father of the private respondent, my lords, filed a petition before the assistant commissioner saying that, my lord, the petitioner, my lords, producer of the petitioner has encroached the property. Once the property is encroached, Lord, the PTCL Act, my lord, has no application. That is the judgment of the honorable court. The assistant commissioner, my lords, issued a notice in which, my lord, the petitioner, producer of the petitioner, my lord, has contended that, my lord, in addition to that, my lords, the original grantee has also issued an agreement conceding that we have been in possession since long. However, my lord, the assistant commissioner, disbelieving the said document, held that he is an encroacher and directed resumption of the land.
The PTCL Act.
Yes, then, my lords,
Learned AGA accepts notice for respond number 1 to 4. Issue notice to respond number 5, returnable by 22nd July. The operation of the order dated so-and-so, bearing so-and-so at Annexure A and Annexure B are stayed till the next date of hearing. Process fee and copies to be furnished by end of day 12th June 2024. Dealing with the interim order will stay and stand vacated. Both the petitioner and respond number 5. Petitioners and respond number 5 are prohibited from dealing in any manner dealing with the property subject matter of the above petition.
38. Gadapati.
I am for the petitioner. Petitioner is the grantee, my lord.
Grantee.
Yes, assistant commissioner allowed my application and deputy commissioner.
And AGA accepts notice for respond number 1 to 4. Issue notice to respond number 5, returnable by 22nd July. The interim order and ಕೇಳಿಲ್ಲ.
ಅದು ಖಾತಾ ಆಲ್ರೆಡಿ ಚೇಂಜ್ ಆಗಿದೆ. ಖಾತಾ ಆಲ್ರೆಡಿ ಚೇಂಜ್ ಇನ್ ಫೇವರ್ ಆಫ್
ಆಗೋಗಿದೆಯಾ?
and therefore
notes.
It may be subject to the,
Please.
please.
39. Pradeep R.
My lord, I represent LRs of the grantee, my lord.
Grantee.
Yes, my lord.
Records
The
beka. Records beka geta hai?
32.
Beka actually. And AG accepts notice for respond number 1 and 2, issue notice to respond number 3 to 5, returnable by 22nd July. Counsel for the petitioner is direct furnish 2 sets of the petition along with annexures on the counsel for on the learned AGA. Process fee and copies to be furnished by end of day 12 June, failing which the petition will stand dismissed.
40. HV Manjunatha.
In this case, I am for the grantee, my lord.
Issue notice to, learned AGA accepts notice to
1, 2, 3.
1 to 3. Issue notice to 4 to 7, returnable by 22nd July. Counsel for the petition furnish 2 sets of the petition along with annexures on the learned AGA.
41. HC Simresh.
Any dispensation ಏನದು?
A dispensation, annexures, yes, sealed deed, annexure B, and then orders, both orders, Assistant Commissioner and Deputy Commissioner's order.
Saying dispensation, you have to produce it. Learned counsel for the petitioner is granted 3 weeks' time.
Please.
To produce annexure, certified copies of annexure B, C, and D.
Please.
1 to 4, I repeat.
Learned AG accepts notice for respond number 1 to 4. Issue notice to respond number 5 to 7, returnable by so same order. By 12th, kodಬೇಕು process.
Please, I will furnish.
42.
Granting.
Granted. ಏನೆಲ್ಲ ಗ್ರಾಂಟಿನೇ ಇದೆ. AGA for 1 to 4. Issue notice to respond number 5. Same by 12th.
3 and 4. Notice to this 3 and 4.
3 and 4.
P for respondent.
4 and 5. 4 and 5.
Comment.
AGA for 1 to 3.
My lord, yes.
4 and 5. 4 and 5 notice.
43.
Process fee by 12th kodಬೇಕು.
Please. Please.
Very good petition.
Yes.
Purchases petition. The finding of the commissioner is that there is no grant records or any sort of
Purchases
document.
petition.
Please, yours.
And AGA accepts notice for respond number 1 to 4.
Please.
Who is the caveat? Chetan?
I have for respond number 4.
5 ಅಂತಿದೆ caveat.
Sorry,
ತಹಸೀಲ್ದಾರ್
five. Yes,
5.
5.
ಇವ್ರು ಶಿವಕುಮಾರ್ಗೂ ಅಪೇರ್ ಆಗ್ತೀರಾ?
Lord, let notice be issued.
Issue note, Shri Chetan B has entered caveat for respond number 5 and accepts notice for respond number 5. Registry is direct, print his name as such. Issue notice to respond number 6, returnable by 22/7. The operation of so and so. He stated till the next date of hearing, both the petitioners and respond number 5 and 6 are restrained from in any manner dealing with the property subject matter of the above petition.
Great, that's great.
44.
Petitioners.
Grantina,
Grantee, the question is, my lord,
grantee.
grantee, my lord, the question is, my lord.
Huh.
The petition filed, appeal filed by the grantees was allowed. And after allowing, my lord, the purchaser sold to different persons. Appeal filed, appeal withdrawn by the purchaser. Purchaser filed no fresh petition, my lord, without challenging the order. It's like, this is res judicata, my lord. I may get a brief facts, my lord.
It was, grant was resumed.
Yes, my lord.
Your petition was allowed.
Allowed.
Purchaser challenged it.
Purchaser challenged.
In between, he sold it to third
Sold
party.
After the order passed by the Assistant
Assistant
Commissioner.
Commissioner.
Yes, subsequent.
He sold it to a third party.
Third party. sir.
Withdrew the appeal.
The original purchaser withdrew the appeal. In that, they made filed an applicant command record. It was dismissed. After dismissal, my lord, they filed a fresh appeal before the Deputy Commissioner. Now, Deputy Commissioner observes. Like, I am questioning the very registration.
Please,
initiation
our
of
application illide.
Second petition.
Annexure D.
The purchase is subsequent to the order. Now rightly observes.
Page?
In the appeal, page, annexure G, page 42.
42.
Like made an endorsement, check the admissibility. And then Malad issued notice Malad, without considering that. Malad, second appeal filed by the purchaser is not maintainable because the original appellant itself has no right to sell the property. Malad.
All these grounds are available for you to place it there.
I should kindly say, I am questioning the very initiation, Malad, because if his purchase subsequently has no right at all.
It may be so, Mr. Chandrasekhar.
Right, sir.
But if it is without any this one, they issued a notice to you.
Yes, Malad.
You can go and
Sir,
say
lordship may know that, Malad, aware of that. I am revenue authorities, even Malad, without even considering all the questions.
ಹಿಂಗೆ ಎಲ್ಲ ನಾಟ್ ಮೇಂಟೈನ್ ಅಂತ ಎಲ್ಲ ಇಲ್ಲ ಹೈಕೋರ್ಟ್ ಬಂದ್ರೆ ಆಮೇಲೆ ಅಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲ ಯಾರೂನು.
ಅಲ್ಲ ಸೇಲ್ ಸೆಟ್ ಅಸೈಡ್ ಆದ್ಮೇಲೆ ಪರ್ಚೇಸ್ ಮಾಡ್ತಾರ ಅಂತಂದ್ರೆ and they knows that
We'll direct the respondent number 2 to pass orders on maintainability with before considering everything else. ಅದನ್ನೇ ಹೇಳ್ಬೋದು. We can't stay the proceedings and we can't take
admitted
as in of
they
the
admit
matter.
that the purchase subsequent order for deputy assistant commissioner Malad.
ಇರ್ಬೋದು. You have to place it before that authority. If we take over that authority's role, then why is that authority required?
It's 226 Malad. I invoke extraordinary decision Malad.
We can only direct that authority to consider your objection. You have been served. You appear before that, you challenge the maintainability. First, that will be considered before considering anything else.
My submission is that it maintain itself is doubtful, Malad. Therefore, it's not proper for him to.
And AG accepts notice for respondent number 1 to 4. Notice to respondent number 5 to 7 is dispensed with in view of the proposed order to be passed.
Judicata ಬರ್ತದೆ ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು ಸ್ವಾಮಿ. ಇಟ್ಸ್ ಲೈಕ್ ಜಸ್ಟ್ ಲೈಕ್ ಇಟ್ಸ್ 482 ತರ
ಅವ್ರ ಮುಂದೆ ಹೇಳ್ಬೇಕು ನೀವು ನಮ್ಮ
ಅಲ್ಲ prima facie Malad, I made out a case Malad. It's a void document.
You may have a good case, but before that authority, not before this authority. ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಹೇಳಿ. See, we can't take cessation of everything because it is right or wrong.
ಹೇಳ
ಹಂಗ ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಎಲ್ಲ ಇಲ್ಲ
ಅಲ್ಲ
ಬಂದ್ಬಿಡ್ತಾರೆ.
ಈಗ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಲ್ಲ, ಯಾಕಂದ್ರೆ they made an application, they are aware of all those things.
You may have the best case. We are not saying no.
Yes.
We are not getting into it only.
But it's
Assuming that you are 101% right. You have to make the application there and it will be considered there. But proceedings have been filed before that authority.
yes Malad. That itself is
authority
a void.
consider.
That's my submission Malad. Without
Consider
jurisdiction.
The petitioner is before this court seeking for the following reliefs. The submission of Shri P.V. Chandrasekhar, learned counsel for the petitioner, is that the petitioner's legal heirs of the grantee, legal heirs of the grantee, having filed an application for resumption under section 5 of the PTCL Act. The said application came to be allowed by the assistant commissioner. The purchaser had filed an appeal before the deputy commissioner.
An appeal number
In the interregnum, the purchaser sold the property to a third party,
that is respondent 6 and 7.
namely respondent number, the purchaser,
7.
respondent number
6 and 7 Malad.
5, sold it to a third party, respondent number 6 and 7.
On 17/12/2020 Malad.
Thereafter, the first purchaser withdrew the appeal filed by her, and subsequently a new appeal came to be filed by
They filed an impleading application there itself Malad. Even that also dismissed.
the respondent number 6 and 7, the second purchasers, in the appeal filed by respondent number 5, respondent number 6 and 7 had filed a impleading application which came to be dismissed. And thereafter, respondent number 6 and 7 have filed a fresh appeal on which notice has been issued to the petitioner. The submission is that the second appeal is not maintainable, and as such, this court ought to intercede in the matter and quash those proceedings. The maintainability of a proceeding before a particular court or tribunal would have to be adjudicated by that court or tribunal seized of the matter. This court cannot, in exercise of the power, extraordinary powers and Article 226 and 227, take cessation or jurisdiction over all matters where a litigant were to approach this court contending that there is injustice caused or the procedure has not been followed.
And there is no end for the litigation.
Unless there is some emergency situation which can be made out. In the present case, there is no such emergent situation made out. It would always be available for the petitioner to bring the above facts to the notice of the deputy commissioner. The deputy commissioner would be duty bound to consider the said submission of the petitioners before considering any matters on merits. Needless to say, if the preliminary objection raised by the petitioners were to be accepted by the deputy commissioner, there would be no requirement to consider any aspect on merits. With the above observation, the petition stands disposed. Disposed. Dismissed ಅಂತ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲ ಆ ತರ ಆದ್ರೆ ಎಂಡ್ ಇರಲ್ಲ ಲಿಟಿಗೇಷನ್ಸ್ ಅಂತ ಅಷ್ಟೇ.
ನೀವೆಲ್ಲ ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ ಗಿಲ್ ಬಂದ್ರೆ ಇಲ್ಲ ಎಂಡ್ ಇಲ್ಲ. ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡಿ.
45. Chairman Madhusudan.
For the respond number 5, for petition. Purchaser appeal.
Purchaser. CG accepts notice for respond number 1, 2, 3, 4 and 5.
5 matters.
4 ge?
Notice may can be issued. I have no instructions.
Shrikant NV has entered appearance for respond number 5. He accepts notice for respond number 5. Registry is direct print his name as such. Issue notice to respond number 4. Correct idiyanappa ಹೆಸರು? ರುದ್ರಟೇಶ್ ಅಂತ ಇದೆ. T wrong ಇರ್ಬೇಕಲ್ಲಿ.
Correct. Rudresh. Sorry.
Issue notice to respond number 4 returnable by 22nd July. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the learned AG as also the counsel for respond number 5. The operation of so and so T and S are stayed till the next date of hearing. Both the parties, both the petitioners and respond number 4 and 5 are restrained from any manner dealing with the property subject matter of the above writ petition.
Kindly permit to amend. Permit to correct.
Amend ಮಾಡಕ್ಕಾಗಲ್ಲ. Amendment application ಹಾಕ್ಬೇಕು. ಎಲ್ಲ ಎಂಟ್ರಿ ಆಗೋಗಿದೆ ಎಲ್ಲ ಕಡೆ.
Disposal serial number 46. Sangamesh RB.
I appeal for respondent. On the last occasion, this honorable court directed the government advocate to secure the record, my lord. Have it done. For 2 weeks.
ಯಾಕೆ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ವಾ? ಎಲ್ಲದರಲ್ಲೂ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
26.
Learned AG submits that is yet to receive the trial, the records from the concerned authorities and seeks for 2 weeks' time. This court had earlier had wide ordered 16/1/24 directed the AGA to secure the original records. It was therefore required for those records to be available today. The matter is taken up for consideration.
ಬೆಂಗಳೂರಿನ 1 week ಅಲ್ಲಿ ಮಾಡಬಹುದು.
The matter being adjourned only for non-receipt of the original records would have to be seriously dealt with if the original records are not received within 1 week within 10 days from today. Relist on 21st June. If the original records are not received by then, the concerned deputy commissioner and the assistant commissioner shall be personally present before this court. And this court would also have to consider whether to impose costs on them or not. Ingeli iವಾಗ ಬರುತ್ತೆ.
Serial number 47.
Lord, I am filing retirement memo for the petitioners, Lord. They have taken NOC from me day before yesterday.
ನೀವ್ಯಾರಮ್ಮ?
Respondent.
Party in person or?
ನೀವು party in person.
Yes, my lord. They have taken NOC on 3/6, my lord. I'm just filing the acknowledgement for having taken the NOC.
V. Srinivas, learned counsel appearing for the petitioner, has filed a memo dated 7/6/2024.
ಕೆಳಗಡೆ ಮೇಲ್ಗಡೆದಲ್ಲ ಕೆಳಗಡೆ there are two.
7/6/2024 seeking permission.
ಅಲ್ಲ NOC ನಲ್ಲಿ ಅಲ್ಲಿ ಡೈರಿ ಜೆರಾಕ್ಸ್ ಅದು, so therefore second serial.
To retire from the above matter. along with the said memo, acknowledgement. Yeah, respond.
Jairaj, my lord. Jairam have signed. He is the second petitioner.
Shanta Kumar iradilli.
Shant Kumar, Ramakrishna, Jairam are three brothers. One of the brother have taken on behalf of all brothers.
Who is the,
Petitioner, my lord. Petitioner number 2.
along with this acknowledgement of return of file, signed by petition number 2 is enclosed. The said memo of retirement is taken on record, accepting the memo and the submission made by the counsel for the petitioner. He is permitted to retire from the matter, he is discharged from the matter. Registry is directed to print the name of the petitioners in the cause list. Since acknowledgement has been made on 3/6/2024, if none were to appear for the petitioners on the next date of hearing, the petition would be liable to be dismissed for non-prosecution.
I made corrections in the.
Final hearing, Kodi.
48, my lord.
Kodi, password.
48 minutes.
One ನಿಮಿಷ. Settlement ಒಂದು ನಿಮಿಷ. ಎಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆಯಪ್ಪ? ಎಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ? 15 ಲಕ್ಷ. ಇನ್ನೇನ್ ರೈಟ್ ಇಲ್ಲಲ್ಲ ನಿಮ್ಗೆ? ನೀವೇ ಖುದ್ದಾಗಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿದ್ದೀರಾ? ಯಾರು ಒತ್ತಾಯ ಮಾಡಿದಾರಾ? Petitioner is before this court. Petitioner is before this court seeking for the following leave. It is submitted that the parties have entered into a compromise and a memorandum of settlement has been filed, which reads as under. The petitioner and respondent number 5A to C are personally present before this court. All of them confirm that the settlement has been entered into out of their free will and volition, and there is no undue influence, duress, or pressure exercised on them by anyone. In view of the said submission, considering that the arrangement and agreement arrived at between the parties is lawful, the compromise is taken on record. The application is taken on record, and I pass the following order. The above petition is disposed of in terms of the compromise entered into. The application for resumption filed by respondent number 5A to C under section 5 of the KT so-and-so Act is dismissed as withdrawn. Consequently, the impugned order.
May I submit, my lord? I would like to. My lord, in PTCL cases, my lord, the compromise, it is not permissible under, my lord. This is without prior permission, my lord. It is government lands, my lord, granted to the utilize of the.
17 years, ನೀವೇನು action ತಗೊಂಡಿಲ್ಲ.
I agree, my lord, but compromise is a government land, it is for the.
We'll record yourself.
Please, please.
The order passed by the third respondent, Assistant Commissioner in so done it. The order passed by the second respondent, Deputy Commissioner in so is set aside. Filed by respondent number 5A to C under section 5 of the ACST PTCL Act stands dismissed as withdrawn. At the Munche, learned AGA submit that a compromise may not be accepted by this court, since the land granted to the grantee
Please, my lord,
is a government land.
please. It is for utilization.
And they should, and this court ought not to permit a compromise to be entered into by the grantee in favor of, along with the purchaser. In the present case, since the transaction stroke sale has occurred during the prohibited period. An examination of the records would indicate that the grant was made on 2/9/52 with a prohibitory period for 10 years. The sale of the property occurred on 25/6/1969.
Please, my lord.
10 years alilwala.
My lord, prior permission, my lord.
10 years ಆದ್ಮೇಲೆ prior permission ಏನ್ ಬಂತು?
My lord, whatever, my lord, now it is,
We'll deal with
please,
that.
please, my.
On 25/6/1969. The said sale had occurred after the period of prohibition.
Please.
The further content will learn at AGA that the sale has occurred without taking prior permission of the concerned authorities is not sustainable
Under section 4.
inasmuch as the sale having occurred after the prohibitory period,
Please.
there would be no requirement to obtain any permission from any authority. Hence, the submission of learned AGA is rejected. The compromise between the parties bringing to an end the litigation between them is accepted.
Please.
Hence, I pass.
Please. Amendment R5A to C.
Sign, order sheet signed, madam.
Please.
Final hearing, serial number 48.
In this 48, 48.1, 48.1, I am appealing for the petitioner. The service is not yet complete, my lord.
Yes.
So far as 4 to 6 are concerned, they have refused the notice. And regarding one R7, I have taken a fresh notice.
48.1, notice issued to respond number 4 to 6 has been written with the Shara, postal Shara refused. As such, notice in respect of respond number 4 to 6 is held sufficient.
Yes.
Registry is directed to print their names in the cost list with the endorsement, service refused. Counsel for the petitioner seeks for, and R7, no.
R7,
RBR
Narendra
petitioner
Babu
party
is-
idara?
Yes, Narendra Babu, he is a purchaser from me. Subsequent purchaser.
R7 is R8 in the earlier matter.
How the R8 in the earlier matter. Otherly, our
He is being
served and
served.
absent at the nodi.
Not represent, so we'll have to issue notice.
Issue
Issue notice on respond number 7, returnable by 22nd July.
22nd. Very well. I'll pay the
Records
process.
ಬಂದಿದ್ಯಾ madam?
Records ತರಿಸ್ಬೇಕು.
Records received, my lord, but only proceedings next, my lord, next date I'll secure original grant
The
records.
learned AGA submits that partial records have been
Please,
received. She will secure the entire records by the next date of hearing.
Please.
Serial number 49, adjourn 50. Gurrajar.
That's for the respondent, my lords. He is seeking a week's time, my lords. Petitioners. In a week's time, my lords.
Okay.
Inconvenience, my lords.
At the request of learned counsel for respond number 1 ABC, released on 14th June. 21st June. ಯಾಕೆ ನಿಮ್ ಅವ್ರ ಟೈಮ್ ಕೇಳ್ತಾ ಅಡ್ಲಲ್ಲ 14 ಸ್ವಲ್ಪ 21st June.
Please.
Grateful.
Serial number
Apply.
51, adjourn 52. P. Basuraju.
But the alienation has been taken place, my lord, after the prohibition period. The
Respondent served unrepresented.
He unrepresented.
Petition filed by
Purchaser.
purchaser.
Please.
Madam, ready?
Sir, ready now. ಮಾಡಿ ಸರ್ ಅದೇನು ತೊಂದ್ರೆ ಇಲ್ಲ. ಯಾಕೆಂದ್ರೆ
2:30.
Please.
Please.
53, SV Prakash.
With the respondent.
Yes. Mr. Prakash. Mr. Prakash, please unmute yourself. Video no ಎಲ್ಲೋದ್ರು?
Video off ಮಾಡ್ಕೊಂಡು.
ಕರ್ಕೊಂಡ್ ರೆಡಿನಾ?
It seems their main grievance is that not the deputy
Ready?
commissioner. Yes, yes, ready.
Forget. Pass on.
54, SV Prakash.
Sit.
Pass on.
55. DS Usman.
Pass on.
56. Vishwanath R. Hegde.
Pass on.
B group matters, serial number 57. Patel D. Karegowda.
In this case, I pray for adjournment, but advocate for petitioner is unwell.
57 is submitted. The counsel, arguing counsel for the petitioner is not well. Relist on 21/6.
Serial number 58 adjourned. 59.
Annexure E challenge before this.
ಬಂದಿದ್ಯಾ madam?
Again, they have
59.
Xerox copy ನ ತಂದಿದ್ದಾರೆ.
My lord, here. Assistant Commissioner will present, my lord. Kindly pass over the matter, my lord.
Pass on.
60.
Much.
CS Patil.
Pass on.
61. Nagaraj RC.
Okay, for respondent for this case. Next week,
ನೀವು ರೆಡಿನಾ?
ನಾನು 13th afternoon ಸ್ವಲ್ಪ difficulty next week.
None appears for the petitioner. Relist on 14 June.
62. Ashwini
Lord,
Rajgopal.
I appear for respondent number 1. Lord, I am no more in the panel as a standing counsel to SCST Commission. My name may be deleted, my lord.
ಯಾರಿದ್ದಾರೆ ಇವಾಗ?
Commission ಗೆ ಹೋಗ್ಬೇಕು ಸರ್, ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾರಿದ್ದಾರೆ.
ನೀವಿಲ್ಲ ಅಂದ್ರೆ ಯಾರಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು.
They have not informed me, my lord. ನಾನು next week ತೋಡ್ರೆ ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ, instruct them to appear, my lord.
ಹೇಳಿ. So you.
Please, my lord.
Please. C. Jagdish, none appears for the petitioner. Shri C. Jagdish, Learned Counsel for respondent number 1 submits that he is no longer on the panel of respondent number 1, but
Please,
would
my lord.
however inform respondent number 1 about the matter being listed on 14/6, relist on 14/6.
Please.
63. Harish HV.
Can it be taken up on 14th? So lease PTCL proceedings are initiated.
Tina, you are ready.
I am ready.
That counsel for respondent number 3 is present and ready to address arguments. Learned counsel for the petitioner seeks for a short accommodation. Relist on 14/6.
14.
64. Yes, Sumati.
For the petitioner, pray for a short accommodation next week, my lord.
None appears for respondent number 4. At the request of counsel for the petitioner, relist on 14/6.
Much obliged.
65.
My lord, petitioner, my lord, seek short accommodation, my lord. 65, my lord. Kindly, my lord.
The request of counsel for the petitioner, relist on 14/6.
My lord, not on 14, my lord. Next week, my lord.
21/6.
My lord,
21/6.
Oblige, my lord. Interim order may be extended.
Interim order is extended till next date of hearing. If arguments are not advanced on that day, the petition would be liable to be dismissed for non-pass.
Oblige.
Interim order ತಗೊಂಡು ಹೋಗ್ತಾ ಇರೋದಲ್ಲ.
ಇಲ್ಲ sir.
Argument ಮಾಡಿ.
Serial number 66 adjourned. 67. Jayanta Pujari.
Pass over.
68.
Pass over. ಆಯ್ತು ಬಿಡಿ. Yes.
Serial number 79, my lord.
Item number 62, please, my lords. I apologize, my lords. I was not present when my lords called the matter. My lords, we're ready in the matter, my lords.
62, Mr. Jagdish is no longer on the panel.
Please.
So he'll be informing them. We have posted it on 14.
Please, interim order may kindly be extended, please.
62 interim order.
Grateful to my lords.
Serial number 74, I request for a short adjournment.
74.
Yes, my lords.
ನೀವು ಯಾರಿಗೆ?
I'm for petitioner, my lords.
Have you informed the respondent?
Yes, my lords. They are not picking the call. I shall inform, right?
Not picking the call. Inform ಮಾಡಕ್ಕಾಗಲ್ಲಪ್ಪ ಇಲ್ಲಿ.
Okay, please, my lords.
When
May I
it's called.
please, your lords, item number 56, your lordships.
I'm for the
56.
56. I'm for the petitioner in this matter. I was not present when the matter was called. So I'm seeking a short accommodation, your lordships, to advance my arguments.
56, none appear for respond number 3 and 4. At the request of counsel for the petitioner released on 14/6, it is made clear that no further adjournment would be granted.
Lord, serial number 17,
Arguments are not advanced, dismissed.
serial number 79, my lord. Lord, counsel for the petitioner is traveling, my lord. She is requested for a adjournment, my lord.
Respondent number two
ಹಾ.
in this case. Memo ಹಾಕಿ.
Madam, travel ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಊರಲ್ಲಿ ಇಲ್ಲ ಅವರು.
ಈ date ಮೇಲೆ time fix ಮಾಡಿ.
ನೋಡಿ, ಏನ್ ಮೆಮೊ ಏನ್ ಹಾಕ್ತೀರಾ?
Memo ಹಾಕಿದೆ, ಇವತ್ತಿಗೆ posting.
Total mood.
Lord, any day after 19th.
Counsel for respond number 2 is present and ready to address argument. Counsel for the petitioner
Lord.
seeks for a short accommodation.
Yes, my lord.
Released
Any day
on-
after 19th, my lord, she is traveling, my lord. Alla, she is traveling, my lord. Counsel on record is
Traveling for so many days when court is in session.
Alla, ಈಗಲ್ಲ.
ಈಗ
10 days she is gone out.
and do it during emergency ಅಂತ ಹೇಳಿದ್ರೆ ಅದು okay.
Alla, I understand.
10 days ಅಂತ ಹೇಳಿದ್ರೆ released on 21st.
Yes, my
My
lord.
lord,
But
June.
interim order to be extended.
If arguments are not advanced on that date, petition will be liable to be dismissed for non-prosecution. Interim order earlier granted is extended till next year.
my lord, serial number 60, my lord. I am for the
60.
my lord. I am for the petitioner, my lord. NOC ವಕಾಲತ್ ಬಂದಿದೆ, my lord. NOC ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೀವಿ. On 2 weeks time maybe.
The so and so submit that you would be appearing for the petitioner.
Petitioner, my lord.
Registry is directed to by filing a NOC wakalatnama. If needful is done, registry is direct print his name as that appearing for the petitioner. None appears for the respondent. Released on 28th June.
Much obvious.
Seventy-seven adjourned, 21 6.
ಇರೋದ್ರಲ್ಲೆಲ್ಲ ನಾವು ಫಾಲೋ ಅಪ್ ಮಾಡಿ ಮತ್ತೆ ಅದನ್ನ ಮತ್ತೆ ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ
71 pass.
ಅದ್ರಲ್ಲಿ
Sir, 21 6, 64 14 6.
ಪೂರ್ತಿ ನಮ್ದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಇರುತ್ತೆ
ಮಧ್ಯಾಹ್ನ.
ಮಾಡ್ಕೊಂಡು ಹಾಕ್ಬೇಕು. ಇವತ್ತಿದ್ದು 2-3 ಆಗಿರುತ್ತಾ
ಎಲ್ಲಿ? ಅಲ್ಲಿ meeting ಇದೆಯಂತ.
ರೆಕಾರ್ಡ್ಸ್ ತರ್ಸಿದ್ರೆ ಎಷ್ಟೊಂದು ಇರುತ್ತೆ ಅವ್ರು ತಂದು ಕೊಡೋದಿಲ್ಲ.
ನೋಡ, 2:30 ಅಷ್ಟ್ರಲ್ಲಿ ಮುಗಿಬೋದೇನೋ.
ನಾವು ಇದನ್ನ
Court of sir, 76 ಇದೆಯಾ? Serial number 76.
ಕ್ರೆಡಿಟ್ ತಗೋಬಹುದು.
Madam, serial number 76.
76 pass over sir. ಇಲ್ಲ ಕರ್ದೇ ಇಲ್ಲ ಇನ್ನು. ಕರ್ದೇ ಇಲ್ಲ.
ಒಂದಾದ್ರೂ ಇರ್ಲಿ ಎರಡಾದ್ರೂ ಇರ್ಲಿ ಬಿ ಹೇಳಲ್ಲ ಸರ್. ಅದಕ್ಕೆ ನಾವು ಹೋಗಿ ಹೇಳೋಣ ಅಂದಿದ್ದು. CRP and RSC ಏನಾಗ್ಬಿಡುತ್ತೆ ಒಂದ್ ಮ್ಯಾಟರ್ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ, R7 ಅವರೇ
ನಾವು ಇದರಲ್ಲಿ 4, 5, 6.
ಈಗ CRP ಒಂದಿದ್ರು
4, 5, 6
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತೀವಿ.
ಮೇಡಮ್, ಮಧ್ಯಾಹ್ನ
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆ ಅದ್ರಲ್ಲಿ. ಅದನ್ನ ಬೇರೆ ಚೆಕ್ ಮಾಡ್ಬೇಕು ನಾವು.
ಧಾರವಾಡ ಆಮೇಲೆ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಒಂದೇ 230 ಇದೆ. ಆಮೇಲೆ
ಅಲ್ವಾ ಆಮೇಲೆ ವಾಸು ಚೆನ್ನಾಗಿ ಮಾಡ್ತೀನಿ ಅಸಿಸ್ಟೆನ್ಸ್ ಇದೆ ಅನ್ನಿಸ್ಬೇಕು. ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ಹಂಗ್ ಮಾಡು ಮೇಡಮ್. ಮೇಡಮ್ ಇದು ನನ್ನ ಆಕ್ಟ್
ತರ್ಸ್ದೆ ನನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಮುಗ್ಸೇ ಯಾವ್ದು
ಇರ್ಲಿ. ಆಫ್ಟರ್ ದಿಸ್ ವಿಲ್ ಹ್ಯಾವ್.
ನಿಮ್ದು ಅದೇ.
ಏನ್ ತರಿಸಿದ್ರಿ ಮೇಡಮ್ ನೀವು? ಏನ್ ಬೇಕಿತ್ತು ನಿಮ್ಗೆ ಎಕ್ಸ್ಟ್ರಾ? ಹೌದಾ, ತರ್ಸ್ಕೊಂಡ್ರಾ? This and all will make notes and section not required actually.
Notice ಆದ್ರೆ ಇವತ್ತೇ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ.
ಹಾ.
Notice ಇವತ್ತೇ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ 12/6 ಒಳಗಡೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ? ಹೌದು ಪಾಸ್ ಓವರ್
9
ಹಾ.
ಪಾಸ್.
ಮಾಡಿದ್ರು ಮಾಡಕ್ ಹೌದು.
58. ಹೌದು ಹೌದು. ಯಾಕೆಂದ್ರೆ ಅದು ಆಮೇಲೆ ಆರ್ಡರ್ ಪಾಸ್ ಅದ್ರಲ್ಲಿ ಬರೋದಿಲ್ಲ, ಅದಕ್ಕೆ ನೀವು ಅಮೆಂಡ್ ಮಾಡ್ಕೊಡ್ಲಿ ಅಂತ. ಬೇಡ, ಕಮ್ಮಿನೇ ತಾನೆ, 3 ಜನದ ಹೆಸರು ನೀಟಾಗಿ ಬರ್ದಿದ್ದೀರಲ್ಲ. ಹೇಳಿ sir. ಇಲ್ಲ ಇನ್ನು ರೀಚ್ ಆಗುತ್ತೆ, ಮಧ್ಯಾಹ್ನ ಆಗುತ್ತೆ ಎಲ್ಲ. ಇಲ್ಲ 3:30. ಯಾಕಂದ್ರೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ತುಂಬಾ ಕಮ್ಮಿ ಇದೆ. ಇಲ್ಲ ಒಂಚೂರೇ ಚೂರಿದೆ ಇವತ್ತು ಕಮ್ಮಿ. ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಲ್ವೇ ಇಲ್ಲ ಸರ್. ಅದು ಇರೋದೇ ಟಾಪ್ ಅಲ್ಲಿ 2:30 ಅಂತ. ಇರೋ ಯಾವ ಕೋರ್ಟ್?
ಇನ್ನೊಂದು ಕೊಟ್ಟು
ಅಲ್ಲ, ಅದು ಇರೋದೇ 2:30 ತಗೊಳಕ್ ಚಾನ್ಸೇ ಇಲ್ಲ ಅಂತ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್
ಫಾಸ್ಟ್
ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್. ಕರೆಕ್ಟ್, ಸಾರಿ ಸಾರಿ.
ಅದು ಲಿಸ್ಟ್ 1 ಅಲ್ಲೇ ಅದು.
ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ತಿರ್ಗಾ ಬರ್ತಾರೆ.
ಹಾ ಸರ್.
ಈಗ 58 ಮ್ಯಾಟರ್ ಅಂತ.
ಇಲ್ಲ ಇನ್ನು ಮುಂದಕ್ಕೆ ಹೋಗ್ಲಿ. 68 ವರೆಗೂ ಹೋಗಿತ್ತು.
58 ತಿರ್ಗಾ 56 ಬಂತು.
60 28/6. ಅವರು ಪಿಟಿಷನರ್ಗೆ NOC ಅಂತೆ. ಹ 66 ಅದು 14/6. ಅಲ್ಲಿ ಯಾಕೆ ಹೆಸರು ಹಂಗಿದೆ, ಇಲ್ಲಿ ಯಾಕೆ ಹಿಂಗಿದೆ? ಒಬ್ರೇ ಅಲ್ವಾ ಆರೋಪ? GS ಪಾಟೀಲ್ ಅಂದ್ರೆ ಒಬ್ರೇ ಅಲ್ವಾ? ಅಲ್ಲಿ 2 ಈ ಬಂತು. ಹಾ ಹಾ.
ಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬೆಂಗಳೂರು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬೆಂಗಳೂರು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬೆಂಗಳೂರು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬೆಂಗಳೂರು. ಮನೆ ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸ್ ಕೇಳಿದ್ಯಾ ಧಾರವಾಡದಿಂದ? ಮನೆ ಸರ್ ಸಂತೋಷ್ ಈ ಮನೆ. ಸಂತೋಷ್ ಮನೆ ಸರ್.
ಸರ್ ಕೇಳಿಸ್ತಿದೆ ನಂದೀಶ್ ಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಅಂತ ಕೇಳಿಸ್ತದೆ.
ಓಕೆ ಓಕೆ ಓಕೆ. ನೀವು ಇಲ್ಲೇ ಇದ್ದೀರಾ ಇದ್ರಾಗೆ?
ಮೇಲೆ ಲಿಟಿಗೇನ್ಸ್
ಲಿಟಿಗೇನ್ಸ್ ರೂಮ್.
ಒಂದ್ ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಇದೆ, ಅದಾದ್ಮೇಲೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ 230, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 230.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಇದನ್ನ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳ್ತೀನಿ.
ಲಿಸ್ಟ್ ಅದು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ ಬಂದೇ ಒಂದಿದೆ, ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ
ಡೈರೆಕ್ಟ್ ಆಗಿ ಬಂದಿದಾರಾ?
ಇಲ್ಲ ರೀಚ್ ಆಗಲ್ಲ. ಎಷ್ಟನೇದು ಅದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನಿಮ್ದು ಫಸ್ಟ್ ಅಂಡ್ ಸೆಕೆಂಡ್ ಥರ್ಡ್ ಮ್ಯಾಟರ್ ಅಷ್ಟೇ ಬಂದ್ಮೇಲೆ ಥರ್ಡ್ ಮ್ಯಾಟರ್ ಆಗುತ್ತೆ.
ನಾನು ಬರೀ ಡೈರೆಕ್ಷನ್ ಮೇಲೆ ಇದೀನಿ, ಇನ್ನು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೋಗೇ ಇಲ್ಲ.
ತಗೊಳಲ್ಲ.
ಅದನ್ನ ಹಿಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದಾರೆ. ಟ್ಯಾಂಪರ್ ಆಗಿರೋದು ಬೇಕಾದ್ರೆ ಮಾಡಲ್ಲ, ಅದನ್ನ ಪೆಂಡಿಂಗ್ ಇಟ್ಬಿಡ್ಬೇಕಾದ್ರೆ ನೆಕ್ಸ್ಟ್
ಯಾರು ಇಲ್ವಂತೆ, ಆ ದಾರಿಲೇ ಸಿಕ್ಕಿದ್ರು. ಯಾರು ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು
is not considered ನಿಕ್ಕಂಟಿ ರಾಮಲಕ್ಷ್ಮಿ ಅಂತ. ಇಲ್ಲ, ಏನಾದ್ರೂ ಆಗಿರ್ಲಿ,
ರೆಡಿ ಇದ್ರೆ ತಗೋತಾರೆ.
ಅದು ಡಿಸೈಡ್ ಮಾಡಿ.
ರೆಡಿ ಇದ್ರೆ ಅಷ್ಟೇ. ನೀವು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್, ಏನ್ ಹೆಸರು? ಫಸ್ಟ್ ಲಿಸ್ಟ್ memo of retirement is accepted. Counsel for respondent number 5 is permitted to retire from the case. Released on 21/6.
But we'll do it ಅಂತ ನಾನು ಹೇಳ್ತೀನಿ, ಬಟ್ ಅವ್ರಿಗೆ ಅದನ್ನ
ಅದೇನೋ ಮೀಟಿಂಗ್ ಇದೆ ಅಲ್ಲಿ ಅಂತೇನೋ ಹೇಳ್ತಾ ಇದ್ರು. ಅದು ಸ್ಲಿಪ್ ಹೆಸರು ಇಲ್ಲಿ ಇಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದೀರಾ? ನಾನು ಕೆಳಕ್ ಹಾಕ್ತೀನಿ, ಇದೇನೋ ಹೆಸರಿದೆ ನೋಡಿ ಅಂತ ನಾಗರಾಜ್ ಕೊಟ್ಟು ಫೈಲ್ ತಗೊಂಡ್ ಪಿನ್ ಮಾಡಿಸಿ. ಅಯ್ಯೋ ಇಲ್ಲಿ ಫೈಲ್ ಸೇರ್ಸ್ಬಿಡಿ. ಹೋಗೋ ಗಡಿಬಿಡಿ ಟೈಮಲ್ಲಿ ನಾನು ನೋಡಲ್ಲ. ಹಂಗೆ ಈಗ ತೋರ್ಸ್ಬಿಟ್ರು ಆಯ್ತು. ತೋರ್ಸ್ಬಿಟ್ರು ಆಯ್ತು. ಅದು ಬರ್ದ್ಬಿಟ್ಟು ಇಟ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದ್ರೆ ನನ್ಗೇನ್ ಗೊತ್ತು? ನೀವ್ ಹೇಳಿದ್ ಪೂರ್ತಿನೂ ನಾನು ಕೇಳಿಸ್ಕೊಂಡ್ನೋ ಇಲ್ವೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ ಬಿಸಿ ಇರ್ತೀನಿ, ಗೊತ್ತಲ್ಲ ನಿಮ್ಗೆ. ಹೇಗಿದ್ರು ಫೈಲ್ ಅಲ್ಲಿಗೆ ಹಾಕ್ತೀನಿ, ಫೈಲ್ ಹಾಕ್ಬಿಡಿ. ಅದನ್ನ ಕೊಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರು ನನಗೆ.
because matter is 83.
ಅವ್ರು ಕೇಳ್ಬಾರ್ದು ಅಷ್ಟೇ, ನನ್ನನ್ನ ಕೇಳ್ಬಾರ್ದು.
ನಿಮ್ದು ಆಮೇಲೆ ನಿಮ್ದು ರೀಚ್ ಆಗುತ್ತೆ. Wait until 5 o'clock, otherwise
ಅವ್ರ ಕೆಲ್ಸ ಅದು. ಏನ್ ಕೆಲ್ಸ?
ಇಲ್ಲೇ ಕ್ಯಾಂಟೀನ್ ಮಾಡ್ತೀವಿ. Go and have lunch and come back. ಹೋಗ್ ಬನ್ನಿ. And I'll take a parcel. ಆಮೇಲೆ ಹೇಳ ಸರ್, ಇದೆ ಈಗ ಇದೆಯಾ ನಿಮ್ದ್ರಲ್ಲಿ? ಆವಾಗ್ಲೇ ನಾನು ಸ್ವಲ್ಪ ಓದೋದಿತ್ತು. ನೋ ರೂಲ್ ಪೀರಿಯಡ್ ಇದೆ ಸರ್ ನನ್ನ ಹತ್ರ. ಆಮೇಲೆ ಅಮೆಂಟ್ ಇದೆ ನೋಡಿ. One more list is there. ನೋಡಿದ್ರ ಇದ್ರಲ್ಲಿದೆ ನೋಡಿ, ಆಮೇಲೆ ನೋಡ್ಬಿಟ್ಟು ಕೊಡಿ ನನಗೆ.
ಹಾ. ಎಲ್ಲ 26. ಇದು ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಏನ್ ಗೊತ್ತಿಲ್ಲ.
ಅರ್ಜೆಂಟ್ ಮಾಡಿರೋದೆಲ್ಲ ನಾನು ಹಾಕಿಲ್ಲ ಸೈಡ್ಗೆ. ಎಲ್ಲ ಓದಕ್ಕೆ ಇಟ್ಟಿದ್ದೀನಿ. ಓದಿ ನೋಟ್ಸ್ ಮಾಡಿ ಇಟ್ಟಿದ್ರಲ್ಲ.
Court officer Bangalore. Court officer Bangalore.
ಹಾ ಸರ್ ಹೇಳಿ ಸರ್.
ಹಾ ಮೇಡಮ್ ದೊಡ್ಡ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಇತ್ತು ಎರಡು.
ಹಾ ಒಂದೇ ಒಂದು.
ಎರಡು ದಾವಡ ಬೆಂಚ್ ಇಂದ
ಹಾ ಹೇಳಿ ಸರ್ ಹೇಳಿ.
ಅದೇ 4 ಕಾಲಿಗೆ ಅಂತ.
ಬಂದ ತಕ್ಷಣ ಅದೇನೆ ಸರ್.
ಅಲ್ಲ 4:15 ಅಂತ ಅಂತಿದ್ವಿ. ಅದಕ್ಕೆ ನಮ್ ಫೋನ್ ಬಂತು.
1 ಅಲ್ಲ 2 ಅಲ್ಲ ಸರ್ ಅದು.
ಇವಾಗ ಫ್ರೆಶ್ ಮಾಡಿಸ್ತಲ್ಲ ಸರ್. ಪ್ರಾಪರ್
ದೊಡ್ಡ ಬೆಂಚ್ ಇಂದ ಮಾತಾಡ್ತಾರೆ ಕೋರ್ಟ್ ಆಫೀಸರು.
ಯಾವ್ದಾ? ಯಾರು ಅಂತ ಏನು ಹಾ ಡಿವಿಷನ್ ಬೆಂಚ್ 4 ಕಾಲ್ಗ. ಓಹೋ ಅದಕ್ಕೆ ಅಲ್ಲಿ ಬರ್ಲಿಲ್ಲ. ಇಲ್ಲ ಇದೆಯಲ್ಲ ಕೋರ್ಟ್ ಇದೆ ನೋಡಿ. 4 ಕಾಲ ಕನೆಕ್ಟ್ ಮಾಡಿ. ಇರೋದೇ ಒಂದೇ ಡಿಗ್ರಿ ಇದೆ.
ಮೇಡಮ್ ಧಾರವಾಡದಿಂದ
ಹೇಳಿ ಸರ್.
ಏನ್ ಮಾಡೋದು ಅದು 4 ಕಾಲಿಗೆ ಅಂತ ಹೌದ್ರಾ?
ಹಾ 4 ಕಾಲಕ್ಕೆ ತಗೋತಾರತ್ತೆ ಸರ್ ಅದು.
ಓಕೆ ಅಲ್ಲಿ ತನಕ ನಾವು ಕ್ಲೋಸ್ ಇಲ್ಲಿ ಇರ್ತೀವಿ ಮೇಡಮ್.
ಆಯ್ತು ಸರ್ ಆಯ್ತು.
ಮೇಡಮ್ ಒಂದ್ ಫೋನ್ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್ ನನಗೆ ಆ ಟೈಮ್ನಾಗೆ.
ಮಾಡಕ್ ಆಗಲ್ವಲ್ಲ ಸರ್.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ನಮ್ದು ಇದಿಲ್ಲ ನೋಡಿ ವಿಡಿಯೋ ಇಲ್ಲ. ಅದೇ ಆಗ್ಬೋದು.
ಹೇಳಿ. 230 matters. List number 1, serial number 83. Krishna name.
Served, everybody is served. Ready, madam?
The last occasion, my lord, I directed the AC and the DC to be present.
Tampering of
Lord,
the
assistant.
tampering of the
Please, my lord. My lord, they then assistant commissioner, my lord, he is promoted as a additional deputy director, my lord, deputy DC, my lord, Dakshin Kannada. And my lord, he couldn't report the complaint to the higher authority. Now present assistant commissioner is present here, my lord. Now, my lord, they then assistant
The order was passed on 18/7/23.
my lord,
When was he promoted as the?
after this order, before this order only, he was promoted as a ADC.
For that order.
Please, my lord.
Then fine.
My lord, yes, sir.
Copy.
My lord,
my
now,
lord,
now, my lord, he is held up in election, MLC election counting, my lord. If court permits.
Who was the order to say when he was promoted?
My lord, on B. Ravindra appears for the second respondent, private respondent. He has filed wakalat today, my lord.
Today?
Yes.
How did you get to know today?
Yesterday only they have handed over wakalat, my lord. Today.
You got to know
And
through
it
the
was
assistant
noticed.
commissioner after we inquiry.
My lord,
That
My-
I don't know, my lord. He has engaged me. I'm appearing.
my lord, all the document I'll file along with memo, my lord, now. I
ಇವಾಗ
just-
ಸದ್ಯಕ್ಕೆ ನೋಡೋಣ.
Please, please. And my lord. And yesterday he reported a complaint to the Deputy Commissioner, my lord, after being continuous following up.
Notice ಆಗಿಲ್ಲ. We can't accept this reason.
My lord, I agree.
And we find this reason to be contemptuous. He
But
was
my-
present personally
Please,
before
madam.
the court on 18/7/23.
Yes, my lord, that he was present.
And he made the submission on 18/7/23. It is not like ಮುಂಚೆ ಏನೋ affidavit ಹಾಕ್ತಿದ್ರು ಅದ್ರ ಮೇಲೆ order ಮಾಡಿದ್ದಲ್ಲ.
Yes, he was present, my lord.
And he was directed by this court.
Yes. ma'am. And after
So he
following.
cannot now say I took charge somewhere else. He should have brought it to notice when the order was dictated in his presence.
Correct. My lord, and today, my lord, his presence was ordered.
Today we will exclude his presence,
Yes, my lord.
but
And
his presence will go somewhere else after some time.
And my lord, yesterday he reported to the higher authority, my lord, saying that initiation of action, my lord.
We'll initiate action against him now. This is not acceptable. What does he think of himself? To be saying all these. What do you have complaint in? And this we came to know because Mr. Unnikrishnan made the submission. Otherwise, we would not have got to know this fact also.
Yes, my
It would
lord,
have just gone like that.
I agree.
This is complete
Ignorance.
abdication of duties
Yes, my lord.
and violation of the orders of this court. Hold it. This court-wide order dated 18/7/23 on the basis of the submission made by the Assistant Commissioner, on the then Assistant Commissioner, adunu helidare.
Yes, my lord, they then.
The basis of submission made by then Assistant Commissioner who had passed the impugned order void annexure A. Had directed him to lodge a complaint with his superior in regard to the alleged tampering of the order void annexure A within a period of 2 weeks. And if such complaint is lodged, the Deputy Commissioner shall take cognizance of the fact and hold an inquiry and submit a report to the registry of the court. Today, a letter dated 6/6/2024 of the then Assistant Commissioner, who is now the Additional Deputy Commissioner, Dakshina Kannada District, Mangalore, is placed on record, which reads as under. In this letter, the then Assistant Commissioner, now the Additional Deputy Commissioner, has stated he was working as the Assistant Commissioner, Chikbadapura Subdivision, and relieved from the said post on 10/7/23 and reported to the post on 12/7/23 as the Additional Deputy Commissioner, Dakshina Kannada District. And now has been deputed to the MLC election counting work at Mysore from 5/6/24 to 7/6/24. On the basis of the same, learned Additional Government Advocate submits, firstly he submits that since he had been relieved of his duties on 10/7/23 and he had reported to new duties on 12/7/23, the complaint could not be filed. Secondly, she submits that at present, the then Assistant Commissioner, now the Additional Deputy Commissioner, is being deputed for election counting work and as such cannot be present today.
Yes, ma'am.
Insofar the second submission is concerned, the presence of the then Assistant Commissioner, now the Additional Deputy Commissioner, is dispensed with.
Yes.
Insofar as first submission, that because he was relieved from duty on 10/7/23 and reported to the post of Additional Deputy Commissioner on 12/7/23, the order dated 18/7/23 could not be implemented and a complaint could not be filed by him, is concerned. On the face of it, the said submission and the statement made by the additional deputy commissioner and now by the learned AGA is contemptuous. This court observing, taking into account the submission of the then assistant commissioner, inverted commas, then assistant commissioner, had taken into consideration that he was no longer the assistant commissioner, but even then directed him to file a complaint as regards such a serious matter as tampering of the order.
Please.
This court had also observed that the said assistant commissioner had passed judgments in violation of the law of the apex court, towards which an apology had been rendered by him. In order to escape from his liability, he had contended that the order had been tampered with. It is in order to ascertain the said facts that he was directed to file a complaint, which he was duty bound to do. It does not now lie for him to contend that he was relieved of the post on 10/7/23 and assumed charge in a new post on 12/7/23 when the order dated 18/7/23 was passed in his presence and a direction had been issued to him.
My lord, my lord, yesterday he has filed a complaint, my lord, against Deputy Commissioner.
Learned AG submits that the then assistant commissioner, now the additional deputy commissioner, has filed a complaint yesterday.
Please, my lord.
That is 6/6/2024.
Initiate inquiry.
Therefore,
Initiate inquiry against the office bearers, my lord.
it is now not understandable as to how the reason given for not filing that he had assumed charge, relieved from the present charge and assumed charge, did not come in the way of presenting the complaint on 6/6/24. The submission made by the then assistant commissioner and the additional, now the additional deputy commissioner, Shri Dr. G. Santosh Kumar, is ex facie contradictory and amounts to a violation of the orders passed by this court. Before initiating contempt, this court deems it fit to grant one more opportunity to him
Please.
to to give an explanation as to why such false submissions have been made.
Please.
Relist on, since he is stated to be deputed for counting work, relist on 21/6 at 2:30 PM. He shall remain personally present
Please.
for this court.
Interim
Not
order,
the way
yes,
we
ma'am.
can do it.
My lord, repeated submissions, my lord, and
ಇಲ್ಲಿ
please.
ರಾಂಗ್ ಆರ್ಡರ್ ಮಾಡಿದಿರ ಅಂದ್ರೆ ಟ್ಯಾಂಪರ್ ಮಾಡಿದಿರ ಅಂದ್ರೆ ಟ್ಯಾಂಪರ್ ಮಾಡಿದ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಅಂದ್ರೆ ಅದು ಕೊಡಲ್ಲ.
Yes, ma'am. You should.
Since the complaint has now been filed by the then assistant commissioner, now the additional deputy commissioner. The deputy commissioner, ಯಾವ
Initiate
district ಇದು?
inquiry.
ಚಿಂತಾಮಣಿನ?
ಇಲ್ಲ,
ಚಿಕ್ಕಬಳ್ಳಾಪುರ, my lord, ಚಿಕ್ಕಬಳ್ಳಾಪುರ.
ಇದು ಯಾವ posted at the deputy commissioner Chikwadapura is directed to cause an inquiry forthwith,
Yes, ma'am.
ascertain the persons responsible, if any, and submit his report by 16 July 2024.
Please.
Interim order memo.
Yes, my lord.
Interim order, the extended link. She so and so submit that he would be appearing for respond number 2.
P. Ravindranath. P. Ravindranath.
Bariyu 2 ga.
Bari 2.
If Wakalatnama is filed, registry is directed to print his name as such.
List number 2, serial number 1, Harish Bhandari.
Appearing for the petitioner, your lordship.
For the responding statement.
Your lordship, so far as the non-filing of the amended cost title is concerned, we have already filed the amended cost title in the open court on 24/4/2024.
No, you can't file it in the open court. We are directed to be filed in the registry. Where have you filed it? Idya? The submission made that you will file it. That is what has been recorded. It is not there.
Will comply with. Your Lordship. So far as the non-filing of the acknowledgement is concerned, we have filed the acknowledgement for serving the copy of
And
on the
SCGP
FCG.
confirms receipt of the copy of the petition along with annexures as submission is based on record. Office note at sale number 2 is directed to be deleted. Counsel for the petitioner seeks for 2 days' time to file the amended cost title. Relist on
Your Lordship,
petition.
interim order may be extended.
Relist on 18th June, interim order earlier granted is extended.
Much obliged.
Serial number 2. Srinivas Rao.
Where's your opponent?
Not aware, my lord.
Huh?
Not aware. I tried contacting them, but wasn't able to.
Gaurav? Mr. Gaurav?
My lord, I have one submission.
Yes.
There are 2 more criminal petitions.
2 more.
With
Connected.
respect to the same parties and same allegations are involved in both of them.
Connect with so and so, so and so. Third, counsel for the petitioner is present and ready to address his arguments. None appears for respond number 2. Third, counsel for the petitioner submit that the above matter is connected with so and so and so and so. Registry is direct, connect the same and relist on 18th June.
Though the Rasta
Made
bench-
clear that in the event of there being no appearance for respond number 2, the matter would be taken up for consideration on the basis of submission of the counsel for the petitioner and the HCGP. Both the counsels are directed to get ready and address the arguments.
Interim order may be extended.
Interim order earlier granted is extended.
The other 2 petitions may come before different rosters because those are also 482 petitions.
Those are?
They are also 482 petitions.
Uh,
So roster bench may vary.
For whoever it goes, they will deal with.
Serial number 3. Siddharth Suman and connected matter.
Lord, I'm paying for petitioner, my lord. I pray for short accommodation.
Modification of order.
Please, my lord. My lord, on the previous occasion on 27th/11, my lord was pleased to, even though granting a stay of the impugned order, directed us to not to proceed with construction. We filed application because of the rains and my lord, subject to the result of the writ petition, we may be proceeding.
To go ahead with construction.
Yes, my lord. It's matter.
It's already 70% over. my lord.
The shown is the park, my
No,
lord.
my lord, the matter now in B group, my lord, we will threadbare argue for final, my lord.
So
All applications and B group. Next week, my lord.
I-1 of 24, you don't press for now.
No, my lord, we press, my lord.
For now, you don't press, you will press it along with the hearing on the main.
Let it come in the same step. Otherwise, my lord.
Same alla, this argument ಮಾಡಿ, we'll allow it. or
ಅದು
dismiss it.
ಅದರಲ್ಲಿ
You
to
can't
argue
have
for
both.
me, there is some difficulty, my lord. My colleague will argue and then next week, my lord.
Then non-compliance, for impleading filed by.
These are all the people, unscrupulous people who illegally purchase the property, illegally constructed
Proposed
building,
respond number 3 to 6.
illegal allotment and construction.
Argument ಮಾಡಿ, we'll pass orders. Who is appearing for respond number 3?
Kalyan, Land County, Kalyan, madam.
Kalyan is my lord first respondent, CMC.
Kalyan R1, again, Yogesh R2, Dinesh Neelkant Gaonkar, 3, please. R3. None appears for respond number 3 to 6. If none were to appear for them on the next date of hearing, IA1 of 23 will be liable to be dismissed for non-compliance since non-compliance. IA11 counsel for the petitioner submits that IA1 or 24 may be considered
My lord,
along with the main.
my lord, my lord. My
Read
lord,
list on.
no, time to argue that application.
You argue everything. When will you argue?
Next week, my lord, 13th, 14th,
Read list on 13th at 2:30 PM.
please.
Passed over matters. List number 1, serial number 3. Chetan B.
Chetan? Set aside application.
IA2 to bring the LS of petition number 2.
Condemnation and set aside Akila antalla.
Set aside not paid.
None appears for the petitioner. 1 week's time is granted finally. 10 days time is granted finally to comply with the office objection in IA 1 and 2 of 24. If they are not complied by 18 June, the said application will be liable to dismiss for non-prosecution released on 21st June.
Serial number 15. Sarvana, yes.
Yes.
One office objection is regarding manuscript of annexure A is filed, my lords, that it's an encumbrance certificate. I will get the typed copy filed, my lords.
What is annexure A?
Annexure A is the encumbrance certificate which reflects all the transactions pertaining to this property.
How
It's a
can that
proceedings
be
under the
manuscript?
PTCL Act.
Why is that a manuscript?
This is
When
a,
did you secure it? On
lords,
11/4/24?
yes, 11/4/24.
They given you a manuscript.
Yes, my lords.
They have to give you a typed copy. Why are they giving you
This
manuscript?
probably, these are all old transactions, I
How
think.
did they know?
I don't know. But anyway, this is
Can't
what
give
we
you a
got.
manuscript. Madam, you will have to give an explanation as to why you are giving a manuscript. Encumbrance certificate ಎಲ್ಲ typed ಎಲ್ಲ ಕೊಡ್ಬೇಕಾಗಿರೋದು ಇವಾಗ.
Yes, ma'am.
Digitized.
Yes, ma'am.
Manuscript ಹೆಂಗ್ ಕೊಟ್ರಿ? ಅವ್ರ ಪಾಪ ಇದನ್ನ type ಮಾಡಿಸ್ಬೇಕು ಇವಾಗ.
My lords, I'll get it filed, my lords.
You get it filed, but we are concerned with a larger thing.
I understand. my lords.
That counsel for the petitioner seeks for and is granted a week's time to file a typed copy of annexure A being an encumbrance certificate.
Or the second,
A perusal of annexure A indicates that a encumbrance certificate has been given in a handwritten format. Learned notice ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ.
Learned AGA accepts notice for respond number 1 to 4 ಅಂತ ಮೇಲ್ ತಗೊಳ್ಳಿ. Respond number 1 is directed to file an affidavit as to why the manuscript encumbrance certificate has been issued by respond number 1 ಬರಲ್ಲ.
state ಗೆ ಹೇಳ್ಬೇಕಾಗತ್ತೆ ಯಾಕೆಂದ್ರೆ lords, it is under the revenue department only, my lords. Sub-registrar comes under the revenue department.
Respond number 1, file an affidavit as to why the encumbrance certificate has been issued in a manuscript format and not in a electronic, not in a typed format. In a typed format, computer generated.
Lords, the second objection, my lords, is essentially the ground which I have raised. I am the purchaser of the property. This is proceedings under PTCL Act. I was not made as a party before the Assistant Commissioner or the Deputy Commissioner. The orders are passed pertaining to my land.
Who are you?
Lords, I am the purchaser.
Then counsel for the petitioner submit that the petitioners are purchasers of the property who are not made parties before the Assistant Commissioner and Deputy Commissioner. And that the orders passed have adversely affected them. Accepting the said submission, office objection at CL number 2 stands overruled. Yes.
Lords, if your lords were to take an action here, my lords, in that serial number 3, lords, 1 acre is purchased by me on 12/7/1972. Lords, this Puttamaya purchases 2 acres 30 guntas. Out of the 2 acres 30 guntas, I have purchased 1 acre. 2 acres, out of 2 acres, I have purchased 1 acre. I am not a party. I am not made as a party in the before the Assistant Commissioner or before the Deputy Commissioner. It's at annexure C, page number 19.
To respond number 4 to 8, returnable by 22nd July. The operation of the order dated so and so is stayed till the next date of hearing. Both the petitioner and respond number, petitioners and respond number 4 to
Rajan
8
and Keshava, please.
are restrained from any manner dealing with alienating or encumbering the petition properties subject matter of the above petition or any part thereof.
They are changing the nature of the property, my lords. That's the. I have produced a
Are in
photograph.
possession.
We are only in possession of the property, my lords. Now your lordships is passing an order against both the parties. Now on the basis of this order, they came out, this is what is produced at annexure E2, page 34, my lords. I have produced the previous photographs also at page number 33, and this is what they could do with the help of the police. When I went to the police station, actually I was made to sit in the police station saying that Sahabru Bartara, but by the time he came back, this is what has happened to my property.
ಏನಾಗಿದೆ?
ಅವರು ಪೂರ್ತಿ ಕ್ಲಿಯರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಅದಕ್ಕೆ.
ಏನಿದೆ 4 ಇದ್ದು
Status quo ಮಾಡ್ಲಿ ಅಂತ ಅಷ್ಟೇ. I will also not do anything over the property.
both the petition not to alienate, encumber or deal with the property, as also changing the nature and character of the property. Process fee and copies to be furnished by end of day 11 June 2024, failing which the interim order above passed will stand automatically vacated.
Please. Great.
Counsel for the petitioner shall furnish 2 sets of the petition along with annexures on the learned AGA. The learned AGA is direct secure
Yes,
with,
ma'am.
the original records.
Please.
What we kindly pardon, these 2 serial number 3 interim order is there. We kindly
Interim order.
sorry, madam.
Serial number 52.
Ready, Adra? Please.
On 1/9/1970,
ಒಂದ್ ನಿಮಿಷ ರೆಡಿ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗಿರೋದ್ರಿಂದ ತಮ್ಮದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಐತೆ, ಲಾಟ್ಸ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಐತೆ.
ರೆಡಿ ಫೈಲ್ ಇದೆಯಾ ಹೇಳಿ
ಪ್ಲೀಸ್.
ಆಮೇಲೆ ಫೈಲ್ ಇಲ್ಲ ಅಂತ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡೋದು ಬೇಡ.
The land, my lord, in survey number 59, measuring 2 acres in survey number 59 of Lakkinayaknalli village, Kasba Hobbli, Chikbalapura Taluk. But I was granted in favor of the grandfather of the respondent number 5. My lord, the land grant consultative committee, my lord, took a decision to grant the land on 1/9/1970.
Under which act?
Land grant rules.
Land.
My lord, under the land grant rules only, my lord, there is a land grant consultative committee could take a decision. My lord, rule 24, my lord, for a moment. Land grant rules. My lord, rule 24. My lord, subclass 4. The committee shall be consulted. This is the constitution of consultative committee for the grant of land.
Yes.
My lord, it refers, my lord, page number 34, along with the petition.
34.
Please, ma'am. Typed copy of the page number 33, 34 produced. Reference, my lord, may kindly. Reference. Resolution of the land grant consultative committee meeting dated 1/9/1970. My lord, based on that, my lord, consultative committee decision, my lord, the directed to prepare the sketch and. My lord, on, my lord, 29/4/1970.
Was granted because of their status as a scheduled caste?
Yes,
or
me. Yes,
on the basis of the income
no, my lord, as a status of state, scheduled caste.
considered.
Please. But the grant certificate shows he purchased the land by paying kimmat in the public action. By paying the kimmat amount.
Saying both of them are contradictory.
My lord, I have produced the grant certificate. My lord, page number 20. My lord, typed copy, my lord, start from page number 22. ಹಿಡುವಳಿಯಲ್ಲಿಲ್ಲದ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ವಿಲೇಮಾರಿ ಮಾಡಿ ಹಿಡುವಳಿ ಹಕ್ಕನ್ನು ಕೊಡುವುದಕ್ಕೆ ಏರ್ಪಟ್ಟ ನಿಬಂಧನೆಗಳ ಮೇರೆಗೆ ಈ ಕೆಳಗೆ ಬರೆಯಲ್ಪಟ್ಟಿರುವ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿ ವಿವರಿಸಲ್ಪಟ್ಟಿರುವ ಜಮೀನು ವಿಕ್ರಯಿಸಲ್ಪಟ್ಟು ಏಕೆ ನಂಜಪ್ಪ ಬಿನ್ ಮೇಲೂರಪ್ಪ ಎಂಬುವರು ಬಹಿರಂಗವಾದ ಹರಾಜಿನಲ್ಲಿ ಅಥವಾ ನಿಯಮಿತವಾದ ಸರ್ಕಾರಿ ಕಿಮ್ಮತ್ತಿಗೆ ಕೊಂಡುಕೊಂಡಿರುವುದರಿಂದಲೂ ಮತ್ತು ಸದರಿ ಹರಾಜು ಕ್ರಮವಾಗಿ ಮಂಜೂರು ಮಾಡಲ್ಪಟ್ಟಿರುವುದಲ್ಲದೆ ಏಕೆ ನಂಜಪ್ಪ ಎಂಬುವರು ಸದರಿ ಜಮೀನಿನ ಕ್ರಯದಾರರೆಂದು ಕ್ರಮವಾಗಿ ಪ್ರಕಟಿಸಲ್ಪಟ್ಟಿರುವುದರಿಂದಲೂ ಮತ್ತು ಸದರಿ ಏಕೆ ನಂಜಪ್ಪ ಎಂಬುವರು 60/2 ರೂಪಾಯಿಗಳ ಕ್ರಯದ ಮೊಬೈಲ್ಗಿನ ಪೂರ ಹಣವನ್ನು ಸರ್ಕಾರಿ ಚಲಾವಣೆಗೆ ಪಾವತಿ ಮಾಡಿರುವುದೆಂದು. Annexure C, my lord, page number 29. My lord, they having tendered the kimmat. Page number 29, my lord, it's typed copy page number 31.
Offset price,
Please, page number 29, my lord, Irsal Patti receipt.
offset price of 200 of land granted out of survey number 25 to Sri Nanjappa.
Please.
Granted ಅಂತಿದೆ ಇಲ್ಲಿ.
ಹೌದು. ಇಲ್ಲಿ ಸಾಗುವಳಿ ಚೀಟಿಯಲ್ಲಿ ಹಂಗೈತೆ.
ಅಲ್ಲ ಅಥವಾ ಅಂತಿದೆ ಅಲ್ಲ
ಅಲ್ವಾ?
ಇಲ್ಲಿ.
ಎಸ್ ಮೇಲ್.
ಹರಾಜಿನಲ್ಲಿ ಅಥವಾ
ಅಥವಾ
ನಿಯಮಿತ
ಸರ್ಕಾರಿ ಕಿಮ್ಮತ್ತಿಗೆ
ಸರ್ಕಾರಿ ಕಿಮ್ಮತ್ತಿಗೆ
ಕೊಂಡುಕೊಂಡಿರುವ
ಅಥವಾ is what is attracted here. ಹೊಡೆದಾಕ್ಬೇಕಾಗಿತ್ತು, ಹೊಡೆದಾಕಿಲ್ಲ.
Anyhow, my lord, the land has been, my lord, granted on, my lord, 29/4/1972. My lord,
Upset price.
please. 29/4/1972, my lord, there is a grant in L&D number 742/1968-69. My lord, the Saguli cheat came to be issued, my lord, in the month of March 1973.
29/4/72
is a grant. My lord, the Sagoli cheat came to be issued in the month of March 1973. My lord, the grantee, my lord, prohibited from alienating the property for the period of 15 years. My lord, the Sagoli cheat itself, my lord, depicts the prohibition clause. But page number 20 is the, my lord, Sagoli cheat. 21, my lord, column number, serial number 7, my lord, there is a condition was imposed, they were written in hand.
Serial number 7,
please, page number 21. ಹದಿನೈದು ಕೈಯಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ ಸರ್. 15 ವರ್ಷಗಳ ಕಾಲ ಪರಬಾರೆ ಮಾಡಕೂಡದು. Now, my lord, the grantee, my lord, the sold the land measuring 1 acre out of 2 acres in favor of the petitioner, my lord, on 19/6/1997. Please. My lord, prior to execution of the sale deed, my lord, the grantee made an application before the assistant commissioner and sought for issuance of no objection certificate to sell the property. My lord, the permission was accorded. My lord, kindly come to, my lord, page number 37. Page number 37. My lord, the typed copy, 38, my lord.
Yes.
You may read, my lord, Vishaya. ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಲಕ್ಕಿನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿ ನಂಜಪ್ಪ ಬಿನ್ ಮೇಲೂರಪ್ಪರವರು ಗ್ರಾಂಟಿ ಮೇಲೋ ಜಮೀನು ಮಾರಾಟ ಮಾಡಲು ನಿರಾಕ್ಷೇಪಣಾ ಪತ್ರ ಕೋರಿ ಅರ್ಜಿ ನೀಡಿರುವ ವಿಚಾರ ಉಲ್ಲೇಖ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಹಸೀಲ್ದಾರ್ ಸೋನ್ಸು ಕೆಳಗಡೆ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಲಕ್ಕಿನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 59ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನು ನಂಜಪ್ಪ ಬಿನ್ ಮೇಲೂರಪ್ಪರವರಿಗೆ ದರಖಾಸ್ತು ಮೂಲಕ 15 ವರ್ಷಗಳ ಕಾಲ ಪರಭಾರ ಮಾಡಬಾರದು ಷರತ್ತಿನಂತೆ ಮಂಜೂರಾಗಿರಲ್ಪಟ್ಟ ಅರ್ಜಿದಾರ ನಂಜಪ್ಪ ಎಂಬುವರು ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಲು ಅನುಮತಿ ಕೋರಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಅರ್ಜಿದಾರರ ಬಗ್ಗೆ ತಹಸೀಲ್ದಾರ್ ಅವರು ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ಉಲ್ಲೇಖಿಸಿದ ವರದಿಯಂತೆ ಅರ್ಜಿದಾರರಾದ ನಂಜಪ್ಪ ಬಿನ್ ಮೇಲೂರಪ್ಪ ಆದಿ ಕರ್ನಾಟಕ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿತ್ತು. ಇವರು ಪರಿಶಿಷ್ಟ ವರ್ಗಕ್ಕೆ ಸೇರಿದ್ದರಿಂದ ಪರಭಾರೆ ಅವಧಿ 15 ವರ್ಷಗಳು ಆಕ್ಚುಲಿ ಮುಗಿದಿರುವುದರಿಂದ ಇವರು ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಿಕೊಳ್ಳಬಹುದು ಎಂಬುದಾಗಿ ನೀಡಲಾದ ನಿರಾಕ್ಷೇಪಣಾ ಪತ್ರ. The applicant was directed to pay a sum of rupees 3,450, my lord. In the bottom, my lord, it's fine. Page number 40, my lord, the grantee had tendered, my lord, amount 3,450 to sell the 1 acre land in favor of the petitioner. Please. My lord, the grandson of the grantee initiated the proceedings against the petition. My lord, the petition was filed before the assistant commissioner, my lord, on
sale deed date, you know?
Lord, sale deed date, my lord, 19/6/1997. Please.
Permission was in 1990. Proceedings were initiated by grandson.
Please, my grandson, My lord, the respondent number 5, Muni Nanjappa. He filed a petition on my lord 29/6/2008 before the assistant commissioner. My lord, before the land assistant commissioner, the petitioner was my lord, orders, my lord, appears, my lord, he did not participate the proceedings and order of presumption has been passed. Then the petitioner challenged before the deputy commissioner by filing the appeal. The appeal also dismissed by confirming the order passed by the assistant commissioner. My lord, there are, in this case, my lord, there are only two submissions, my lord. One is regarding, my lord, there is a inordinate delay of 11 years, 1 month, nearly 1 month, in initiating the proceedings from the date of sale deed.
What do the assistant commissioner and deputy commissioner say about the permission?
Please, my lord, before the assistant commissioner, my lord, the petitioner, my lord, remains unrepresented. But before the deputy commissioner, my lord, there are reference, my lord, regarding securing the permission. Well, page number 15, last para, my lord, may I permit me to read? Page number 15, last para.
Yes.
ವಾದಿಯು ತನ್ನ ವಕೀಲರ ಮೂಲಕ ಸಲ್ಲಿಸಿರುವ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಲಕ್ಕಿನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 59ರ 2 ಎಕರೆ 2 ಕುಂಟೆ ಜಮೀನಿನ ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನು ದಿನಾಂಕ 23/6/97ರಂದು ನೋಂದಣಿ ಕ್ರಯಪತ್ರ ಸೋನ್ಸೋರಂತೆ ವಾದಿಯು ಖರೀದಿಸಿದ್ದು. ಸದರಿ ದಿನದ ವಾದಿಯು ಖರೀದಿಸಿದ ದಿನದಿಂದ ಸ್ವಾಧೀನದಲ್ಲಿರುವುದಾಗಿ, ಕ್ರಯಪತ್ರದನುಸಾರ ಅವಶ್ಯಕ ನಮೂದುಗಳು ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ಆಗಿರುವುದಾಗಿ, ವಾದಿಯು ಸರ್ಕಾರಕ್ಕೆ ಕಂದಾಯ ಸಹ ಕಟ್ಟುತ್ತಿರುವುದಾಗಿ, ವಾದಿಯು ಸದರಿ ಜಮೀನನ್ನು ಖರೀದಿಸುವ ಮುಂಚೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಯು ಸದರಿ ಜಮೀನನ್ನು ಖರೀದಿಸುವ ಸಮಯದಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಉಪವಿಭಾಗರವರಿಂದ LND-CR 13/1989/90 ದಿನಾಂಕ 22/10/1990 ರಂತೆ ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು, ಅದರನುಸಾರ ವಾದಿಯು ಸದರಿ ಜಮೀನನ್ನು ಖರೀದಿಸಿರುವುದಾಗಿ, ಎರಡನೇ ಪ್ರತಿವಾದಿಯು ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿರುವ ಬಗ್ಗೆ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಅದನ್ನು ನಂಬಿ ಸದರಿ ಕಿಮ್ಮತ್ತು ಬೆಲೆಗೆ ಮಂಜೂರಾಗಿರುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟಪಡಿಸಿರುವುದಾಗಿ, ಒಮ್ಮೆ ಕಿಮ್ಮತ್ತು ಬೆಲೆ ಪಾವತಿಸಿದಲ್ಲಿ ಪರಭಾರ ಷರತ್ತಿನ ಪ್ರಶ್ನೆ ಬರುವುದಿಲ್ಲವೆಂದು ಕೆಳ ನ್ಯಾಯಾಲಯವು ಇಲ್ಲಿನ ವಾದಿಗೆ ಯಾವುದೇ ಅವಕಾಶ ನೀಡದೆ ಅಸಮ್ಮತವಾದ ಆದೇಶ ಮಾಡಿರುವುದಾಗಿ, ಆದ್ದರಿಂದ ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಲು ಕೋರಿದೆ. My lord, this ground was urged before the my lord. This ground, my lord, next para, my lord. ಎರಡನೇ ಪ್ರತಿವಾದಿಯು ತನ್ನ ವಕೀಲರ ಮೂಲಕ ಸಲ್ಲಿಸಿರುವ ಆಕ್ಷೇಪಣೆಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಪ್ರಸ್ತುತ ಮೇಲ್ಮನವಿಯು ನಿರ್ವಹಣಾ ಯೋಗ್ಯವಲ್ಲವೆಂದು ವಾದಿಯು ತನ್ನ ಮೇಲ್ಮನವಿಯ ಪ್ಯಾರಾ 2ರಲ್ಲಿ ತಿಳಿಸಿರುವ ಅಂಶ, ಅಂದರೆ ಎರಡನೇ ಪ್ರತಿವಾದಿಯು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಉಪವಿಭಾಗರವರಲ್ಲಿ LND-CR 13/89/90 ದಿನಾಂಕ 22/10/90ರಂತೆ ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿದ್ದೆ ಎಂದು ತಿಳಿಸಿರುವುದು ಸುಳ್ಳೆಂದು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಲಕ್ಕಿನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಹಳೆ ಸರ್ವೆ ನಂಬರ್ 25 ಬ್ಲಾಕ್ ನಂಬರ್ 2 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 59ರ 2 ಎಕರೆ 2 ಗುಂಟೆ ಜಮೀನು ಎನ್ ಅಂಜಪ್ಪ ಬಿನ್ ಮೇಲೂರಪ್ಪರವರಿಗೆ LND 748/1968/69 ರಂತೆ ಮಂಜೂರಾಗಿ ದಿನಾಂಕ 13/3/1973ರಂದು 15 ವರ್ಷಗಳ ಪರಭಾರ ಷರತ್ತಿನ ಮೇರೆಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿರುವುದಾಗಿ, ಮೂಲ ಮಂಜೂರಿದಾರರು ಎರಡನೇ ಪ್ರತಿವಾದಿಯ ತಾತ ಅಮಾಯಕರು, ಅನಕ್ಷರಸ್ಥರು ಹಾಗೂ ಸಾಮಾನ್ಯ ಜ್ಞಾನ ಇಲ್ಲದವರೆಂದು ಅದನ್ನು ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡು ವಾದಿಯು ಸರ್ಕಾರದಿಂದ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಕ್ರಯ ಮಾಡಿಸಿಕೊಂಡಿರುವುದಾಗಿ, ವಿವಾದಿತ ಜಮೀನನ್ನು ಪರಿಶಿಷ್ಟ ಜಾತಿಯವರಿಗೆ ಪರಭಾರ ಷರತ್ತಿನನ್ವಯ ಮಂಜೂರಾಗಿರುವುದಾಗಿ, ಆದ್ದರಿಂದ ಈ ಸಂಬಂಧ ವಾದಿಗೆ ಆಗಿರುವ ಕ್ರಯವು ಊರ್ಜಿತವಲ್ಲವೆಂದು, ಈ ಸಂಬಂಧ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಉಪವಿಭಾಗರವರು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ತನಿಖೆ ನಡೆಸಿ ಎರಡನೇ ಪ್ರತಿವಾದಿಯ ಪರ ವಿವಾದಿತ ಜಮೀನನ್ನು ಪುನರ್ ಮಂಜೂರಾತಿ ಮಾಡಿರುವುದು, ಆದ್ದರಿಂದ ಪ್ರಸ್ತುತ ಮೇಲ್ಮನವಿಯನ್ನು ವಜಾಕರಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಉಪವಿಭಾಗರವರು ಸಂಬಂಧಪಟ್ಟ ಕಡತವನ್ನು ಸಲ್ಲಿಸಿಕೊಂಡಿದ್ದು, ಸದರಿ ಕಡತ ಮತ್ತು ಪ್ರಸ್ತುತ ಕಡತದ ದಾಖಲಾತಿಗಳನ್ನು ಪರಾಮರ್ಶಿಸುತ್ತದೆ. ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಲಕ್ಕಿನಾಯಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 25ರ ಪೈಕಿ ಎರಡನೇ ಬ್ಲಾಕ್ 2 ಎಕರೆ ಜಮೀನು ಎಕೆ ನಂಜಪ್ಪ ಬಿನ್ ಮೇಲೂರಪ್ಪರವರಿಗೆ ದರಖಾಸ್ತು ಕಡತ ಸಂಖ್ಯೆ LND 748/1968/69 ರಂತೆ ಮಂಜೂರಾಗಿ 15 ವರ್ಷಗಳ ಪರಭಾರ ಷರತ್ತಿನ ಮೇರೆಗೆ ಮಾರ್ಚ್ 1973ರಂದು ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ಮೂಲ ಮಂಜೂರಿದಾರರು ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ ಆದಿ ಕರ್ನಾಟಕ ಸೇರಿರುವುದು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಕಂಡುಬರುತ್ತದೆ. ಕ್ರಯಪತ್ರ ಸಂಖ್ಯೆ 533/1997/98 ದಿನಾಂಕ 23/6/97ರಂತೆ ವಾದಿ GP ಕುಲಶೇಖರ್ ಅವರಿಗೆ ಮೂಲ ಮಂಜೂರಿದಾರರಿಂದ ವಿವಾದಿತ ಜಮೀನು 2 ಎಕರೆ 2 ಕುಂಟೆ ಪೈಕಿ 1 ಎಕರೆ ಜಮೀನು ಮಾರಾಟವಾಗಿರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ವಿವಾದಿತ ಜಮೀನು ಮೂಲ ಮಂಜೂರಿದಾರರಿಂದ ಪರಭಾರ ಷರತ್ತು ಅವಧಿ ಮುಕ್ತಾಯಗೊಂಡ ನಂತರ ಮಾರಾಟ ಮಾಡಿದ್ದು, ಸರ್ಕಾರದಿಂದ ಯಾವುದೇ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಮಾರಾಟ ಮಾಡಿರುವುದು ಕಂಡುಬಂದಿರುತ್ತದೆ. ಹಾಗೂ ಈ ಸಂಬಂಧ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ವಿಭಾಗರವರು ಪರಭಾರೆ ಮಾಡುವುದಕ್ಕೆ ನೀಡಿರುವ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರ ಊರ್ಜಿತವಾಗುವುದಿಲ್ಲ. ವಿವಾದಿತ ಜಮೀನು 60 ಮಂಜೂರಿ ಬೆಲೆಯ ಮಾರುಕಟ್ಟೆ
Who is the
ಬೆಲೆಗೆ
authority to grant permission?
Deputy Commissioner.
Assistant Commissioner could not have granted.
Assistant Commissioner is not having any power
the authority to grant is this. My lord, not
Was it delegated in Chikbalapura? Was it delegated to give this permission?
has no power.
Now, my lord, even my lord, keeping aside this aspect granting the permission, my lord, the apparent, my lord, there is a bar by limitation. The division bench of this honorable court, my lord, 7 years delay has not been condoned in ethical matters. My lord, here, my lord, there is admitted 11 years, 1 month delay in filing the petition. My lord, the land grant rules, my lord, the act itself is not attractive. My lord, there are, my lord, my lord,
As per the Amendment Act, there is no limitation.
Was an application submitted by the grantee?
Please, my
no.
lord,
Was submitted.
submitted
And Assistant Commissioner granted.
to the Assistant Commissioner. Assistant Commissioner has given permission to
Is
the
granted it.
land.
Third party purchaser will go by what is granted. What permission is granted. How did you Assistant Commissioner grant the permission?
He has no form.
How did he grant it? What action have you taken against him?
Please, my lord, they have not taken any action. ಈಗ ತಗೊಳ್ಳಿಕ್ಕೆ ನಾವು ಇನಿಷಿಯೇಟ್ ಮಾಡಿ
ಇಲ್ಲಪ್ಪ ಅವ್ರು ಏನೇನೋ ಅವ್ರ ಪವರ್ ಇಲ್ಲ ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಾ. ಅವ್ರ ಮೇಲೆ ನೀವೇನು ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ. The people will rely on that order and act on it. So if you don't take any action, they'll continue to.
has to take action against the Assistant Commissioner.
So now that you have done, can a third party purchaser who is bona fide
Please.
be deprived of it? You're madilla application to a wrong authority. The grantee made the application.
Grantee made the application to the Assistant Commissioner.
Assistant Commissioner
Assistant Commissioner issued the NOC.
as issued. Thereafter, they said, pay this money in that order.
The competent
amount has
authority is
been
the Deputy
paid.
Commissioner, my lord. Competent authority is the Deputy Commissioner. He has to
Amount
issue,
has been paid. You have collected the money.
collected the,
You have not taken any action against the Assistant Commissioner. You have not refunded the money. You have not said cancelled.
will initiate the action against the Assistant Commissioner.
You have to take action against him to contend that he has no power. You will do whatever you want without power. But they have to suffer, Andre. You are appearing for the Assistant Commissioner. Is he still in service or no?
Which year is done?
97 ಅಲ್ಲಿ permission ಕೊಟ್ಟಿದ್ದಾರೆ.
On 22/10/1990, 90.
ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇರಲ್ಲ.
1990.
ಚಾನ್ಸ್ ಇಲ್ಲ. 34 ವರ್ಷ ಆಯ್ತು. 90 ಎಂಟ್ರಿ ಆದ್ರೇನೆ ರಿಟೈರ್ ಆಗಿರ್ತಾರೆ. This will be
Document ನ relay ಮಾಡ್ಬೋದು. Document certified copy.
Yes, certified copy produce.
get the records of that.
My lord, will verify original of that, my lord, originals,
If
please.
that is there,
Yes, my lord.
then you have a problem.
Yes, please.
But
Will-
that doesn't mean that you suppress it and get a file without it.
No,
Yeah,
no.
produce the certified
Whatever the
copy.
originals will, I'll secure, my lord.
3,450 ದುಡ್ಡು ಕಟ್ಟಿದ್ದಾರೆ.
Yes, my lord.
ನೀವು accept ಮಾಡಿದೀರಾ.
We'll secure that file and we'll verify, my lord. ಅದ್ ನೋಡೋಣ ಅವ್ರು ಕೊಟ್ಟಿದಾರೋ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
Unless you have to show
Please, my lord.
that they have colluded, Assistant Commissioner and the purchaser has colluded.
Yes, my lord.
Then
I got purchase after lapse of 7 years from the date of.
Subsequent purchaser, he may be.
After lapse of 7 years, my lord, what, my lord, the bona fide purchaser can do. If it is immediately same year, my lord, same month, my lord, there may be. We could establish the doubt of creation. After lapse of 7 years, my lord. My lordship, in the identical matter, my lordship held in the judgment, my lord, land grant rules where the land was granted with no PTCL Act will not be attracted.
That also you need to show us from the record.
Yes, ma'am.
On what basis this grant was
Granted in.
made for a person belonging to a scheduled caste, then that PTCL will apply.
Yes,
If not, then PTCL will not apply.
yes, ma'am. We'll verify from the records.
The submission of the learned counsel for the petitioner, firstly, is that the grant of the land was made under the land grant rules
Note money.
pursuant to the recommendation made by the land grant consultative committee in terms of Rule 24 of the Karnataka Land Grant Rules 1969.
File it.
And as such, the skilled care PTCL Act will not apply. The second submission made by him is that the purchase made by the petitioner on 23/6/1997 was pursuant to the permission granted by the Assistant Commissioner dated 22/10/1990 for sale of the property. And as such, he submits that no proceedings could have been initiated for resumption, nor could orders passed thereon after such permission was granted.
Please.
Learned HCGP would submit that the Assistant Commissioner is not an authorized officer to grant the permission, it's only the Deputy Commissioner. He is directed to produce the records pertaining to the said order and also to verify and make a submission if there was any delegation
Please.
of authority to the Assistant Commissioner.
Please.
He is also directed to place on record the details of the original grant, comma, whether it was made under the land grant rules
64. 64.
1969
Yes.
or was made to a person of the depressed class stroke SC/ST on the basis of his status. Released on
2 weeks, my lord.
21st.
Please, ma'am.
Oblate.
Serial number 53, SV Prakash.
My lord, I appear for petitioner.
For the respondent, my lord.
Yes.
My lord, the land, my lord, that is, my lord, 5 acres of land in survey number 212/9 of Vasur village in Shikaripura Taluk was, my lord, granted in favor of, my lord, the original grantee Nyamya Naika. My lord, out of 5 acres, my lord, the father of the petitioner purchased 2 acres from the original grantee under a registered sale deed. My lord, the fourth respondent, she claims to be, my lord, the wife of the adopted son of the original grantee. My lord, she makes an application, my lord, before the Assistant Commissioner on 18/6/2004 to declare the sale as transaction as null and void and for restoration after resuming the land to the government. My lord, this order, they based on that, my lord, the Deputy Commissioner, page 39, Annexure B. My lord, the Assistant Commissioner on 23rd January 2006, my lord, dismissed the application on the ground that the possession of the purchaser 12 years prior to, my lord, coming into force of the act, my lord, matured into a title by law of adverse possession, placing reliance on the judgment of the Honorable Apex Court, my lord, report in the case of K.T. Huchegowda and Deputy Commissioners and others. My lord, he dismissed the application. My lord, the purchaser Chikkappa, my lord, died, my lord, on 8/10/2008. My lord, this order of the Assistant Commissioner was challenged by way of an appeal before the Deputy Commissioner by the, my lord, fourth respondent. My lord, your lordship kindly take page 42, my lord, that is the order. Your lordship kindly see, the appeal was filed, my lord, in the year 2006-07. My lord, that is immediately after the order of the Assistant Commissioner dated 23/1/2006. My lord, order is passed, my lord, order is passed, my lord, on 16/3/2016. 13 years after, my lord, Your Lordship, kindly see the order sheet I have produced, my lord, page 51, annexure E. My lord, typed copy also I have furnished, but before that, my lord, I invite my lord's attention to ink page 52. Ink page 52. My lord, case on 2/4/2009, this is on 2/4/2009. Case called, both the counsel present. Written arguments have been filed. They are taken as heard. Posted for orders. This happened on 2/4/2009. Then, my lord, it was called again as per the order sheet 19/5/2015. Case is recalled. Case is recalled on 9/7/2015. That is after a lapse of almost, my lord, 6 years. Then, my lord, 9/7/2015, case called Advocate for Respondent appeared and prayed to accept the argument. Adesha. This, my lord, the order is passed. My lord, I furnished typed copy at annexure E, page 56.
You are the appellant there.
No, I am respondent. I am respondent. There is no notice issued to anybody. And purchaser died, my lord, 2008. This order is
respondent present ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ ಅದಿಲ್ಲ, ಅದು ಎಲ್ಲಿ notice, my lord, the order sheet shows that, my lord, on 2/4/2009. 2/4/2009. ಅದು ನಾನು ಆತರ 2/4/2009 ಅದು 7 ಇದೆ. 7 ಆದ್ಮೇಲೆ case called appellant counsel present and he has already filed written argument. Respondent counsel present, files written argument, posted for orders. ಅದು 38 ಅಂತಿದೆ 2007ಕ್ಕೆ. ಬಟ್ ಅದು ಕರೆದಿಲ್ಲ 2/4/2009. ಅದು 9 ಬರೀತಾರೆ. ಅದು 9/7 ಅಲ್ಲಿ. Case called both counsel present, already written argument have been filed. They are taken as heard. Posted for orders. ಇದು 2/4/2009. ಆಮೇಲೆ 19/5/2005 case is recalled.
And all these orders seem to be by different officers. The signatures are different.
There must be a notice. This is one aspect. Another aspect is I have produced the death certificate, page 50. My lord, I have produced the death certificate of the purchaser. My lord, it is at annexure C, my lord.
41, my lord.
Page 41. Chikkappa, the purchaser against whom proceedings are initiated, died on 8/10/2008. His LRs were not brought on record. The deputy commissioner order allowing the appeal and overturning the order of the assistant commissioner, resuming the land and direction to restore against dead person. And there is no notice. This is the second aspect. Therefore, your lordship is aware that, my lord, in order.
This is even worse. Orders, it was posted for orders on 38/2007.
Please, ma'am.
No basis, but on 2/4/2009, it was called. He records that advocate, both counsels are present.
Please.
Why were both counsels present on 2/4/2009 without notice being issued? ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು ಎಲ್ಲಾರ್ಗು? To be present at ಇವತ್ತು ಕರೀತಾರೆ ಸಾಹೇಬ್ರು, ಇರಬೇಕು ನಾವು ಅವ್ರ ಮುಂದೆ. Then again, it was posted for orders. Again, 19/5/2015. Case is recalled.
Yes, ma'am.
On what basis? No reasons. And all the signatures of the deputy commissioner on 38/07, 2/4/2009, 19/5/2015, 9/7/2015, and 16/3/2016. They're all different signatures by different officers.
My lord.
It appears different officers.
Maybe different officers, my lord, they would have transferred and, my lord, order sheet.
So the person who is heard will have to pass orders.
Please, ma'am.
It was heard only on 3807. There was no argument thereafter.
Yes, my lord.
How can a person who has not heard anything pass orders? Kashta, you are put in a difficult position because of them.
Yes,
This is,
procedures properly not followed. Shivamogga Deputy Commissioner.
Now, the third point is, my lord,
Hmm.
the application was made in 2004. My lord, that can't be said to be, my lord, within reasonable time. Regard being had to, my lord. the
that's a different aspect.
No, of course,
That
of
we
course.
consider on
Of
merits.
course, of course.
There is no signature of the councils
Yes, my lord, I can say.
to accept this also.
My lord, 9/7/2015, my lord, orders were pronounced on, my lord, 16/3. Again, after, my lord, 1.5 years, almost 1 year.
File an affidavit of your counsel that you, whether you appeared or not on that, whether he appeared on or not on that day.
That day, my lord, I made a statement in the petition, but
File
anyway,
an
my lord.
affidavit of the counsel. If
Counsel,
we are to take it with seriousness, then we'll need the affidavit on record. Not on a mere statement. The submission of Shri S.V. Prakash, learned counsel, for the petitioner is that arguments were heard on 38/2007 and written arguments were also filed. And matter posted for orders without a date being fixed. Subsequently, on 2/4/2009, case was apparently called out. Both the counsels were present. Written arguments were filed. And the matter was posted again for orders. No orders have been passed. On 19/5/2015, the case was recalled and adjourned to 9/7/2015. When the case was called out, it is noted that the advocate for respondent and appellant were present, who prayed for orders to be passed. Hence, again, the matter was posted for orders and finally orders was passed on 16/3/2016. His submission is that the counsel for the respondent, who is the petitioner herein, was not present on 9/7/2015, he having no notice of the said matter. Furthermore, the respondent had expired on
2008, my lord, Annexure C, page
Page
2008. 8/10/2008, Annexure C, page 41.
8/10/2008. Thus, the order passed is against dead person. A perusal of the order sheet would indicate that the signatures of the deputy commissioners for each of the above orders looks ex facie different. The arguments were only advanced on 38/2007 and thereafter written arguments were filed. From 2007 to 2015 or till the date of the order, that is 16/3/2016, there were no arguments advanced before the presiding deputy commissioner. It cannot be presumed that the same deputy commissioner continued from 2007 to 2016.
Listen.
Hence, learned AGA is directed to place on record the names of the deputy commissioners of Shivamogga district from 3807 to 16/3/2016.
Please.
To also place on record if there was any notices issued on 2/4, prior to 2/4/2009, prior to 19/5/2015, to the parties calling upon them to be present.
Please, my lord.
As if There is no such record. And there is no explanation offered. Action would have to be initiated against the concerned officers. Released on 21/6.
Blame.
54, SV Prakash.
Lord, Lord, I appear for petitioner.
Records ಬಂದಿದ್ಯಾ?
Please, my lord, records. I have received the records, my lord, has. I told
ನೋಡ್ಬೇಕಾ?
you, please, my lord, I have to verify original records.
Mr. Ananda, and AGA submit that the original records have been received.
Yes, ma'am.
She however requires 10 days time to go through the same and make a
Please,
submission.
please, ma'am.
Released on 21/6.
55. PS Osmats.
None appears for the parties, though called twice, once in the morning session, once in the afternoon session. If none were to appear for the petition on the next date of hearing, petition would be liable to dismiss for non-prosecution. Released on 21st June.
59. R Swaminathan.
Petitioner. This is the original records, my lord. Assistant Commissioner Chitradurga, my lord. Assistant Commissioner Chitradurga is present, my lord. Same, my lord. Proceedings filed, they have sent, my lord. Original records, my lord. He wants 1 week time to secure, my lord.
Why does he need 1 week time
My
so
lord.
many times?
Please, my lord, but is a newly.
Sir, Lordship. Actually, Tahsildar office is the custodian of this record, sir, Darkhast file. We have constituted a special team for search of that Darkhast file, sir. We played 1 more week time for searching the records and the place in.
Searching the records.
Yes.
My lord, it is misplaced and they say, my lord, misplaced. We have to rebuild the file, my lord. Then
We are finding lot of
original records,
with
revenue
these
department.
authorities on SCST matters.
Please, my lord.
It is wanton, it is not negligent,
Yes, my lord. Lot of,
and it is not misplaced. There is an order passed on 4/2/2020.
please, my lord.
Sorry, 23/1/2020.
Yes.
Produce the original records.
Yes, my lord.
No original records were sent. The Assistant Commissioner was directed to be personally present.
Yes, my lord.
We'll observe, we heard at the end. While order dated 23/1/2020, this court had directed the government advocate to secure the original records
This file,
immediately.
where is this file?
Matter being taken up on 4/2/2020. It is submitted that the records have not been received, hence this court directed the Assistant Commissioner Chitradurga to be personally present on 13/2/2020 with the original records. On 13/2/2020, Shri Prasanna, the then Assistant Commissioner, was present and sought for a week's time to produce the original records. Thereafter, the same was not produced, hence when listed on 22/2020 was adjourned to 17/3/2020. On 17/3/2020, once again adjourned to 31/3/2020. And thereafter, again on 5/11/2020, 25/11/2020. And several other dates. Once again, this court on 26/11/2020 directed the SCGP to secure the records, original records. On 22/12/2021, learned SCGP submitted that he has received certified copy of the records. However, this court directed the SCGP to secure the original records. Thereafter, despite which till date, the original records have not been secured. This court, while ordered 31/5/2024, had once again directed the original records to be produced in terms of the earlier orders. and if not so secured, for respondent number 3 to be personally, respondent number 3, Assistant Commissioner to be personally present before this court. In pursuance thereof, we so and so the Assistant Commissioner is present
Please, my lord.
before this court. He submits that he is still in the process of securing those documents and seeks for a short accommodation to produce.
Please, my lord. 21st.
There's been a wanton non-compliance with the orders passed by this court from 23/1/2020 for nearly 4.5 years. It is rather shocking for the Assistant Commissioner to be present today and ask for further time when the order was passed on 23/1/2020, which was to be his knowledge, and those documents were to be produced. In the interest of just, though there is no further indulgence required to be given, extended, 1 week's time is finally granted to produce the records. If records are not produced on 14/6/2024, serious action would have to be taken against such non-compliance,
Please, my lord.
if necessary, by initiating an action for contempt. Released on 14 June 2024, the Assistant Commissioner shall be personally present on that date also. 4.5 years you have taken.
My lord.
4.5 years.
Please, my lord. Please.
Is this how efficient it is?
Submission, Lord. My lord, it's the Tahsildar office is custodian of that record.
Correct, yes, I am
We are not
also
concerned.
for that.
We have directed we have formed a special team for bringing to.
The Assistant Commissioner at this stage submits that the Tahsildar is the custodian of the documents. If that be so, the jurisdiction Tahsildar shall also be present before this court
Please, my
if the original records are not secured by them.
And sir,
We'll take action against both of you if you don't do that.
14th inconvenience, 21st one. Sorry for the issue. 14th some inconvenience. On 14th.
No problem. We won't hear you that day. First, let us get the documents. You waited 4.5 years, you can do that.
Much.
Serial number 67. Jayanta Pujari.
Sir, notice 67.
For respondent number 4.
You are appearing for the respondent?
Respondent number 4.
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ ನೀವು? ಎಲ್ಲ ನಿಮ್ದು you are not appearing in any of the matters. You are Bhargav ji.
Bhargav ji.
So please be present ji in all matters. A lot of matters are getting adjourned because you are not present. Ready? Ready?
Please.
Ready.
Lord, after lapse of 41 years, my lord, the son of the original grantee held an application before the Assistant Commissioner, my lord, for restoration of land for violation of PTCL Act. My lord, the original grant who in favor of Dodda Timmaya is, my lord, on 15/5/1956.
Dodda Timmaya
Dodda Timmaya
is the father of the respondent.
Please, I'll it to be father. 15/5/1956.
Sale?
Sale, first sale deed, my lord, on 15/7/1969. My lord, the extent of land is 8 acre 24 guntas granted, my lord. Out of which first sale, my lord, entire sale was, sale deed was in favor of Rudrappa. Thereafter, my lord.
69 entire.
69 entire 8 acre was sold by the original grantee in favor of Rudrappa.
In favor of?
Rudrappa.
Rudrappa.
Please.
Yes.
Next, my lord, on 19/4/1989, my lord, the petitioners, the first petitioner has purchased, my lord, 4 acre 12 guntas. And on the very same day, my lord, second petitioner also purchased by another sale deed, my lord, 4 acre 12 guntas.
Same 8 acre 24 guntas.
Please,
One the entire property, 2 sale deeds.
2 sale.
Yes, it was 1989,
89.
96,
2010, my lord.
1989.
Yes. After sale deed, my lord, revenue entry has changed. I have in possession of the property. I am enjoying the property. In the year 2010, my lord, even after lapse of even, my lord, 41 years from the first sale deed, 2010, my lord, the fourth respondent file application. My lord, for this set aside the sale deeds, my lord, 2 sale deeds which were executed, my lord, after inordinate delay, my lord, it was not considered. My lord, the assistant commissioner, my lord, as per annexure B, my lord, held that, my lord, it is in violation of section 4 of the PTCL Act, my lord, that sale deeds are set aside and ordered to be handed over the possession to the fourth respondent. I have
Confirmed by the deputy commissioner.
commissioner. My only submission, my lord, after 41 years, my lord, as per
What
Supreme
is the
Court,
explanation for 41 years?
my lordship, kindly press times, senior is inconvenience.
You are Bhargavji.
Our senior, my Bhargavji.
ಆಗ್ಲೇ you are Bhargavji and ಅಂದ್ರೆ ready na ಅಂದ್ರೆ
Parents
ಹ್ಞೂ
for
ಅಂದ್ರೆ.
Bhargavji.
So, learned counsel for the petition submit that the grant was made on 5/5/1956. The entire land granted, that is 8 acres 24 guntas, was sold in favor of Rudrappa on 15/7/1969. Who thereafter sold the said land in 2 portions. The first portion of 4 acres 12 guntas in favor of the first petitioner, and second portion of 4 acres 12 guntas in favor of the second petitioner on 19/6/1989.
1904.
19/6?
1904, 1989.
1904.
Please.
1904/1989. The application for resumption under section 5 was filed in the year 2010 after lapse of 41 years.
My lord, after
Which has
lapse
not
of
been
31
explained.
years, my lord. Here, my lord, delay can be taken 31 years, my lord. 1979 is the act, my lord.
Which has not been explained.
Please.
69.
And as such, he submit that the same being hopelessly delayed ought to have been considered by the assistant commissioner and the deputy commissioner. Wherein AGA would however submit that the delay can only be taken into consideration from the amendment to the act in the year 1979. And at the most, there could be a delay of 31 years. Learned counsel for respondent seeks fund is granted a week's time to make his submission. Relist on 14/6.
68.
I pay for the petitioner, ma'am. Petitioner is a grantee, ma'am.
Yes, just a minute. They've been served and unrepresented. Yes.
Please.
Ready?
Please.
Yes, madam.
So the petitioner's father and uncle were granted the land in 1956, my lord. The sale took place in 1972.
You are the grantee.
I'm the grantee, my lord, please. 3 acres of land in,
And date of grant?
date of grant is 19/8/1956, my lord.
Please,
And the Sagwali Chiti was given on 13/11/1958.
13/11.
1958.
Yes.
They were issued Sagwali checks. The grant was on 19th August 1956.
19th August
56, my lord.
1956, yes.
Please.
ಅದು ಹೇಳಿದ್ದೀರಾ?
The non-alienation period was for a period of 20 years, my lord.
Yes.
On 23rd March 1972 is the date of the sale, my lord. 2002,
the
the application
grantee.
is filed. I'm so sorry, ma'am.
By the grantee.
Please.
Please, my lord.
Hmm.
And 2002 is the date of which the application has been filed.
By?
The petitioner, who is the son.
Legal aids.
legal air.
Please, my lord, legal aids.
2001 and 2.
2001 or 2 na?
1 and 2, my lord.
1 and 2.
Please, Mr.
My lord, what happened thereafter? The Assistant Commissioner, my lord, by an order dated 23rd September 2002, he rejected the application on the ground that the non-alienation, on the ground that that the non-alienation period is 10 years, and saying that the sale had taken place prior to the commencement of the PTCL Act. That was challenged by me before the Deputy Commissioner. Deputy Commissioner allows my appeal. By order dated 23rd September 2012.
20?
I'm so sorry, 23rd November 2015.
23rd November 2015.
15 allows my appeal, my lord, saying that the non-alienation period is in fact 20 years, and considering that the PTCL Act is also applicable retrospectively. Thereafter, my lord, the purchaser approaches this honorable court, saying that there was a delay in filing of the appeal, and therefore the matter has to be, and therefore this honorable court remands the matter back. The order of this honorable court is on 22nd February 2016. The order, my lord, of this honorable court is at page 31.
Yes.
The counsel on both sides, after arguing the matter for some time, submitted the matter is not properly considered by the appellate authority, and the order also does not indicate whether the delay in filing the appeal was condoned or not, and hence the impugned order dated 23/11/2015 passed by the appellate authority, namely the Deputy Commissioner, may be set aside and the matter may be remitted to the appellate authority for reconsideration. On this point, my lord, the impugned order dated 23/11/2015 passed by the appellate authority is set aside. Matter is remitted to the Deputy Commissioner for reconsideration in accordance with law. All contentions for both the parties are kept open. Thereafter, my lord, the matter goes back before the Deputy Commissioner. 2017, my lord, on 27th November 2017, Deputy Commissioner rejects the appeal on the ground that there is the delay of 30 years in filing the application for restoration, and also saying that there is no ground for the condonation of the delay in filing of the appeal, my lord. Therefore, I filed for this court. I'm so sorry, my lord.
Filing the appeal.
Yes,
Appeal
please,
was
my lord.
delayed.
I'm so sorry.
Appeal was delayed or application was delayed?
My lord, application, 30 years. So the Deputy Commissioner says that there is a period of 30 years, and therefore he rejects my application, appeal. Now, my lord, firstly, my lord, the recent amendments that have come in to section 5, those, my lord, specifically apply to this to say that there is no limitation insofar as filing the application is concerned. If I may just take my lords to the.
Nobody is appearing. We'll have to appoint amicus. If that point has to be, because that has not been dealt with earlier. Mr. Prakash. Or ಮಾಡ್ತಾರಲ್ಲ ಬಡ SC/ST. You can appoint him as amicus.
Very well.
SV Prakash.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಯಾರ್ಯಾರು, is there anybody who has filed challenging the?
Yes, my lord.
Who has?
New amendment, my lord.
We'll appoint them only as, so double work will be seen.
I'll give name.
Except, my lord, the amendment is not under challenge here.
Not
It is
in
only
service,
insofar
you are
as.
pressing it into service.
Please, my lord.
There are petitions where somebody has challenged it.
Yes, very well.
Same lawyer can be appointed so that.
But that I don't have anyone is on that side, that's no issue on that front.
Time for people.
My lord,
Please.
I'll provide the name, my lord.
The respondent, those served. In the present matter, the grant was made on 19/8/1956. And Sagoli Chit was issued on 13/11/1958 with a non-alienation period of 20 years. On 23/1972, a sale deed came to be executed by the original grantee, which came to be the son of the original grantee filed an application in the year 2001-2 under Section 5 of the PTCL Act for the cancellation of sale deed and resumption. The Assistant Commissioner, while his order dated 23/9/2022, dismissed the said application firstly on the ground that the non-alienation period was only 10 years, and secondly on the ground that the sale had occurred before the PTCL Act came into force. The same having challenged before the deputy commissioner allowed the appeal, cancelled the sale deed and directed resumption of land by its order date 23/11/2015. The purchasers challenged the same by filing a writ petition in WP number 2901-2903 of 2016.
Please.
The said writ petition came to be allowed and the matter remanded to the deputy commissioner for fresh consideration. The deputy commissioner rejected the application filed by the son of the grantee on the ground that it was belated. There was no explanation for the delay of more than
30 years. my lord.
30 years.
My lord, 30 years.
22, 30 years, of nearly 30 years.
Please.
And therefore rejected the application filed by a son of the original grantee. It is this order which is challenged in the present proceedings. Notice having been issued to respond number 4, legal representative respond number 4. Were the petitioners in WP 2901-2903 of 2016, there is no appearance made. Shri U. Panduranga Nayak and Shri K.V. Satish Chandra, who had entered appearance for the petitioners in WP number 2901-2903 of 2016, are directed to accept notice. Counsel for the petitioner to serve copy of the petition along with annexure on the said counsels. Registry is directed to print their names as that appearing for respond number 4, B, C, and D. In the event of considering learned counsel for the petitioner also presses in service the recent amendment made to the what was the date?
2023, my lord.
1999.
1978 Act.
Also present to service the Karnataka Scheduled Caste and Scheduled Tribes bracket prohibition of transfer of certain lands bracket Amendment Act 2023, which came into force on 27/7/2023, by which amendment to Section 5 has been carried out.
Please.
Since none has appeared for the petitioners, for respondents, and a new argument is raised before this court on the basis of subsequent event, I deem it fit to appoint Shri so-and-so
Yes, ma'am.
as the amicus
Yes, ma'am.
to assist this court in the present matter. Adi yavatide?
14th ಗಿದೆ, all other matters.
We list
14th.
on 14th.
Should it be taken up with those, my lord, or
Work together.
very well,
That aspect once decided will put an end to all this.
very well, my lord.
My lord,
Please,
this
you are given the list
rules,
of-
my lord, this is the rules, conditions, my lord, which is the year wise, madam,
Sorry.
from which year, my lord, conditions was revealing rules, my lord, and that time.
No, we understand this,
Please, ma'am.
but if the Sagwadi chit says so and so,
Yes, ma'am.
can we refer to your circular
Yes,
to
ma'am.
say, no, ಅದು 10 years ಅಲ್ಲ 20 years ಅಂತ?
Yes, ma'am.
Sagwadi chit ಏನ್ ನೋಡಿದ್ರೆ ಅದು ನೋಡೋದು.
Yes, ma'am.
The problem is in all this, your officers commit the mistake.
Yes.
And then your officers only bring it to, no, that is not correct. And you don't take any action. Who suffers is a person who doesn't know anything about it.
Yes, my lord, that's happened.
This is all
That's
your
been happening.
internal. You cannot say my officer has committed a mistake, it is so and so. He has committed a mistake. Unless there's collusion,
Yes.
then we won't accept it. But if they are bona fide, why should they suffer?
Shouldn't,
Adu problem ಇದೆ.
problem.
If you show collusion, we'll accept your submission straight away.
Yes, ma'am.
Relist on 14th. Have you given that full list of all those
Yes, my lord, I have now. Today I'll submit. my lord.
body? Adella connect with so and relist on 14th.
My lord, my only submission is, the only reason I would not request for so that it's not connected is because even independent, my lord will obviously look into the wires of this.
Deal with each matter separately, though they are
Please, very well.
connected. But first, if that issue, everywhere it is being raised,
Please,
if we answer that issue,
please, my lord,
then we can take the matters individually on.
please, my lord, because
each of
the amendment itself otherwise is very clear, if not for that.
But if the amendment challenge is allowed,
Please, my lord, I understand
then you
that.
cannot bring it in service.
That I understand.
Today, under challenge, we cannot bring it into service.
But there is no order, interim order that has been passed to the best of my knowledge, my lord, as
Yeah,
I'm subject
All
to
those
correction.
matters Where the purchasers are challenged.
It's a question of challenge, my lord, certainly.
There are interim orders is what we are told.
Very well, my lord, it may be taken up on 14th and released.
69, SG Hegde.
For the petitioner, waiting for respond number 5 to 9. I make one submission. 11, 10 and 11 were wrongly undertaken by one of my colleague. Because he cannot undertaken, cannot be taken because.
Okay.
Again, 5 to 9 has sold it to 10, 10 has sold it to 11. That is the difficult.
Notice hogilwa?
Notice by idralli.
B. Ravindra Prasad, Lieutenant Counsel submits that he is only appearing for respond number 5 to 9. And by mistake, he had, his colleague had accepted notice for 10 to 11. His submission is that respond number 5 to 9 sold the property to respond number 10, who subsequently sold it to respond number 11. Again, there is no conflict actually.
No conflict because this sale. After that, what has happened? Next B, C is concerned, my lord. One more gift was executed by the respondent number 10. That is the only to the petition.
Where is the conflict? Conflict idea.
The same, but if they want to say something.
11 can claim only under 10. 10 can claim only under 5 to 9.
Yes.
Neither 10 and 11 can claim more than 5 to 9. If you are appearing for 5 to 9, you may, if you are appearing for 11, there is a conflict for 5 to 9. Because you may claim against them.
Yes.
You have notice hogbeka? Or kodalwa nimge ವಕಾಲತ್ತು?
ಅದು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ ಟ್ರೈ ಮಾಡ್ತಾ ಇದೀವಿ.
Issue notice, hence registry is directed to correct the appearance of Shri B. Ravindra Prasad as that appearing for respond number 5 to 9. Issue notice to respond number 10 and 11, written by 22nd July. Process fee to be paid by 12th June.
71.
I am for the petition, my lord.
Yes.
The land was granted on 4/10/1962, my lord.
Where is Mr. Rajanna? Though counsel for the petitioner is present and ready to address his argument, none appears for respond number 4. If none were to appear for respond number 4 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by counsel for the petitioner. Records in Arubeka?
In ಬೇಕಾಗಿಲ್ಲ, some based on records, the pleadings.
Counsel for the petitioner submit that there would be no requirement to secure the records. Relist on 14th June.
The 14th, but some 15th are in it. 14th.
Saturday, 21st.
ಆಗ್ಬೋದು. Publish.
72, Shanmukappa.
In 72, I appear for the petitioner, my lord.
Yes.
I pray for a week's time, my lord. There is an inconvenience.
None appears for respond number 4. You are there. ಈ ಕಡೆ ಬರ್ಬೇಕು ನೀವು, ಅಲ್ಲಿ ಹಿಂದೆ ಹೋಗಿ ನಿಂತ್ಕೊಂಡ್ರೆ ಅವ್ರಿಂದ ಅವ್ರು ನಿಮಗೆ ಸಪೋರ್ಟ್ ಮಾಡ್ಬೋದೇನೋ, ಬಟ್ ಈ ಕಡೆ ಬರ್ಬೇಕು. ಸಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅವರು. You are ready?
I was surprised for time.
You also, both counsel for the petitioner and respond number 4 seek for a week's time to get ready and address their arguments. Relist on 14th.
74. The Manivandan.
For petitioner, I request for a week of accommodation.
None appears for respond number 3. Counsel for the petitioner seeks for and is granted 2 weeks' time to get ready and address argument. Relist on 21st. If none were to be present for respond number 3 on that date, on the basis of submission of counsel for the petition.
76. Ravi Prakash V.
For the petitioner. 1937,
Y3/1937 is the grant, my lords. And it was sold on in the year 2011, 2013. As on that time, there was no rule period, my lords. That's what's the contention.
You
we
are
have
for the
raised.
purchaser.
We are the purchasers in the year 2011 and 2013.
Yes, Mr. Raghavendra. Though counsel for the petitioner is present and ready to address his argument, none appears to respond. Number 3. Records ಬಂದಿದ್ಯಾ?
ಇನ್ನು ಬಂದಿಲ್ಲ. ಇನ್ನು ಬಂದಿಲ್ಲ.
ಬೇಕಿದೆಯಾ ಫಸ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ
ಬೇಕಿದೆ.
ಬೇಕಿಲ್ಲ ನೋಡಿ.
That AG has submitted that he is yet to secure the records.
May not be required, my lord, sir.
Not be required.
May not be required.
Please, I'll secure the record.
ನಿಮ್ ಪ್ರಕಾರ ರಿಕ್ವೈರ್ಡ್ ಅವ್ರು ಬೇಡ ಅಂತ ಇದ್ದಾರೆ.
ಬೇಡ ಅಂದ್ರೆ
Because they have also, I mean, admitted that it is the 1937 grant is admitted, so far as with respect.
ಬೇಡ ಅಂದ್ರೆ ಬೇಡ, ಆಮೇಲೆ ಬೇಕು ಅಂದ್ರೆ ಮತ್ತೆ ಡಿಲೇ ಆಗತ್ತೆ ಅದಕ್ಕೆ.
ಇಲ್ಲ ಬೇಡ.
Then it, counsel for the petitioner submit that there are no disputes
ಅನ್ನೋದಕ್ಕಷ್ಟೇ.
of any documents requiring the securing of the original records. Hence, production of original records is dispensed with.
ಡಿಸ್ಪೆನ್ಸ್ ಬೇಡ ಅಂದ್ರೆ ಪ್ಲೀಸ್
ಅವ್ರು ಬೇಡ ಅಂದ್ರೆ ಬೇಡ.
ಪ್ಲೀಸ್ ಮೇಡಮ್ ಗ್ರೇಟ್.
ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ?
ಎನಿ
2 weeks.
At the request of counsel for learned AG, none appears for respond number 3. Relist on 21/6. If none were to appear for respond number 3 on that date, matter would be taken up consideration on the basis of submission of the counsel for the petitioner and the learned SCGP.
Interim order may kindly be extended.
Interim order earlier granted is extended.
78. Prakash Reddy.
My lord, I am appearing for respondent number 3 and 4. I pray for 5. Yes, I am the contesting party, my lord.
Yes, you are ready.
I pray for time, my lord. Kindly fix the date, my lord, 26 or 27.
None appears for the petitioner. Learned counsel for respond number 3 and 4 seeks for a short accommodation to get ready and address his arguments. Relist on 21/6. If none were to appear for the petitioner on that date, the petition would be liable to be dismissed for non-prosecution.
Much obliged.
Serial number 80. Puneet C.
So Dasappa. Ready?
Ready.
So counsel for the petitioner is present and ready to address his argument. None appears for respond number 6. Records in Rebecca?
Team bed.
Better.
Amendment is challenged.
Counsel for the petitioner submit that the records are not required to be secured. His submission is placed on record. Idenidu annexure G enidu?
Annexure G is the notification, please, my lord, the recent amendment notification. Wherein I've
You challenge that.
I've challenged that amendment.
Accepting reason stated in support of IA 1 of 23. The production of certified copy of annexure G is dispensed with. Relist on 14th. 14th other matters also there.
Please.
List ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡಿ. ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? ಅದು ಗೊತ್ತಿಲ್ಲ. ಒಂದು ಪೆಟಿಷನ್ ತಾನೇ ಕಾಪಿ ಆಗಿಲ್ಲ ಹಾಗಾಗಿ. ಗೊತ್ತಿಲ್ವಾ? 14th.
Please.
Serial number 81. Raghavanyam.
Petitioner, my lordship. Actually, I am challenging this annexure N, my lordship. Actually, it has been passed by the deputy commissioner, respondent number 1. Actually, this order itself only not maintainable because as on that day, the applicant before the respondent 1, that is the third respondent, he was dead. And that death certificate is also been produced before
Third
the.
respondent was already dead. That is why it's been said that it's not necessary, is it?
Yes, my lordship.
That is why it's been observed that fresh steps are not necessary.
Actually, ಏನಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ your honor, ಯಾರು appear ಆಗ್ತಾ ಇಲ್ಲ.
ಎಲ್ಲದಕ್ಕೂ actually ಅಂದ್ರೆ ಕಷ್ಟ. ಎಲ್ಲ
Yes. I am the grantee, my lordship. My grandfather is a grantee in 1923. But ಏನಾಯ್ತು ಅಂದ್ರೆ 1965 ಅಲ್ಲಿ ಗುಜ್ಜಾರಪ್ಪನಿಗೆ ಒಂದು 50 rupeesಗೆ ಒಂದು ಇದು ಕೊಟ್ಟಿದ್ದೆ ನಾನು. ಏನ್ ಲೋನ್ ಕೊಟ್ಟಿದೆ. ಬಟ್ ಆ ಲೋನ್ ತೀರ್ಸಕ್ಕೆ ನಾನು ಎಷ್ಟೋ ಸಲ ಇದು ಮಾಡಿದೆ, ಅವ್ರಲ್ಲಿ ಏನು ಇದು ಮಾಡಲಿಲ್ಲ. ಅವ್ರ ವೈಫ್ ಏನ್ ಮಾಡೋದಂದ್ರೆ ದೇ ಆರ್ ನಾಟ್ ದ ಶೆಡ್ಯೂಲ್ ಕ್ಯಾಸ್ಟ್ ಪೀಪಲ್. That his wife has sold the property to that Kadiraya. That is a respondent number 3. So only once if it is a SC in between scuttle ಆಗ್ಬಿಡತ್ತೆ, my lord.
R4 has been served unrepresented.
R3, my lord.
R5 is held sufficient. R3 not necessary.
R3 ಡೆಡ್ ಆಗಿದ್ದಾರೆ.
5.
ಅವರ ಮಗ ಬಂದು ಕಾಂತರಾಜು KV8 ಹಾಕೊಂಡು ಬಂದಿದ್ದಾರೆ, but he is not before the
6, there's
DC at all.
Supreet who has entered appearance for R6. None appears for respondent number 6. Though counsel for the petitioner is present and ready to address his argument, none appears for respondent number 6. To provide an opportunity to respondent number 6 to be represented, relist on 14/6, 21/6. If none were to appear for respondent number 6 on that date, the matter would be taken
My
up
lordship, there is a
consideration.
status quo order is there, my lord.
On the basis of submission made by the counsel for the petitioner, the interim order earlier granted is extended till next date.
Much obliged.
ಎಲ್ಲ ಆಕ್ಚುಲಿನೇ ನೀವು ಆಕ್ಚುಲಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರೆ ಅಲ್ಲ ಅದು ಆಕ್ಚುಲ್ ಅಲ್ಲ ಅನ್ಸ್ಬಿಡತ್ತೆ. ಡಬಲ್ ನೆಗೆಟಿವ್ ಆಗೋಗ್ಬಿಡತ್ತೆ.
ಅಲ್ಲ, yes, my lordship.
82. Petitioner.
Last date of hearing, I have taken time.
This time you won't take time.
No, no. Further time I need.
ಇದು ನಿಮ್ದು ಡಿಲೇ ಎಕ್ಸ್ಪ್ಲನೇಷನ್.
Explain ಮಾಡೋದಕ್ಕೆ. I need some more time, my lord. I intimated to my party.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ
Records
ಒಂದು ವಾರದಲ್ಲಿ ಕೊಡ್ತೀರಾ ಅಂದ್ರೆ ಹ್ಞೂ ಅಂದ್ರು.
Records ಕೊಡೋದಕ್ಕೆ ಕೇಳಿದ್ವಿ.
ಯಾವಾಗ ಬರುತ್ತೆ?
2 weeks time.
2 weeks. I make one submission. In the meantime, call for records because it's required for that.
Counsel for the petitioner seeks for 2 weeks' time to comply with the submission dated made on 31/5/2024. Relist on 21/6. In the meanwhile, learned AGA is also directed to secure
Yes, ma'am.
the original records.
Please.
If it is available, it's with me. Those documents are.
ಅಲ್ಲೇ ಗೊತ್ತಾಗೋಗ್ಬಿಡತ್ತೆ. ನಿಮ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ನೋಡ್ತೀವಿ.
Like even opportunity could be granted to, granted to explain delay.
ನೀವು ಅಲ್ಲಿ
Since
ಮಾಡಿಲ್ಲ
as on the
ಅಂದ್ರೆ
date of, even they have not raised the objection regarding the delay, in the statement of objection.
you'll see what you have said. You cannot go by what they have not done.
On that point of time, delay was not a criteria. Therefore, what is sufficient under the act? I was pleaded that. Since he has not also pleaded regarding delay, inordinate delay.
We'll see the
That
file.
was not.
21st.
Forward bench matter.
ಇದಾರೆ. ನಮಸ್ಕಾರ ಬಸವರಾಜ್ ಅವರೇ.
Serial number 1.
In Gurudev, we are in Bangalore
For this matter.
for this matter. ನೀವ್ ಯಾರಿಗೆ? Respond number 2.
Pleading application in this case. I explain.
Who is appearing in this matter?
Lots,
Shivraj
Shivraj
Baloli.
Baloli and Girish Yadwad are opposing.
ಅಲ್ಲಿದ್ದಾರಾ ಬಸವರಾಜ್ ಅವರೇ? ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ. ಗಿರೀಶ್ ಯಾದವಾಡ್.
VC ಬರ್ತಾರಂತ ಮಾರ್ರೆ 4:15
ಓ, ಇನ್ನ 3 ನಿಮಿಷ ಇದೆ.
I'll wait. Till such time, Milords, can I narrate the facts, Milords?
Not in their absence.
Please.
You are proposed respond number 2.
Yes, yes. I shall explain, Milords. There is an allegation of fraud and misrepresentation before.
In a disposed matter.
Disposed matter. Compromise ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Without, Milords, my knowledge, though I am having a decree prior to this order. There is a decree, Milords, in my favor. Please. Please.
Serial number 2.
Very well.
ಇನ್ನೊಂದಿದೆಯಾ?
Santosh Gogi.
Mr. Mane.
This Milords, I appear for Milords, the respondent Milords. But I pray for some time, Milords. Day before yesterday, I have been served with Milords the copy. The entire file is Milords returned to the client. I have contacted him, Milords. I have to get some instructions.
24/4 order ಇದು.
Oh, day before yesterday, Milords, the.
Santosh B. Mane submitted that he
evening.
was served with the copy of the review petition only 2 days ago. He seeks for and is granted 2 weeks' time
Please.
to obtain instruction, make his submission. Released on 21st at 2:30 PM.
Please.
Friday.
Grateful.
Bench split are better.
My apology. I sent there to the Dharwad. I sent the copy to Dharwad, my colleagues.
ಧಾರವಾಡಿಗೆ ಕಳಿಸ್ಬೇಕು ಮನೆ ಅವ್ರಿಗೆ ಬಟ್ ಬೇಗ ಕಳಿಸ್ಬೇಕಾಗಿತ್ತು ಅಷ್ಟೇ. ಆಯ್ತು.
Serial number 1.
Mr. Burley, you are appearing for the appellant.
Please, Manoj. In this minutes, the third party has filed an application.
Yes,
Manoj,
where is
to
Mr.
recall the.
Yadwar?
He's on his legs, Manoj. Now.
He's on his legs.
Here, Manoj, my main objection is, Manoj, on the maintainability of the application filed by a third party. To recall, Manoj, the compromise decree.
Let him start.
Please. Mr. Gachinmat will have to start, Manoj.
We
He's
had
the applicant.
communicated 4:15, so in 1 ನಿಮಿಷ ಇದೆ. After 1 minute. TPC.
May I submit minutes? Is there? A few facts, my lords, may be relevant.
1 ನಿಮಿಷ.
Please.
Yes.
Please, my lords, the appellant and respondents, my lords, have entered into compromise. What makes, my lords, what drives them to this honorable court, my lords, was OS number 33 of 2018, my lords, initially. They contend that, my lords, on 17/8/2016, there was an agreement, my lords, for sale of the property, my lords, between the appellant and the respondents. Then, my lords, since, my lords, there was no, the one of the party, my lords, did not satisfy the terms of the agreement. My lords, the plaintiff, my lords, has filed a suit seeking for specific performance. My lords, and after contest between the appellant and the respondent, on 29/3/2019, my lords, the suit was decreed in part, and there was a direction, my lords, for the defendants, my lords, to refund the earnest money which he has taken. Challenging that order, my lords, the plaintiff, my lords, has approached this honorable court. And, my lords, on 8/7/2019, by filing a regular first appeal number 1000336 of 2019. Then, my lords, on 7/12/2022, my lords, there was a compromise which was entered between these two parties in the said RFA, my lords. But in the said RFA, my lords, if my lords could kindly see, prior to all these aspects of the matter, my lords, even prior to 17/6/2016, where, my lords, there was a alleged agreement between the appellant and the respondent. There is, my lords, agreement between the respondent herein and, my lords, between me on 30th April 2015. Their agreement, my lords, is dated 17/8/2016. Prior to that, my lords, there is an agreement which the respondent has executed in my favor in respect of the very same suit schedule property on 30th April 2015. My lords, that agreement, my lords, was, my lords, for the purpose of selling the suit schedule property in my favor, and the total sale consideration was for a sum of rupees 40 lakhs. And my lords, the amount 11 lakhs, my lords, was paid. 14 lakhs was paid through check, and my lords, and the remaining part of the amount, my lords, was paid by way of cash. And my lords, in between several intervals, the sum of rupees 30 lakhs 25,000, my lords, was paid by me to the respondent herein. Then, my lords, he did not perform his part of the contract. Therefore, my lords, I was constrained to file a suit against the present respondent in OS number 30 of 2019. All these material facts are suppressed, my lords, before the division bench of this honorable court, my lords, before entering into compromise. And, my lords, the suit was decreed in my favor. I had a benefit of the decree. That decree, my lords, was passed on 23/11/2021. And, my lords, there was a direction for the present respondent to execute the sale deed in my favor. Kindly see, my lords, I have produced that decree.
So
along
is the sale deed executed?
Please, my lords.
Execution ಆಯ್ತಾ sale deed?
ಇಲ್ಲ ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗಿಲ್ಲ. ಇನ್ ಬಿಟ್ವೀನ್ ಬಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾನು ಡಿಗ್ರಿ ಇರೋದು
ಯಾವತ್ತಾಗಿದ್ದು?
ಪ್ಲೀಸ್ ಮಿನಿಟ್ಸ್.
When was the
Decree was passed on 23/11/2021 minutes.
You have not filed, compromise was
Compromise was in the year 2022 minutes.
in 22.
ಹೌದು ಹೌದು. Compromise, my lords, was
File
dated.
execution proceeding.
Please.
Before you could file execution proceeding.
Yeah, I have filed the execution petition. I will justify, my lords. Kindly see, my lords, document number 1, that is OS number 30 of 2009, where the decree is passed in my favor. That is, I have filed the application, my lords, for setting aside that compromise, that IA,
Document
page number
one of
37. IA, my lords, IA number 2 of 2023, my lords. First is to implead and then is to dated 14th March 2023, I have filed. With a prayer to set aside the compromise, to recall and set aside the compromise dated 7/12/2022, made in RFA number 1000336 of
3 of 23.
Please, minutes, please. Page 37 minutes.
Yes.
My lord's court. Page
Defendant
37,
was
running page
represented.
37, ink page.
Defendant was ex parte.
Yes, my lords. He was served with the suit summons. He chose not to appear before the court, and the court observed that though the notice has been served upon him.
What do you have to show that he had knowledge about this?
Yes, I have produced documents. I'll justify one by one, my lords. The suit of the plaintiff is hereby decreed with cost. It is further ordered that the defendant is hereby directed to execute the registered sale deed in favor of the plaintiff after receipt of the balance consideration amount within 2 months from the date of the decree. It is further ordered that the plaintiff is entitled for permanent injunction against the defendant, restraining him not to alienate the suit property to anybody except him. So that was the injunction which was in operation as on the date, my lords, when the compromise was entered, and there was a decree in favor of me. Thereafterwards, my lords, my party, that is the impleading applicant before this honorable court, and the respondent herein, my lords, who has suffered a decree, both of them, my lords, go to the office of the sub-registrar and present the sale deed, my lords, for registration.
Both of whom? You.
Myself and, my lords, the impleading applicant and the respondent in RFA, who had entered into an illegal compromise, my lords, which is under challenge.
Who is the respondent? Is the vendor or the purchaser?
He is the owner of the property, my lords.
Vendor.
Yes, my lords. He is a vendor.
That is
Jasood.
Sanjay Tukaram Jasood.
Sanjay Tukaram Jasood, my lords, is a respondent.
You and Jasood went to the sub-registrar.
Went to the sub-registrar office.
Before the compromise.
After the decree was passed. Before the compromise.
Before the compromise.
Yes, so after the decree was passed, kindly see page number 41. This is the affidavit which he has given. Herein, I, Mr. Sanjay Tukaram Jasood, aged about 42 years, occupation so-and-so, today so-and-so. Today, I am presenting sale deed in respect of property described in sale deed, along with the order sheet of the Honorable High Court of Karnataka in RFA number 1000336. This is the RFA, my lords, where the compromise was entered. He produces that order sheet. Though he was placed ex parte, my lords, he knows that there is a decree and he wanted to execute the sale deed in my favor. He goes and executes an affidavit before the sub-registrar, presenting the sale deed before the sub-registrar to register it as per the decree that was passed in my favor. As per the order sheet, injunction is not continued. Hence, affidavit may be believed, and I will indemnify any legal complication arises. Hence, this affidavit. The content of the above affidavit, paras read over so and so, so and so. Then, my lords, the sub-registrar issues an endorsement stating that, my lords, the RFA is pending, so he cannot register it. Kindly see, my lords. ನಿಪ್ಪಾಣಿ ನಗರದಲ್ಲಿ ರೀಸಾ ನಂಬರ್ 72A2 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 11 ಗುಂಟೆ 9 ಆಣೆ ಬಿನ್ ಶೇತ್ಕಿ ಜಮೀನಿನ ಪೈಕಿ 2047 ಚದುರಡಿ ವಿಸ್ತೀರ್ಣದ ಖಾಲಿ ನಿವೇಶನ ನಂಬರ್ ಸೋನ್ಸೋಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಹಿರಿಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರು ಮತ್ತು JMFC ನಿಪ್ಪಾಣಿರವರೊಂದಿಗೆ ಮೂಲ ದಾವೆ 30/2019 ನೀಡಿರುವ ಅಂತಿಮ ಆದೇಶದನ್ವಯ ಸೋಮನಾಥ್ ಶ್ರೀಕಾಂತ್ ಪರಮಾನೆ, ದಟ್ ಇಸ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್, ಸಂಜಯ್ ತುಕಾರಾಮ್ ಜಾಸೂದ್ ಆದ ನಾವುಗಳು ದಿನಾಂಕ 17/1/2020 ಸಂಜಯ್ ತುಕಾರಾಮ್ ಜಾಸೂದ್ ಇಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಿನಿಟ್ಸ್ ಆದ ತಾವುಗಳು ದಿನಾಂಕ 17/1/2022 ಖರೀದಿ ಪತ್ರ ದಸ್ತಾವೇಜನ್ನು ನೋಂದಣಿಗಾಗಿ ಈ ಕಚೇರಿಯಲ್ಲಿ ಹಾಜರುಪಡಿಸಿರುವುದು ಸರಿಯಷ್ಟೇ. ಸೊ ಬೋತ್ ಆಫ್ ದೆಮ್ ಪ್ರೆಸೆಂಟ್ ದ ಸೇಲ್ ಡೀಡ್. ಮೇಲೆ ತಿಳಿಸಿದ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ನ್ಯಾಯಾಲಯ ತಡೆಯಾಜ್ಞೆ ಆದೇಶಗಳ ವಹಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ತಾವು ಖರೀದಿ ಪತ್ರದಡಿ ನೋಂದಾಯಿಸಲು ಉದ್ದೇಶಿಸಿರುವ ಸ್ವತ್ತಿನ ಮೇಲೆ ಮಾನ್ಯ ಹಿರಿಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರು ಮತ್ತು JMFC ನಿಪ್ಪಾಣಿಯವರು ಮೂಲ ದಾವೆ ಸಂಖ್ಯೆ 33/2018 ಹೊರಡಿಸಿರುವ ಅಂತಿಮ ಆದೇಶದ ವಿರುದ್ಧ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಧಾರವಾಡ ಪೀಠದಲ್ಲಿ RFA ನಂಬರ್ 100336 of 2019 in which they entered the compromise. ಪ್ರಕರಣ ದಾಖಲಿದ್ದು ಗಣ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 26/11/2019 ಮತ್ತು 7/12/2019 ಮಧ್ಯಂತರ ಆದೇಶಗಳಲ್ಲಿ ಪ್ರಶ್ನಿತ ಸ್ವತ್ತನ್ನು ಪರಭಾರೆ ಮಾಡದಂತೆ ತಡೆಯಾಜ್ಞೆ ನೀಡಿರುವುದು ಈ ಕಚೇರಿ ಗಮನಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. But as on that date, my lords, the interim order was not continued. Therefore, the Sanjay Jasud gives an affidavit that interim order is not continued and there is no impediment for him to go ahead. ಕಾರಣ ಖರೀದಿ ಪತ್ರದಡಿ
If that had got registered on 11/1/2022,
This
this
problem wouldn't
compromise
have
would
arisen.
not have happened. Yes.
ಕಾರಣ ಖರೀದಿ ಪತ್ರದಡಿ ತಾವು ಪರಭಾರೆ ಮಾಡಲು ಬಯಸಿರುವ ಸ್ವತ್ತು ನ್ಯಾಯಾಲಯದ ಪ್ರಶ್ನಿತವಾಗಿದ್ದು ಅಲ್ಲದೆ ಈ ಕುರಿತು ಗಣನ್ಯಾಯಾಲಯ ತಡೆಯಾಜ್ಞೆ ಇರುವುದರಿಂದ ಸದರಿ ಸ್ವತ್ತನ್ನು ನೋಂದಾಯಿಸಲು ನಿಯಮಾವಳಿ ಅವಕಾಶ ಇರುವುದನ್ನು ತಿಳಿಪಡಿಸಲಾಗಿದೆ. He gives an endorsement. Then, my lords, the respondent assures me that he is going to get the RFA disposed, and my lords, he would come and execute the sale deed in my favor. He knows about this suit, my lords, which has been decreed against him. Then afterwards, my lords, what he does, my lords, instead of executing the sale deed in my favor, he goes and files an application, my lords, for rescinding the agreement of sale before the very same court which has got the decree. That order, my lords would find at page number 45, my lords. He goes before the very same court, and my lords, he says that this agreement has to be rescinded. My lords may kindly see, my lords, case advanced in the disposed OS, where the decree is in my favor. That is OS number 30 of 2019, where he has suffered a decree. He goes before the court. That is, MVK advocate filed wakalat on behalf of the defendant, files application, my lords, got it, my lords? Page 45, my lords.
Yes, we got.
Yes, please. Application under section 151 read with section 21 of the Specific Relief Act, seeking prayer that rescind the agreement of sale dated 34/2015. This is the agreement in my favor where the suit is decreed, which is subject matter in the present suit. The matter is already disposed of on 23/11/2021. It is a lookout of the parties to enforce or execute the order of this court. As is, there is no necessity to issue notice of this application to plaintiff as because the matter is already disposed of. So the trial court refuses, my lords, to rescind the agreement as per his prayer. Challenging this order, my lords, he files a writ petition before the Dharwad High Court, and that is still pending. That is writ petition number 104072 of 2022. And that writ petition, my lords, he does not obtain any interim order. It is still pending before the High Court, and it is, my lords, pending consideration. Now, my lords, suppressing all these material facts, my lords, the respondent and the appellant enter into a compromise in that RFA, my lords, as though bringing it to the note, posing it before this honorable court, as though, my lords, it's a pure contractual obligation between the appellant and the respondent, and therefore they want to enter into a compromise by taking certain balance consideration amount. Apart from that, my lords, if my lords could kindly see, there is one more development agreement which this Sanjay Jasud executes in my favor, and also executes the general power of attorney in my favor in respect of the very same suit schedule property. That development agreement, my lords, I have produced at page number 46, and the general power of attorney, my lords, irrevocable general power of attorney, which he has executed in my favor, I have produced it as document number 7, my lords, both documents. So all these material facts, my lords, all these things have happened prior to entering into the compromise petition between the appellant and the respondent. Now, my lords, respondent knowing fully well that he has suffered a decree, respondent having come to the sub-registrar's office to execute the sale deed in my favor, respondent having filed an application seeking to rescind the agreement of sale, respondent having filed a writ petition before the Honorable High Court challenging the order, my lords, where the rescinding was refused, my lords, comes before the this Honorable Court and enters into a compromise. Now, the question is, my lords, whether the appellant knew about these proceedings. I have produced certain documents, my lords, in order to know that appellant also knew about these proceedings. So both the appellant and respondent having known about all this.
Produced for the
Please,
appellant.
please. Kindly see, my lords, application under order 41 rule 27 I have produced. My lords. On 29 February 2024, because after filing of this petition, my lords, they took up the defense by saying that my lords, appellant was ignorant about all these proceedings, so he should be excluded and kept away from these proceedings. That made me, my lords, to further probe into the matter and, my lords, in order to ascertain as to whether, my lords, the appellant was also knowing about these proceedings. Even he knows about these proceedings, my lords. If my lords could kindly see application under order 41 rule 27, filed on 29th February 2024, my lords. Since they took up that defense, my lords, that made me to file this application.
Yes.
Kindly see, my lords, the first document, the advocate, my lords, for the appellant, prior to this, my lords, issues a paper publication stating that he wants to deal with this property.
What is this legal notice to who are 1 and 2 there?
Yes, my lords, I'll justify, my lords. Page number 9 is the first paper publication, which has been issued by the appellants, my lords, notifying the public at large that they want to deal with this property, with this very property where the decree was in my favor.
So their power of attorney knew about it is what you are saying.
Yes, my lords, they knew about this, this thing, this issue, my lords. So they issue a public notice. And for that public notice, my lords, through my advocate, I reply to them stating that, my lords, there is already a decree in my favor. Please don't deal with this property. That is, my lords, that legal notice I have produced at page number 11.
But that is being returned with the endorsement refused.
That is, he refuses it. As an abundant precaution, my lords, I issue a legal notice, my lords, to the advocate who has issued the paper publication. That is at document number 5, my lords, page 16. Then, my lords, I have issued the notice to his advocate also. Then, my lords, may kindly see, I have taken out certain wakalat. The advocate for the appellant and the advocate for respondent are one and the same. That is, one Mr. M.M. Kulkarni, my lords, appears for the appellant as well as for the respondent. The wakalats I have produced at page number 19, 20, and 21.
This is after the compromise or before the compromise?
Before the compromise, my lords. All these documents, my lords, are prior to compromise. These are, my lords, suppression of material facts, my lords. There is fraud played upon this honorable court. Page number 19, 20, and 21, my lords, are the documents which says, my lords, kindly see page number 19, Sanjay Jasud. His advocate is one Mr. M.M. Kulkarni and M.V. Kulkarni. Page number 20, Sanjay Jasud, my lords, and Haji Salim Syed Nagarji, that is the appellant herein. Even his advocate is also Mr. M.M. Kulkarni. Then, my lords, Salim Syed Nagarji, that is the appellant. His advocate is again M.M. Kulkarni and he has been appearing. And I have issued notice
Mr.
to...
Yadwad. Yeah, what do you say for your client Jasud? Yadwad.
So far as the decree that is passed in OS number 30 of 2019, that is an expired decree, I was not aware of that proceedings.
You were aware, you went before the sub-registrar, you gave an affidavit for registration.
Please.
Saying that there is no order in this in this RFA.
Am I audible, Manoj?
Yes, you are audible. You gave an affidavit to the sub-registrar that there is no injunction order.
That affidavit for it is denied. I have filed objections. I have filed objections. That affidavit of objection specifically, that he had taken signatures of the respondent on some blank sheets. That does not show my presence. It is submitted before the sub-registrar, which is now being alleged, and that document has seen the light of the day now. I was not aware of that decree, my lord, earlier passed. And even after, my lord, a conditional order having been passed, my lord, he never took any steps, my lord, to execute that decree. He completely abandons, my lord, one day, and after this compromise is, my lord, entered into, he comes and files his application.
After the decree, you filed an application for resciling of the agreement on
That is much later.
6/9/21.
21,
Before the
yes,
compromise.
Yes.
Your counsel M.V. Kulkarni filed the application for resciling the agreement dated 34/2015 in that suit.
Yes, sir.
Before
Was
the
30.
compromise was entered into before us. How can you say you are not aware of it? We'll
No,
come to
not
you
at that
later,
stage,
Mr.
when the
Varali.
affidavit
First,
was
let
filed, that is what I'm trying
us
to
ask the
say.
vendor, then we'll come to you. If your client thinks that he can abuse the process of the court,
This is
it's mistaken.
later on. I'm saying when the
On 6/9/21, you went before
no,
the
certainly
trial
not
court.
for us, that is not the after coming to know of this decree, my lord, this application came to be filed.
No, when was the recordal of the
6/9/21,
decree?
yes, my lord.
When was the compromise?
Compromise, my lord, 7/12/2022, my lord.
7/12/22. You filed this application on 6/9/21.
21.
Or even if it is taken as 6/9/22, one jagada 22 ಅಂತ
ಇಲ್ಲ,
ಇದ್ದಂಗಿದೆ.
2021, my lords.
One ಜಾಗದಲ್ಲಿ 21 ಇದ್ದಂಗಿದೆ, ಇನ್ನೊಂದು ಜಾಗದಲ್ಲಿ
ಇಲ್ಲ,
22
submissions
ಇದ್ದಂಗಿದೆ.
6/9/2021.
That was
On the top, left-hand side, may not
7/12/2022.
stop.
Let us take it as 6/9/22.
Yes,
Even then, it is prior to the compromise being entered into,
before the trial court.
before the trial court. In that suit, you go and file. How can you say you are not aware of the decree? Stay Edward, uncomfortable ಆಗೋಯ್ತು. So what? We'll post
So
it.
that
on
is
the-
after I came to know, my lords.
Huh?
There was
After you
a
came to-
conditional decree passed, my lord, he did not deposit the amount.
So you were
Then
aware
immediately
of.
after coming to know that he did not deposit, my lord, then I filed an application.
We can't hear you very well, Mr. Yadwad. Your voice is garbled.
There is some problem with the relay, my lords. There is
We'll have it,
delay in, my lord.
IA number 1 of 23 has been filed for impleading.
Relay, there is little delay in, my lord, the relay of the proceedings, my lord. I am able to, my lord.
By ನಿಮ್ಮ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರೇ ಬರ್ದಿಲ್ಲ. By one Mr. Somnath
Lords, I have filed the impleading application.
Srikanth Paramane.
Permanent. Impleading application, it contains the full name.
In IA 1 of 2023 to come on record contending that he is a decree holder in a suit in OS number 30 of 2019, which was filed for specific performance agreement dated 34/2015, which is prior to the agreement of sale entered into with the appellants herein on 17/8/2016. Submission of Shri Gurudev Adjournment, learned counsel for the applicant is that the appellant and the respondents have suppressed material facts inasmuch as the decree in the suit in OS number 30 of 2019 was not brought to the notice of this court. The said decree having been passed on
23/11/2021.
If the same had been brought to the notice of this court would not have permitted the compromise to be recorded. His submission is also that in pursuance of the said compromise, the impleading applicants and the respondent had approached the jurisdiction sub-registrar for registration of a sale deed in terms of decree in OS number 30 of 2019, which came to be refused by the sub-registrar on the ground that the injunction orders passed in RFA number 100336 of 2019. An affidavit having been filed by respondent number 2 would evidence that he is aware of the decree passed in OS number 30 of 2019.
Respondent, sole respondent.
And the same was to be implemented. His further submission is that after the sub-registrar refused the registration of the sale deed, respondent approached the court earlier seized of OS number 30 of 2019 with an application under section 151 read with 21 of the specific relief act for resigning the agreement of sale dated 30/4/2015, which also came to be dismissed. And it is only thereafter that the present compromise petition was filed. In view of the above, it would be for the respondents, for the appellant and respondents to make their submission on the said facts, since if the submission of the impleading applicant were to be accepted, then serious action would have to be taken against the appellants and the respondents for abuse of the process of court, bordering on obstruction with justice amounting to criminal contempt of court. ಇವಾಗ ಸರಿ ಹೋಯ್ತಾ ನಿಮ್ದು ಅಲ್ಲಿ?
Please, we are, we can hear your lordship.
Now we can hear you also. Yes, Mr. Yadwat, what is your submission?
Yes, sir.
So far as the affidavit code which is relied upon by the impleading applicant.
ಜಾಸ್ತಿ ಮಾಡಕ್ಕಾಗತ್ತಾ? ಸೌಂಡ್ ಜಾಸ್ತಿ ಮಾಡಕ್ಕೆ. ಸೌಂಡ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಅಷ್ಟೇನಾ? We'll have it on another day, Mr. Adwat. There's a lot of rain sound and we can't hear you.
Yes, here also it is raining, my lord. Perhaps that may be the reason, my lord.
Released on 14th, next Friday.
For 18th.
No, we'll have to have it on Friday because Mr. Basraj will not be.
18th.
Just Basraj is sitting on a division bench there.
Single. Today only single. Today single.
Huh?
ಇವತ್ತು ಮಾತ್ರ ಸಿಂಗಲ್ ಮೇಲೆ
ಇವತ್ತು ಸಿಂಗಲ್ ಫ್ರೈಡೇ
ಡಿವಿಷನ್ ಬೆಂಚ್ ಮೇಲೆ
ಫ್ರೈಡೇನೋ ಡಿಬಿನೇನಾ
ಎಲ್ಲ ಒಟ್ಟು ಅವ್ರೇನ ಸಾಹೇಬ್ರು ಬಿಟ್ಟು ಮಾತ್ರ
18th ಹಾಕೊಳ್ಳೋಣ ಸ್ವಲ್ಪ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಇದೊಂದು ಸ್ವಲ್ಪ ಮುಗಿಸೋಣ 18th at 2:30 PM ಇಲ್ಲ 18th at 4:30 ಹಾಕೊಂಡ್ಬಿಡೋಣ
4:30 ಆದ್ರೆ ಮಾಡ್ಬೋದು
4:30 ಹಾಕೊಳ್ಳೋಣ ಆಫ್ಟರ್ ದಟ್
ಪ್ಲೀಸ್
18th at 4:30
grateful
ಮಂಡೇನೇ ಬೇಕಾ ನಿಮ್ಗೆ
Lordship, a humble submission, Lordship. Serial number 81, I'm for respondent number 6. It was called out as held up in another court. It may kindly be posted on 24th of June.
81?
Serial number 81. I'm for respondent number 6.
None appears for respondent number 6 badlu. We observed is not there. We'll delete that.
24th, it may be. posted.
Interim order to.
Yes, yes, all on Friday only.
21st.
Interim order may kindly.
24th, it may kindly.
You can't ask for a date. We take it only on Friday, it will be on 21st. Please ask him to be present.
Interim order may kindly be.
ಹೋಗಿ.
Interim order may kindly be.
ಇದೆಯಾ interim?
ಇದೆ.
Interim order earlier granted is extended.
ಸರಿ. ಸರಿ ಬಿಡು. ಹೇಳಿದ್ರ ಅದು ಮತ್ತೆ ಹೇಳಿ.
ನಮಸ್ಕಾರ ಬಸವರಾಜ್ ಅವರೇ.
ಮೈಲಾಡ್ ನಮಸ್ತೆ.
ಬಸವರಾಜ್, yes. ರೂಪ ಅಂತಿದ್ರಲ್ಲ ಅವ್ರ husband. Encumbrance dated.
ಮೇಡಮ್ ನೀವೆಲ್ಲ ಸೆಕ್ಷನ್ ಗೋಸ್ಕರ ಯಾವ ನಿಮ್ಮ ಟೇಬಲ್ ಯಾವ
ಸರ್ ನಾನು ಸೆಕ್ಷನ್ ಕಳಿಸ್ಬಿಟ್ಟೆ ಆಗ್ಲೇ ನಿಮ್ದು ನಂದು
ನೀವೆಲ್ಲ ಟೇಬಲ್
ಅಂದ್ರೆ ಬರೀ ಫ್ರೈಡೆ ಮಾತ್ರನೇ ತಂದಿದ್ದು. ನಾನು ಹೇಳಿದ್ದು PTCL ಎಲ್ಲ
ಬಂದಿದೆ ಅಂತ ಹೇಳಿದಾರಲ್ವಾ, ಎಲ್ಲ ಬರೀ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ. ಇದನ್ನೆಲ್ಲ ಮತ್ತೆ ವಾಪಸ್ ರೆಕಾರ್ಡ್ಸ್ ಕಳಿಸಿ ಅಂತ ಹೇಳ್ಬೇಕು. ನೋಡಿ ಸರ್ವೆ ನಂಬರ್, ವಿಲೇಜು ಎಲ್ಲ ಹೇಳ್ಬೇಕು. ಎಷ್ಟು ಟೈಮ್ ಹಿಡಿತಲ್ಲ ಸರ್?
2 ದಿವಸ ಬೇಕು ಮೇಡಮ್.
2 ದಿವಸ ಬೇಕು. ಆಮೇಲೆ ಅವ್ರು ತಂದಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದ್ಸಲ ಮತ್ತೆ ರೀ ಫಾಲೋ ಹೋಗ್ಬೇಕು.
ನಾಳೆ ಬರ್ತೀರಾ?
ನಾಳೆ ಬರಲ್ಲ, ಮಂಡೇನ ನಾನಿಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ಹೇಳೋದು ನಮಗ್ ಬೇರೆ ದಿವಸ ಬೇಡ. ಏನಂತೀರಾ ಸರ್?
ಆಯ್ತು, ಇವತ್ತು ಈಗಿರಲ್ಲ,
ಈಗಿರಲ್ಲ, ಇನ್ನೊಂದ್ ದಿವಸ ಬಂದು ಹೇಳೋಣ.
ಸಂಡೇ ಮಾರ್ನಿಂಗ್ ಬನ್ನಿ, ಸ್ವಲ್ಪ ಬೇಗ ಬನ್ನಿ.
ಬೇಗ
ಅಂದ್ರೆ ಅವ್ರು ಇರ್ತಾರೆ ಅವಾಗ ಹೇಳೋದು. 10:30 ಬಂದ ತಕ್ಷಣ ಕೋರ್ಟಲ್ಲಿ ಓಡ್ಬಿಡ್ತಾವ.
ಮಂಡೇ ಯಾಕೆ ಹೇಳ್ಬಾರ್ದು ಅಂತಂದ್ರೆ ಅವ್ರು ಹೆಕ್ಟಿಕ್ ಬಿಸಿ ಇರ್ತಾರೆ. ಇವಾಗ್ಲಾದ್ರೆ ಸ್ವಲ್ಪ ನಾಳೆ ನೋಡೋಣ, ಬರೋದಾದ್ರೆ ಬಂದು ಮಾತಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಡೋಣ.
ನಾಳೆ ಬರ್ತೀರಾ?
ನೋಡೋಣ, ಅವ್ರು ಇದಾರೆ
ಬಂದ್ರೆ 10:30
ಕಾಲ್ ಮಾಡ್ತೀನಿ. ಅವ್ರು ಇದಾರೆ ಅಂದ್ರೆ ತಿಳ್ಕೊಂಡು ನಾನು ನಿಮ್ಗೆ ಕಾಲ್
ಕಾಲ್
ಮಾಡ್ತೀನಿ.
ಮಾಡಿ.
ಹಂಗೆ ಮಂಡೆ ಕಿರ್ಚು ಬಿಡ್ತಾರ ಒಂದೊಂದ್ಸಲ. ಈ ಮ್ಯಾನೇಜ್ ಇರ್ತಾರೆ, ಆಮೇಲೆ ಅದನ್ನು ಕಷ್ಟ. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಡೇಟೆಡ್
ಇವೆಲ್ಲ
ನಿಮ್ ಫೈಲಲ್ಲಿ ಇಟ್ಬೇಕು.
ಅಲ್ಲ ಇವ್ರೆ
ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್
ಈ ಸೆಕ್ಷನ್ಗೆ
ಇದಿರು ಬರಿಬೇಕು ಮೇಡಮ್.
ಈ ಸೆಕ್ಷನ್ ಕಳಿಸ್ಬೇಕು. ಇವ ಸೆಕ್ಷನ್
ಸರ್ ಸೆಕ್ಷನ್ ಯಾವ ಹೇಳ್ಬೇಕು?
ಎಲ್ಲ ಇವೆರಡು ಸೆಕ್ಷನ್.
ನಿಮ್ ಟೇಬಲ್ ಸಪರೇಟ್ ಇದೆ.
ಸೆಕ್ಷನ್ ಇದೆಲ್ಲ ಚೇಂಬರ್ ಇಲ್ಲಿ ಇಷ್ಟೇ ನಾವು ಹೋಯ್ತೀನಪ್ಪ ಹಿಂದ್ಗಡೆ ಮತ್ತೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡಿ
ಹಲೋ ಸರ್, ಅದಕ್ಕೆ
ಮೇಡಮ್ ಅದೊಂದು 482 ರೌಂಡ್ ಮಾಡ್ಬಿಟ್ಟಿದೀನಿ.
ರೌಂಡ್ ಮಾಡಿ 482 ಮೇಡಮ್ ಚೆಕ್. ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಬೀರುವಲ್ಲಿ ಇಡ್ಬೇಕು. ನೋಡಿ ಮೇಡಮ್, ಹಿಂಗೆ ಪ್ರತಿಯೊಂದು ಹಿಂಗ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿರುತ್ತೆ. ನಾವ್ ಅದ್ರ ಒಳಗಡೆ ಓಪನ್ ಮಾಡಿ ನೋಡಿದಾಗ ಅಷ್ಟೇ ನಮ್ಗೆ ಒರಿಜಿನಲ್ ಇದೆಯಾ ಇಲ್ವಾ, ಯಾವ್ದ್ರಲ್ಲೂ ಒರಿಜಿನಲ್ ಇಲ್ಲ. ಆಮೇಲೆ ಫೈಲ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ನಮ್ಮವರು ನಮ್ಮ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ LCR ರಿಸೀವ್ಡ್ ಅಂತ. ನಾವೇನ್ ಅನ್ಕೊಳ್ತೀವಿ, ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತೀವಿ ಸಾಹೇಬ್ರಿಗೆ, ಅಲ್ಲಿ ಇಲ್ಲ. ಸೊ ಈಗ ಎಲ್ರಿಗೂ ನಾವು ಫೋನ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು.
ಫಸ್ಟ್ 1-2 ವಾರ ಸುಮ್ಮನೆ ಆಗ್ತಾರೆ,
ಆಮೇಲೆ ಕ್ಲಾಸ್ ತಗೊಳ್ತೀವಿ. ಅನೆಕ್ಷರ್ A dated, ಅನೆಕ್ಷರ್ A